And sir, volume on ಆಗಿಲ್ಲ. Court officer, volume is off.
ಬರ್ತಿದ್ದಾರೆ ಈ ಕೇಸ್ ತಗೊಂಡಪ್ಪ ನಾಳೆ ಕಷ್ಟ ಆಗುತ್ತೆ ಗುರುವಾರ ನಾಡಿದ್ದು ಸರಿ ಅನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಆರ್ಡರ್ ಶನಿವಾರ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಾ ಶನಿವಾರ ಸಿಟ್ಟಿಂಗ್
ಸರ್ ಡೇಟ್ ಹೋಗುತ್ತೆ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೊಂಡು ಇವಾಗ ತಗೋಬೇಕು ನೀವು ಅಷ್ಟೇ ಡೇಟ್ ಈಗ ಆಲ್ರೆಡಿ ಲಿಸ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ ನಿಮಗೆ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳ್ಬೇಕಾ ಸೀರಿಯಲ್ ನಂಬರ್ಸ್ ಇದ್ರೆ 2:30 ತಗೋತಾರೆ serial number ನಾಳೆಗೆ such matters will be sorted out and it will be heard afternoon ಅಲ್ಲಿ ಏನು ಜುಲೈ ಹೋಗುತ್ತೆ ಎಲ್ಲ ಬೋರ್ಡ್ ಫಿಲ್ ಆಗಿಬಿಟ್ಟಿದೆ ಅಪ್ ಟು ಜುಲೈ 15th ಜುಲೈ 15th ಆದ್ಮೇಲೆ ಬರುತ್ತೆ we will assign the dates after 15th onwards ಡೇಟ್ ಕೊಡ್ತೀವಿ ಏನೋ ಅದಾ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಆಗ್ತಾ
next week the CRP hearing not for move ಮಾಡಿ ಗೋಲೆ ಕೊಡ್ಬೇಡಿ ಇಷ್ಟ ವಿಷಯ ಇದು ಬರೀ ಡಿಸ್ಕ್ರಿಪ್ಟಿವ್ ಪ್ಲಾನ್ ಅಂತ ನಮ್ಮಲ್ಲಿ ಫೈಲ್ ನಮ್ಮ ಪ್ರೊಸೆಸರ್ ಇಲ್ಲ ನಾವು ಇಲ್ಲ
ರಾಸಿಮಾ ಇಲ್ಲ ಇಲ್ಲ
ಯಾವ ಡೇಟ್ ಕೇಳಿದ್ದೀರಾ ಅದಕ್ಕೆ
ಏನೋ ಅದೇ ಬೇರೆ ಏನಾಗಿದೆ ಚೈಲ್ಡ್ ಪ್ರೊಹಿಬಿಷನ್ ಚೈಲ್ಡ್ ಅಂಡ್ ಅಡೋಲೆಸೆನ್ಸ್ ಲೇಬರ್ ಪ್ರೊಹಿಬಿಷನ್ ಇದೆ ಇಲ್ಲ ಇಲ್ಲ ಅಲ್ಲಿ ನೋಡು ಅಲ್ಲೊಂದು ಸ್ವಲ್ಪ ಬುಕ್ಸ್ ಎತ್ತಿಕ್ಬಿಟ್ಟಿದ್ದೆ ಅವತ್ತು ಮಹೇಶ್ ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ ಬರ್ತಾ ಇದ್ದೀರಾ ಮೇಡಮ್
23 ಇಂದ 23 ಬರಲ್ಲ 24 onwards ಟಿಪಿಸಿ ಅಲ್ವಾ ಅದು ಫೈನಲ್ ಡೇಟ್ ಇಂದ ಬರೋದಿಲ್ಲ ಬರೀ ನಮ್ಮ ಕಳಿಸೋದು ಮೇಲ್ ಕೊಟ್ಬಿಟ್ರ ನೀವು ಯಾವಾಗ ಅಸೈನ್ ಮಾಡಿದ್ರಿ ಮೇಲ್ ಸಬ್ಜೆಕ್ಟ್
ಮೇಲ್ ಪಕ್ಕದ ಕೊಟ್ರು ಸರ್
ಪೆಂಡಿಂಗ್ ಸರ್ ಇದು
ಪೆಂಡಿಂಗ್
ಕರೆಕ್ಟಾಗಿ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಸರ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ರೀಚ್ ಆಗುತ್ತೆ ಅದು 44 ಲಿಸ್ಟ್ 1 ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ 2 ಸರ್ ಎನಿ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ಅಂತಂದ್ರೆ 10:30ಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೋಬೇಕು ಸಚ್ ಸೀರಿಯಲ್ ನಂಬರ್ಸ್ ವಿಲ್ ಬಿ ಸಾರ್ಟೆಡ್ ಔಟ್ ಅಂಡ್ ವಿಲ್ ಬಿ ಹಿಯರ್ಡ್ ಇನ್ ದ ಆಫ್ಟರ್ನೂನ್ ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅನ್ರೀಚ್ಡ್ ರೀಚ್ ಆಗಲ್ಲ ನಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಪ್ಲೀಡ್ ಮಾಡಿ ಮೂವ್ ಮಾಡ್ಕೋಬೇಕು
ಕೋರ್ಟು ಲೈವ್ ಬರ್ತದೆ.
Lords, one submission. Trial court has granted an ex parte temporary injunction on an interstate transmission line. It comes under public infrastructure. It can be taken up tomorrow.
What is the order?
My lord, the order is dated 14 January. Subsequently, I have entered appearance. The arguments have been concluded on 23rd March. Still the orders are not passed, and the dates are simply adjourned for posting for orders.
Tomorrow. Yes.
Please.
This is the yesterday's matter, my lord, which got
give it to the
please.
Tomorrow.
Great.
Excise matter.
Huh?
Pending excise matter. The Lordships were pleased to give date during first week of July, but my renewal is before this June 30th. So I have made an application for renewal.
29.
29.
Huh? When was it filed? So March it has not come up. Next week. Is this matter on 2nd of July? Yes. 29th. 29th. Huh? When was the warrant issued? Huh. Yeah, when you have filed the writ petition, why it is not coming? She was not there that time. You were not there when the date is assigned? Then no, you have to say what is urgency. You keep quiet. Thirtieth, listed on 29th. No, when is it listed? 30th? Oh, that much you can say. You can't choose the date. List it on 29th. Yes. Huh? Which was it?
So I am requesting, my lord, it may be taken on 25/6, my lord. Please, my lord.
Strange submissions. You have a case in Mandya, so matter should be taken up.
No, that is not the different case. This. Kindly, there is.
Sometimes I don't understand what to respond also.
25/6.
List it on 25th.
My lord, suit for specific performance filed by the plaintiff, my lords. Interim order ex parte is granted by the trial court, my lords. Only on one thing, my lords, not to alienate. It did not grant on not to put up any construction. Later, my lords, they have approached this honorable high court, my lords, and obtained a stay, my lords. Therefore, my lords, I have filed vacating application, my lords, may be posted in the.
Kind of vacate applications are about at least 1,000, 2,000. So every
My lords,
vacate
yes,
application I
my
cannot
lords,
take.
respond.
Interject, I appear for him in this matter. I'm sorry to trouble your lordships. I can see your lordships is not well also. You know, the only thing is this matter can be disposed of. Let them go back to trial court and work out the remedy, because only against an ex parte order. Let the stay order continue. Let the trial court.
Why I am not entertaining these vacate petitions is,
The
unfortunately,
board will be flooded.
No, every matter there is a stay. So every vacate petition, if it has urgency, then I have to list
So
all
in fact,
1,000
in fact, I
matters.
told him also this matter can be disposed of, continuing your lordship stay order, because anyway we have already filed our objections before the trial court. Till the objections are considered.
Is that matter tomorrow?
Grateful.
My lords, this is regarding matter of WP, my lords.
Matter?
WP, writ petition, my lords. My lords, in this matter, so what has happened is where the petitioner and the respondent 1 and 2, 3, I am the respondent number 4, my lords. In this, where the three parties are not letting to take the position of respondent number 3, my lords. Kindly hear this, my lords.
And this is a writ petition filed.
My lords, it's basically two cases, my lords, two matters, my lords. It's of one is on 2022, my lords. Another is before this court, 25, my lords.
We will see. Yes. Don't take that. We'll see. Yes.
That's in list 2, serial number 34.
We'll call the list. Yes.
List wise, page wise adjournment, list 1, page number 2, serial number 6 to 13, page 3, 14 to 24, page 4, 25 to 32, page 5.
Serial number 25, your lordship. I pray for 2 weeks adjournment, Your Lordship.
Yes, this matter, the request in the month of September. Yes.
Much obliged, Your Lordship.
Page number 5, serial number 36 to 37. Page number 6, 38 to 44. Page 7, 45, 46. Page 8. Page number 11, serial number 47. Page number 12, 48 to 54. Page number 13, 55 to 59. Page number 14, 60 to 62. Page number 15, 63 to 66. Page number 16, 67 to 70. Page number 17, 71 to 74. Page
My Lordship,
number
serial
18.
number 71. I am appearing party in person, My Lordship. Matter may kindly be taken at 2:30, My Lordship. The urgency is that the witness cross-examination has to be conducted and they are aged around 80 years. They are hospitalized. So I request My Lordship to please take it at 2:30.
When is the matter coming up before the trial court?
Trial court, it is at 28, My Lordship. Next month, My Lordship.
Then you can.
For the last eight hearings, it has not came to the board.
Even if your order is passed, the matter will come on that day only. So be in the month of July, before your hearing, 10 days before you can mention. No urgency, no. Yes.
Page number
List
18.
this matter 71.
My Lordship,
on,
I will wait for it.
On 15th of July.
My Lordship, I will wait for it. Whether it comes today it is scheduled. I will wait for it.
Good that you realized it. Yes.
Page number 18, serial number 75 to 80. Page
Serial number 78, my lords. Matter is listed before the trial court today, my lords, for the stage of defendant's argument. I filed my recall and reopen application for plaintiff cross that has been rejected. The same has been challenged in this petition. There is a direction in the matter by the court.
But if it doesn't reach this matter, then at 4:30.
Yeah, at 2:30, my lords. Matter is listed today.
You can tell the court that the matter is being heard at 4:30. Yes.
Page number 19, 81 to
Because
80.
I don't take up 2:30 matters at 2:30. Yes.
Page number 19, 81 to 84.
81, serial number 81.
Huh.
Today, because I'm for the respondent, I have some personal inconvenience. In that on Monday.
Interim order is there.
No,
This is
Petitioner, I informed
matter,
the
this is matter in the month of August.
My lord, some urgency, my lord. We are for the petitioner. My FDP is stayed, my lord. The petition
Please
is.
stay is not there.
No, not in this matter, my lord. In civil court, my FDP is stayed. Hence, I have filed this writ petition, my lord, challenging that order.
All of you have to understand, if I adjourn the matter is.
One date may be fixed. That's
date may be.
List the matter on 4th of August. Yes.
Page number 20, serial number 85 to 87. List number 2.
My lords, serial number 87, I appear for the petitioner, my lord. I pray for short accommodation to amend the cause title, my lord.
This order was passed when?
87.
8/7/2024. And you see time now. We'll allow it on cause. I'll adjourn it on cause.
Oblige, my lords.
Wait, it's okay to impose cause?
My lords, actually my senior is out of station. He's in Supreme Court.
Said okay. Let this matter on 22nd of July. By the time, if the cause title is not amended, without further reference to the court, the CRP stands dismissed. Yes.
Grateful, my lords.
Look at it, if interim order is extended. Yes.
Page number 2, list number 2, page 1, serial number 1, page 2, 2 to 5, page 3, 6 to 9, page 4.
My lordship, I am on BC, serial number 8, my lordship, party in person. I'm appearing through VC from Australia, my lordship. I wanted 5 minutes submission to make my submission. About 20 years of fraud on court is happening, my lordship. 12 honorable judges. So I just want 5 minutes time for submission, my lordship.
Call the list.
My lord, serial number 7, list number 1.
Serial number 7.
Yeah. This matter is posted on month of July. This is a connected matter. So kindly today adjourn, madam. List number 1, serial number 7.
Taken up along with July matter.
Yeah, ma'am.
Take that.
Total 8 matters, ma'am.
List along with so and so. Yes. Look at it if interim order is there. Yes.
Page number 4, 10 to 13, page number 5, 14 to 19.
Serial number 19, my lord, may be taken up on any other date. In respect of the documents That's a
Anyhow, it won't reach today. It won't reach today. Yes, next.
serial number 18 you are 18 and 18.1 you are. That was already office eviction is completed in 18.1. But both matter will be posted and date will be fixed. Your Honor. Matter will be urgent. That is the reason. Today is not reachable. That is the reason.
18.1 non-compliance of office objections.
Office eviction already completed. Your Honor.
Then why it is coming like that?
But I don't know what is the reason they have mentioned. It's already completed in long.
Look at this file. If office objections are complied with, list this matter day after tomorrow in the first list.
Much of it.
Page number 6, serial number 20 to 26. Page number
26 serial number for petitioner, any date. Any date may be given.
It will be, the date will be given whenever you want.
Yes.
If, but not in June, July, August.
This,
This is matter. You have an interim order.
yes, madam.
Who has moved the memo?
I am the petitioner. I am not moved the memo, madam.
Have you informed?
I
them?
informed the, the other side advocate.
They have no objection.
And no objection.
Yes, list this matter in the month of September. It is submitted that at the request of land counsel for the petition, it is submitted that informed to the counsel for the respondent. This is on 15th of September. Yes.
Interim order, next.
Interim order earlier granted is extended. Yes.
Page number 7, serial number 27 to 30. Page number 8, 31 to 33. Page 9, 34.
My lord, serial number 34, my lord, I appear for the respondent. It's listed for dismissal, my lord. There's a stay order operating against me and the petition has become infructuous, my lord. Last time also they didn't appear, my lord, in serial number 34.
List this matter tomorrow in the first list.
Much of it.
So Lordship, kindly,
one,
matter
purpose.
of fresh matter.
No?
I'm sorry, yes.
Yes.
Yes, sir. Please.
No, what do you want?
Fresh matter, my lords, matter tomorrow.
Fresh matters don't have to mention, they will come in the list. Yes.
List number 1, for pronouncement of order, serial number 1, yes, Ram Murthy, AG Nagaraj for respondent.
For the respondent, my lord. For the petitioners.
The so-and-so court is requested to dispose of the matter as expeditiously as possible. The pending IA filed by the petitioner shall be considered expeditiously. Writ petition disposed of.
Serial number 2, M. Sudhakar Pai.
Petitioner minutes. Then respond.
Writ petition is dismissed.
Yes.
Serial number 3, D.R. Lakshmipati Reddy.
Both the writ petitions are dismissed.
Serial number 4, T. Sheshgiri Rao.
For petitioners, my lords.
Writ petition is dismissed.
Serial number 5,
Only request if possible, if the trial court can dispose of the matter.
Which year is
Serial number 4, my lord.
no, which year is the suit?
2022, sir. 2022.
Bangalore,
Ramnagar, my lord.
Ramnagar. Yes, in this matter, expeditious disposal. Yes, next.
Grateful to.
serial number 5, Kiran B.
For petitioners.
Or the order passed by so-and-so court is set aside. Consequently, I number 7 is allowed. The learned judge is directed to import the documents and determine the deficit, stamp duty, penny and penalty in accordance with law. Accordingly, it is
Obliged.
For orders matter, serial number 6, Omkar Basava Prabhu for petitioner. Withdrawal of.
I appear for the petitioner in this matter, my lords. The CRP has become infructuous. Aggrieved by the rejection of the IA, filed under Order 7 Rule 11, the CRP was filed. The underlying original suit is disposed on 5/8/2024, my lord.
petition has become infructuous as the main suit itself is disposed of. Accordingly, its petition is dismissed as infructuous. Yes.
I'm
Serial
great.
number 7, preliminary hearing, serial number 7, Maruti GB for petitioner.
Yes, what is the petition about?
They are seeking to consider the representation.
7/2/2022 order.
Yes, my lord.
2025 writ petition.
Yes.
It comes up for hearing in 2026 for the first time.
Yes.
What is this? Huh? Oh. List along with so-and-so. Morning he gave a memo.
Yes, my lord.
He gave wrong number. Yes.
This matter, my lord, the respondent number 3 and 4 are represented by Prashant BR, my lord, they are the authorities. And respondent number 5, my lord, HV Devraj.
Serial number 8.
Can you?
Serial
let
number
it- Let
7.
it come along with that.
Please, please.
Yes, 8.
Serial number 8, Kavita D.
My lord, in this case, mandamus direction I'm seeking, my lord. Mandamus direction I'm seeking to the respondent number 1, my lord. The bus is running, my lord, for that they are harassing and.
Concern petitioner representation dated 16/12/2025. You have given it to whom?
Respondent number 1, my lord, the Commissioner
Respondent
and
number-
Transport of Road Safety.
Who is respondent number 1?
Is given to respond number 1 is the state of Karnataka, my lord.
What is the representation she has given?
My lord, this representation, my instructions, my lord, this representation is not received by the authority, my lord. There is no acknowledgement for this representation, and this type of
You
representation.
got instructions on that?
Yes, my lord. There is no representation given, my lord. There is no acknowledgement in this representation.
Acknowledgement I'll furnish, my lord,
And kindly
because
see
they are
the subject,
given
my
by
lord, what
hand,
they
my
have
lord.
sought in the representation.
What is the representation?
Representation seeking direction to refrain transport officials from illegal stopping, harassment and coercion for bribe despite valid national permit and statutory documents.
My lord, despite I'm having all the documents, valid documents.
If they show, my lord, nothing will.
No, they are for bribe, my lord, each and every.
No. Will the principal secretary will consider your representation and will give the directions to entire state that this particular vehicle number so and so, whenever you see that vehicle, please don't stop it.
No,
Is that what you want?
My lord, here, my lord, we are facing
Whenever it
lot
happens-
of problems, my lord,
whenever
because
it
of this.
Please understand, whenever it happens, if it is, they are doing it something, immediately who is the authority there, you have to complain to them. What the principal secretary will do?
My lord, they are not ready to take complaint also. This representation, my lord,
It is not given.
10 times
No
we have
acknowledgement,
given,
my
my
lord. It is
lord.
not received, my lord. I received the instructions.
We have given 10 times,
Let them
my
give, my
lord.
lord.
They are not ready to take because their own officials know, my lord, they are not ready to take.
But what principal secretary will do? There can't be a general direction saying that don't stop this vehicle. Will he give such a direction?
My lord, not only for my vehicle, madam, n number of vehicles, this is the problem facing, my lord. Every day,
Then go file a public interest litigation.
if we are having a solid proof, my lords, definitely we can file that PL or something we can do. Here, my lord, every day, every officials, in the midnight also, my lord, they'll stand and they'll.
We cannot give that kind of a direction to the principal secretary.
My lord, I'll do subsequent, any other alternative remedy, my lord. Kindly, 2 weeks time may be given.
This is matter in the month of September. Yes, next.
Serial number 8, 9, serial number 9. Saji George.
Here for petitioner, my lord. My lord, suit is for miscellaneous petition.
Suit.
Suit for miscellaneous petition, my lord. The petitioner has filed a petition and
Who
after
appears the respondents?
Power Grid Corporation of India, my lord.
Yes, SCGP.
There is no state, my lord.
Serial number 8.
Who appears for this?
It's individual.
Oh, your petition is a Power Grid Corporation.
Yes, my lord.
What is the amount?
My lord, they are claiming that 12,60,000 rupees. But here, after 17,
How much is granted by the court?
there is no granted, my lord. I have filed the order 7 rule 11D application, my lord.
In this?
Yes, my lord. In that is page number.
Where is the order?
But order is annexure page number 41, my lord. My lord, there is a delay is condoned. The reason is paragraph number 2, my lord. Page number 42.
No, you said you filed order 7 to 11 petition.
And yes, my lord.
You are questioning this order, condemnation of delay.
Yes.
Your order 7 to 11. What is the impugned order?
There is no cause of action also, my lord. The impugned order is orders on IA number 1 and IA number 3 also. But here is my lord, paragraph number 2.
No, IA number 1 and 3 are two distinct different cause of actions. How can you file one writ petition?
IA1 is.
Order dated 10th October passed with the.
Yes, my lord.
In IA number 3.
Yes, my lord.
You have questioned only IA number 3, not IA number 2.
Yes.
IA number 3 is a limitation.
Limitation.
Yes, we'll order notice to the respondents.
Interim order may be granted, my lord.
Petitioner may be permitted to take hand summons on the council appearing with the respondent and file a memo to that effect. In once a memo is filed, it's a matter.
Serial number 10. M.N. Ramesha for petitioner.
I'm appearing for petitioner, my lord. It is a writ petition filed by the impleading applicant in a suit for specific performance, my lord. My lord, impleading applicant already filed the suit for partition against the defendant, who is the father and mother and brother, my lord. During the pendency of the suit, the defendant's hearing, they have alienated the enter into agreements of sale with the plaintiff, my lord. We have impleaded the plaintiff in the suit for partition and also obtained a stay order, my lord. Subsequently, we have filed the impleading application. Plaintiff never participated in the partition suit, my lord. Subsequently, he had filed a suit for specific performance. Yes, therefore, we have filed an impleading application. The Honorable Court has rejected the application, saying that you are a third party to the suit. Hence, before this Honorable Court, my lord.
Is during the pendency of the suit, all this has happened.
Yes, my lord.
That is hit by lis pendency.
Yes, my lord. My lord.
You have already filed a comprehensive suit.
Yes,
in that this person is also a party. Then why should you contest this matter?
My lord, if it is decreed, my lord, it is against to my interest.
All these facts will be there on your the partition suit that is filed. Your defendants must have filed the written statement. Already your.
My lord, this plaintiff did not contesting the matter in the partition suit, my lord.
If not, he will face the consequences. In this suit, the defendant, that is your family, is there.
Yes, ma'am.
In that they must have filed a written statement about the suit that is filed. So they are already your file.
My lord, another one, my lord. Defendant one is the father of the impleading applicant. Subsequently, has died, my lord, expired. On Annexure F, my lord. Annexure. Death certificate has been produced, my lord. 2012-2025, my lord. So the petition impleading up.
The respondent's petition is permitted to take out hands and file a memo to the defendant.
Stay, my lord, in this.
Cell number 11.
Once the memo is filed, is the matter.
This case, my lord, for the petitioners, my lord. I filed an application for appointment of court commissioner, my lord. The defendant, my lord, the defendant by suit for injunction, my lord. Well, the defendant by encroaching the
suit of which year? No, if you tell the answer the court's query, it will be easy, so that we can. Suit is for?
Suit for injunction to the 2024.
For the?
2024, my
lord. The plaintiff.
I am the plaintiff, my lord.
What is the stage of the suit now?
Well, plaintiff, my lord.
Yes.
Yes,
at the stage you filed the IA.
Application, my lord.
Come to the IA. Where is that?
IA, page number 85, my lord.
Yes.
To appoint court commissioner, city survey, my lord.
Let's see. What happened? What happened to the interim injunction?
My lord, the application is rejected, my lord. My lord, the observation by the honorable trial court, my lord, the trial is not commenced.
Let us just see.
At page 30,
he filed a counterclaim.
My lord?
Filed a counterclaim.
Not filed counterclaim, my lord. He admitted that he is the adjacent owner. Western side is property, eastern side my property, my lord. In his written statement. Now, I filed, since my contention is that eastern portion by encroaching the property, he started work in his property. Therefore, I filed a suit, my lord. Now, the court commissioner to identify whether he is encroached or not, my lord. Why? Because there is an adjacent property each other, my lord. The page number 30, my lord.
Please come to the order.
But page number 30, my lord, para 24, my lord. The orders of the honorable trial court. Judgment court. Para 24, my lord.
No, we'll go from para 15. Para 15.
Yeah, right. Now the plaintiff have filed the present application seeking appointment of court commissioner, stating that the defendants in collusion with each other trying to encroach upon the suit scheduled property on eastern side, having dug the borewell in a portion of suit scheduled property and thereby alter the nature of property. The relevant portion, para 24, 25, my lord. Judgment. Trial has not
On
started.
careful perusal of the material, it is evident that after filing the written statement by the defendants, issues have not yet been framed and the trial has not yet commenced.
Yes, ma'am.
At this stage, the parties have not led any evidence before commencement and without there being any evidence placed on record, so and so. Yes, what is wrong with this?
Now,
order?
my lord, the application can be filed at any stage of the suit, my lord. Why? Because
Yes, take that.
In that judgment, my lord, page 9, my lord.
There are other judgments.
One more judgment is, my lord.
Not in your favor. There are so many judgments against you.
No, my lord. In this, my lord, at any stage, the application may be considered page 9, my lord. My kindly moment. In the last paragraph. In the above decision, it is held that depending on the facts and circumstances of the case, the court commissioner could be appointed for elucidating the dispute
Suit
between
is
the
for
parties.
declaration of the scheduled property. Now, in your suit, what you are seeking is injunction restraining them from interfering with your portion. Your interim application for injunction is dismissed. Now, the trial has not commenced. Nothing has. You have to lead your evidence.
My lord,
You have to prove your case basing on
my contention in the suit, my lord, eastern side by encroaching his property is the recent holder, my lord. 2024 he purchased the property. My property since from 1956 is ancestral property, my lord, the social property. And we requested him to measure his property, but he is without there being anything, is started construction, my lord. Therefore, I filed a suit. Now, my lord, to come to a conclusion whether he encroached or not, the appointment of court commissioner is required to, in terms of the report, the dispute may be resolved, my lord, between the parties. Therefore, the report is required. I filed the present application. Therefore, the application and my lord, the another judgment, my lord, the appointment of court commissioner will not put an end to decree the suit, my lord. It is only to get the evidence whether it is really encroached or not, my lord. The another.
So, according to you, in every suit, even without leading the evidence, appoint a court commissioner, basing on the court commissioner's report, decree the suit.
No, my lord. But the main contention by the both parties is in the written statement is saying is not encroached.
First of all, lead
In
your
the plaint,
evidence.
I am contending that is encroached.
Take that judgment.
Therefore, my lord,
Yes, which paragraph you
is
are
para number 6, my lord.
Yes.
Therefore, this court is of the considered view that merely appoint the court commissioner to measure the alleged encroachment by the respondent defendant would not amount to decreeing the suit in favor of the petitioner plaintiff and not amount to collection of evidence in favor of the party of the suit. However, it would be definitely aid the trial to decide the controversy between the parties. It is always open to the respondent defendant to challenge the report of the commissioner in a pending suit by filing objections and by cross-examining the court commissioner. In view of the same, keeping in mind of the peculiar facts and circumstances of the case, this court is of the considered view that the trial court has committed an error by rejecting the application filed by the petitioner plaintiff. Hence, the aforementioned reasons cause the following order.
Please come. Present petition is filed. Agreed with the order passed in I number 2. NOS number 7244 of 2024, dated 6th March 2026, by the 6th Additional Civil and Session Judge at Bangalore. The petition herein has filed a suit for partition. In the said suit, the petitioner has filed an IA seeking interim injunction that came to be dismissed. Now, the suit is pending for framing of the issues.
The issues are framed, ma'am.
No, the court observes that it is not as per the.
No, ma'am. As an present issue.
Not now. We are only concerned
Yes,
with when the suit is pending for framing of the issues. At that juncture, the petitioner has filed an application. Petitioner plaintiff has filed an application seeking appointment of commissioner that came to be dismissed by order impugned. Hence, the plaintiff is before this court. Next paragraph. The trial court, while dismissing the application, has observed that on careful perusal of the material on record, it is evident that after filing of the written statement by the defendants, issues have not yet been framed and the trial has not yet commenced. At this stage, the parties have not led any evidence. Before commencement of the trial and without there being any evidence based on record, the plaintiffs have filed the present application seeking appointment of a surveyor as court commissioner to measure the written statement scheduled property. The court observed that it is a settled law that a court commissioner cannot be appointed for the purpose of collecting evidence on behalf of a party. The parties have to establish their respective claims by leading proper evidence before the court. It is also relevant to note that in a suit for permanent injunction, the primary issue for consideration is with regard to the lawful possession of the suit scheduled property as on the date of the suit. Under alleged interference by the defendants, the next same para full stop. The question of title or encroachment to determine exact boundaries generally cannot be adjudicated in such a suit. Therefore, the parties must first lead their evidence during the course of the trial. If after the parties have adduced their evidence and despite their best efforts, the court finds that there is any ambiguity or difficulty in appreciating the evidence, then the court may consider appointing an advocate court commissioner for local inspection to clarify such ambiguity. Court further observed that it is a well-settled principle of law that a court commissioner cannot be appointed for the purpose of collecting evidence on behalf of a party, particularly in a suit for injunction. The purpose of appointing a court commissioner is only to assist the court in elucidating any matter in dispute and to bring the real facts before the court when necessary. Such appointment can be considered only after the trial. Also, if any ambiguity arises in the evidence placed before the court, and accordingly dismiss the petition. Plaint counsel appearing for the petitioner submits that at any stage of the proceeding, the court commissioner can be appointed, particularly in the light of the dispute between the parties, where according to the petitioner there is encroachment, according to the defendant there is no encroachment. It is all the more necessary to appoint the advocate commissioner, and the court, without considering all these aspects, dismisses IA only on the ground that the trial has not commenced. He has relied on the order passed by a coordinate bench of this court in WP number 2362 of 2023, dated 24th November 2023, in case of Sri S.V.K. Patil and Manjunath C.J. and others. He relied on paragraph number 7. Also, he relied on another judgment, another order passed by a coordinate bench in case of Manjunath SC versus Srimati Gangamma, arising out of WP number 17853 of 2023, dated 9th October 2023. He relied on paragraph number 6. Please extract both the paragraphs. Relying on these judgments, Land Council submits that the court went wrong in dismissing the application only on the ground that the trial is not yet commenced, and in the light of these judgments, at any stage of the proceedings, the commissioner can be appointed. Anything else?
In view of the report, my lord, in the coordinate bench already held, my lord, in the para 6, my lord, even if it is a filed report, that can be filed an objections and cross-examined also.
That is already extracted.
And to put an end to the litigation, my lord, only is that, my lord, if its reports comes, my lord, whether it is encroached or not encroached can be find out, my lord, then dispute will be resolved, my lord. Therefore, the appointment of court commissioner
submitted by the Land Council that just because the advocate commissioner is appointed and basing on his report itself, the suit will not be declared. Whether there is encroachment or not, the court will be able to come to the conclusion. Next paragraph. Having heard the counsel for the petitioner, there is a material on record. The suit is for bare injunction. Petitioner has filed an IA seeking interim injunction that came to be dismissed. As on the day when the order is passed, the issues are not framed. The trial has not yet commenced. The petitioner has not yet left. Both the parties have not yet let their evidence. At this stage, the submission of the petitioner that any stage of the proceedings, the advocate commissioner can be appointed. Such submission cannot be appreciated. This court has perused both the orders passed by both the courts, by the judgment the petitioner has relied on, and the ratio that is laid down in the judgment All depends upon facts and circumstances of each case. In the considered opinion of the court, without even before the evidence is started, the court cannot appoint an advocate commissioner. And in fact, as rightly observed by the trial court, appointment of an advocate commissioner is only to assist the court in elucidating any matter in dispute and to bring the real facts before the court. First, the parties have to discharge the burden cast upon them, and they cannot, without proving the case, without adducing any evidence, they cannot seek for appointment of advocate commissioner. And the court was right in dismissing the IA, and this court finds no reason to interfere.
And one indulgence of this court. Maybe liberty after trial may file an application.
This will not preclude the petitioner to seek appointment of advocate commissioner at an appropriate stage.
Please.
And then the court will consider the same in accordance with law. Yes.
Number 12, H.S. Santosh for petitioner.
Petitioner. Petitioner is a defendant before the trial court. My lord, application under 6 Rule 17 filed by the respondent plaintiff is allowed by the trial court.
Suit is which year?
Suit is of the year 2024, my lord.
What is the suit for?
Suit is for bare injunction filed by the respondent one.
Please come to that affidavit.
Application.
Affidavit filed in support of the application.
Please, my lord. The affidavit is at page number 26. Annexure C. Affidavit is at page 26. Unnumbered para 3.
1 minute. Trial has commenced?
Not yet commenced. But your lordship may kindly see the unnumbered paragraph number 3. I state on oath after filing of the suit by the defendants have appeared and filed written statement, and in the written statement the defendants have admitted regarding the execution of the mortgage deed by Chikkamada Shetty and his son in favor of our father. They have taken a false contention that the said Chikkamada Shetty and his son have executed the registered sale deed on 29/11/2020 in favor of Chikke Gowda, who is none other than the husband of the first defendant and father of other defendants. And also contended that after purchase of the said land, they have discharged the mortgage money and redeemed the suit scheduled property, etc. Thereby, defendant have denied my ownership and possession over the suit scheduled property in view of the said plea of the defendants. The incorporation of the relief of declaration is quite essential.
What is wrong in this?
And now the suit is filed for bare injunction. The dispute between the parties is that, my lord, whether the mortgage deed is redeemed by the defendants or not.
No. According to the plaintiff, he is the owner of the property.
He is the owner of the property, and the contention in the suit was that, my lords, only there is an interference by the defendants basing on the fact that there was no redemption of mortgage
the title
deed.
of the plaintiff or not, and you are asserting your title to the property. When you are asserting title to the property, as in the light of the settled law in Anathul Sudhakar, the bare suit for injunction is not maintainable. Necessarily, he has to seek declaration.
My lords, it was within this knowledge that, my lords, there was a sale deed in my favor. It was within the knowledge of the respondent plaintiff that there was a sale deed in my favor in the year 2020 itself.
No prejudice, nothing. No prejudice to that.
My lords, there is no statement in the affidavit.
What is the prejudice to you at this time? At this juncture, what is the prejudice to you?
Because, my lords, the sale deed in my favor.
2024.
Suit is of the year 2024, my lords. The sale deed in my favor is in the year 2020.
Let us see what is the amendment that is seeking.
The very previous page, my lords, page 24.
So when either the mortgagee and his son Shivanna, so and so never discharged the mortgage money and never received the mortgage deed dated, thereby the lease sale deed dated, executed by the mortgager by name so and so, is illegal, void, and does not bind on the plaintiff. And in view of the failure on the part of the mortgager or purchaser in not redeeming the mortgage within the statutory period, they have lost the right of redemption, and the plaintiff and his father have become the absolute owner and in lawful possession. Come to the plaint. What is this case?
Plaint, my lord.
Plaint.
Plaint, please. Page 11, my lords. Annexure A, page 11 is the plaint. My lords, para 3. It is submitted that the above referred suit scheduled property is originally owned and possessed by one Chikkamada Shetty and his son by name Shivanna, and being the absolute owner and in full possession, lawful possession of the suitable property, they have mortgaged the same in favor of the father of the plaintiff by name Bulegowda under the registered mortgage deed dated 30/4/1971 by receiving the mortgage money of rupees 800 and delivered the vacant possession of the suit schedule property in favor of the father of the plaintiff. And under the said mortgage deed, the mortgagors have undertook to redeem the mortgage by discharging the mortgage money within 5 years from the date of mortgage. But even after the lapse of 5 years, neither the mortgagor nor their legal heirs never redeemed the mortgage.
So in the plaint, there is no whisper about the document of whatever the sale deed, there is no mention about this. Because
There is
they are
no
not-
mention.
Because they are not aware. They say that they came to know about it when you filed the written statement. That is
That's
what.
1980 is my sale deed. They are aware that in the year 1971, there was a mortgage deed. My sale deed is of the year 1980.
Well, what about the revenue entries and all?
Revenue entries were there in my name.
Come to the order.
Please. Para 7, page 53. Minutes. Reasoning.
No, the relief that is sought is that seeking a declaration that the sale deed is not binding on them.
Well, just because I have averred in my written statement and to cover up the latches and lacuna, my lords, now they have filed this amendment application.
Come to the order.
Page 53. Ma'am.
Let's read the reasoning part.
Suit of the plaintiff is one for the relief of permanent injunction in respect of the suit scheduled property and further submits that the defendants have admitted the execution of the mortgage deed by Chikkamada Shetty and his son in favor of his father, and they have taken a false contention that the said Chikkamada Shetty and his son have executed the sale deed on 29/11/2000 in favor of Chikke Gowda in favor of deceased Chikke Gowda. After purchase of said land, they have discharged the mortgage money and redeemed the suit scheduled property, and also the defendants have denied the ownership and possession of the plaintiff in respect of the suit scheduled property, hence praised to allow the same. On the other hand, the defendant number 9 has denied the said facts by submitting their objection, and they have taken that the suit scheduled property worth more than rupees 30,000 per gunta. Hence, this court has no pecuniary jurisdiction to try this matter, and also the present amendment claimed by the plaintiff only to drag on the proceedings, and also once a mortgage, always a mortgage. Accordingly, at any point of time, he has not claimed any ownership on suit scheduled property, hence praised to reject the same. But as per their defense, set out in the objection, he is not specifically denied made in the IA along with the affidavit, and they have only taken plea regarding over the once a mortgage, always a mortgage, but they have not specifically pleaded in their objection with regard to the suit scheduled property on the ground that nature of the property and nature of the acquisition of the suit scheduled property, and the defendants have not specifically denied the possession over the suit scheduled property. And my lords, the
Please come.
decisions are.
Then counsel appearing for the petitioner submits that initially the plaintiff has filed the suit for injunction. Later, now the IN under order 6/17 is filed, seeking amendment of the plaint, whereby is questioning a sale deed that is executed in favor of the defendant in the year 1980.
1980, my lords.
1980, all the encumbrances and all the documents show, all the public documents reflect the title of the petitioner, as he has failed to question the same. Now to cover up the latches, he is coming up with the time barred the pleas, which cannot be permitted by way of an amendment. Considering the submission, there shall be stay of all for the proceeding. Notice to the respondents. In addition, petition is permitted to take out hand summons on the respondent, counsel appearing to the respondent before the trial court, and shall file a memo to that effect by 16th of July, or else the stay granted by this court.
My lords, may I seek for a dispensation of notice to the other respondents except respondent number 1, because respondent number 1 is the contesting plaintiff.
What? To whom you are seeking dispensation?
2 to 8, my respondents 2
Memo
to
is
8.
seeking dispensation of notice to 2 to 8. Notice to 1 and 2.
Only notice to respondent number 1, who is the plaintiff
Is
before
to
the trial.
respondent number 1. Yes.
and dispensation to 2 to 9, my lords.
2 to 9. Give the memo.
Please, my lords.
Yes.
Your lordship, may I seek for a stay of the proceedings?
Stay.
Yes.
Serial number 13, Chairman CS.
No, I am not loud.
Appeal for petitioner, my lord. Petitioner has filed this present writ petition seeking mandamus to the respondent to give electricity connection, my lord. The petitioner is aged about 83 years old lady. She is residing for the part 20-25 years in the same house. There are 4 houses, ground floor,
No,
2 houses.
please serve the papers on Mr. Devraju. I will take up tomorrow.
I have served the copy to the
No, counsel is there. for
Please.
them. Then counsel shall serve the copy of the writ petition on Mr. What is it? Devraj? H.V. Devraju, District Director to print the name of Mr. Devraju. List this matter tomorrow in the first list.
Please.
Serial number 14, A.V. Narasimhan for
appear for
petitioner.
The first defendant's writ petition. My lord, a suit had been filed by the plaintiff seeking, my lord, totally 6 reliefs, as could be seen at page number 19 of the petition. My lord, she wants the cancellation of the gift deed executed in my favor. Declaration of.
So what is the suit for?
The suit is, my lord, for seeking a cancellation of the gift deed that is executed in my favor. Seeking a declaration that plaintiff is the owner of the property. Mandatory injunction that the structures that I have put up will have to be demolished. Then concerning, my lord, injunction not to alienate and for cancellation of the khata. These are the reliefs, my lord, that have been sought. My lord, the issues did not cover, my lord, all these reliefs and averments that were made. My lord, Annexure C, page number 26, my lord, only one issue, my lord, had been framed concerning the gift deed that was executed in favor of defendant number 2. The other part of it, my lord, was never covered. And hence, my lord, I make an application saying that since the matter pertains to her declaration of title and also for cancellation of a registered gift deed in my favor, additional issues will have to be framed. That, my lord, by the impugned order has been rejected.
Yes, sir.
My lord, please. My lord, it commences from page number 43, my lord, paragraph number 9.
40?
Page number 43, paragraph number 9.
No, where is your IA? You
My lord,
wanted
IA,
what
my
are the
lord, is
issues
that-
to be framed?
The IA is at Annexure D, my lord, page number 27.
Yes. The plaintiff proves she purchased the suit property using her own funds and not the funds of defendant number.
It is in, all that I'm saying is she must prove that she is the owner of the property. It could have been, my lord, casted in a better manner. I do not, and even, my lord, the second thing also could have been done in
No,
a better.
you want an issue which is beyond the scope of the suit and beyond their pleading.
I wanted, my lord, she to prove her title.
Whether the plaintiff proves that the fraud was committed by the defendants.
My lord, may I request this, my lord? I'll withdraw this IA. My lord may permit me to file a fresh application, my lord, culling out the proper issue, my lord, that could be framed. Then, my lord, let the trial court take a decision. I quite see, my lord, that the issues that I myself have proposed, my lord, is not that appropriate. This IA, my lord, I may be permitted to withdraw.
Then what about notice to the respondents?
Since, my lord, I am withdrawing the application, my lord, they may not be prejudiced.
No, because I'm giving liberty to you to again.
May I take notice, my lord, in that?
List, the petition is permitted to take out hand summons on the counsel appearing with the respondent and shall file a memo to that effect. First of July.
Please, ma'am. Please.
If the memo is filed by 1st of July, list this matter on 2nd July.
Very well, please. My lord, I'll take out notice on first respondent, my lord, who is the plaintiff. The rest I may be permitted to seek a dispensation.
What the others?
My lord, they are co-defendants, my lord. The sub-registrar be
Any 2
to 4, my lord.
Notice to a memo is filed seeking dispensation, notice to 2 to 4. Dispensed with respondent number, you shall take out hand summons on respondent number 1.
Please, great.
Your colleague is arguing very well.
Great, please.
Cell number 15, Manjunatha A. for petitioner.
Appeal for the petitioners, my lords. Plaintiff's writ petition, my lords.
Yes.
Plaintiff's application for consolidation of 2 suits, it's been rejected, my lords. This suit is for
What are the
declaration.
suits?
Declaration, my lords.
When is the declaration suit filed?
Declaration suit is filed in 2019, my lords.
What is the suit number?
OS 4301 of 2019, my lord.
4301 of?
2019.
Hmm.
Earlier suit is, my lord, 6833 of 2016.
68?
33, my lords.
What is that for?
That suit was only for bare injunction, my lord. That was filed only by second petitioner or second plaintiff, my lord.
Parties are not one and the same?
No, second plaintiff is the owner of the property.
You
my
are?
lord. I'm for the plaintiffs, my lord. All
Which
the plaintiffs.
case?
In both the cases, my lord.
Oh.
Both the cases, except in the present petition, my lords. For parents have been added as an additional parties. Defendants are same, my lord. Properties are same, my lord.
Hmm. What is the stage in both the cases?
My lords, the stage of plaintiff's evidence, my lords.
In both cases?
Yes, both the
Filing
cases.
before the, pending before the same court?
Same court, my lords. It was earlier, this suit was pending before court number 10. I filed transfer petition and thereafter it has been transferred.
Let's see the order impute.
Yes, please, my lord. Annexure E, my lords. My lords find it in page number 56, my lord.
In page number?
56 is the order, commencement of the order, annexure E. My lords find the findings at page 59, my lord. Reasons.
Yes, let's read.
Para 10, my lords. On perusal of the pleadings and material placed on record, it is evident that OS 6833 of 2016 is filed seeking bare injunction, whereas OS 4301 of 2019 is the suit for declaration and consequential relief.
No, you have filed a suit for injunction.
Yes, my lord.
That defendant is also a defendant in this suit.
Yes, my lord. In a suit for declaration related alleged transaction, including agreement of sale dated 27/7/2015, the nature and scope of the reliefs and cause of action and issues of adjudication in both the suits are not identical. Merely because the suit shall property may be common, it cannot be automatically led to consolidation.
What you said is not correct. Para number 11.
Yes, please, my lords. Further, from the records, it is clear that the present suit is in the initial stage of plaintiff evidence. The suit in OS 63 has already reached an advanced stage argument, and on 14/9/2022, the case was posted for argument on
No, your
merits.
suit for declaration is against your family.
No, my lords. The fact is this, my lord. Second plaintiff acquired the property by virtue of a gift deed executed by first plaintiff, my lord.
Come to the cost item. In the suit.
Suit, my lord.
Plaint, come to the
Plaint
plaint.
annexure A, my lord.
Page number.
Page 22, my lords. Chinnappa Reddy, Mona Saralavati, my lords.
You are the plaintiffs.
Yes, my lords. Mona is the owner of the property, my lord. She acquired the property by gift deed executed by her father, first plaintiff Chinnappa Reddy, my lords. She alone had filed a suit for permanent injunction, my lords. Thereafter, the defendant had raised the defense that there is a sale agreement coupled with GPA executed by Chinnappa Reddy. On the strength of agreement and GPA, they have transferred the property into their names, is what their defense taken. Pursuant to me filing a suit for injunction, my lords, my father, that is the Chinnappa Reddy, along including me, has filed the present suit for declaration, seeking for cancellation of those agreement of sale and GPA, my lords. Allegations
So
of
agreement of sale is executed by Mona.
no, my lord, Chinnappa Reddy.
In favor of?
That is Pavan Kumar and Krupananda, defendants, my lord.
And injunction suit
By Mona, second plaintiff, my lords.
against?
Against Pavan Kumar and Krupananda, my lords. After execution of an agreement to sell, my lords, he executes a gift deed in my favor, my lords. When there are an acts of interference, I file a suit for injunction, my lord. Subsequently, my lords, they set up agreement of sale and power of attorney, and challenging those documents, my lord, second suit has been filed, my lords.
Yes. Oh, it is at the stage of arguments, OS number 6833.
My lords, it's been recalled for further chief, my lords. In the same para, my lords, the trial judge records that the counsel for plaintiff
No,
filed
in the other suit, the evidence itself is not yet commenced.
evidence. It has been commenced, my lord. It is stage of plaintiff evidence, my lord.
No, it's the initial stage of plaintiff's
Yes, my lord.
evidence.
So that defendants have not led in evidence in both suits, my lord. So that a common trial can be conducted, my lords. If
Court has rightly said consolidation would lead to delay in protraction of proceedings. No, in this case, the issue is very simple. Your sister,
daughter, my lord.
has filed a suit for injunction.
Injunction, my lord.
Whether it is interference or not under water, that will be decided independently. It's a simple suit.
But properties and facts are
Might be.
Yes, my lord.
But what were you doing from 2019 till now?
Lords,
2026.
I'm plead. It's a transferred brief, my lords. I filed my NOC Wakal in 2025, my lords. Immediately on yes,
You means not you.
yes, parties.
You mean the party.
They
what
ought
they're
to have,
doing.
my lords. They had filed miscellaneous petition and got it transferred, my lords, but they did not, out of ignorance.
At this stage, it is not required. Please come. Agreed with the orders passed in I number 1. OS number 4301 of 2019. dated 12th January 2026 by the 20th Additional City Civil and Session Judge Bangalore. The petitioner plaintiff is before this court. The petitioner, the second petitioner here, petitioner plaintiff herein has filed OS number 6833 of 2019. Is it 2019?
My lord, 2016, my lord.
2016, seeking bare injunction against the respondents herein. Thereafter, OS number 4301 of 2019 is filed by all the plaintiffs against the very same defendants seeking declaration that the agreement of sales are not binding on them.
Yes, my lord. Agreement and the GPA is not binding and seeking for cancellation.
And also seeking for cancellation. The suit OS number 6833 of 2016 is at the stage of arguments, and at that stage an application was filed for recall and reopen of further chief examination of PW2. It was allowed on 25/1/2025. The other case, that is a bare injunction suit, is in the initial stage. The plaintiff in OS number 4301 of 2019 has filed the present application under section 151 CPC, praying to consolidate or club the present suit with OS number 4301 of 2009, with OS number 6833 of 2016. And that came to be rejected by order impugned. While rejecting the IA, the court has observed that looking at the stages at which the cases are pending, consolidation would lead to delay and protraction of proceedings, defeating the object of expeditious disposal. The court had placed reliance on the judgment of the apex court in Chittivalasa Jute Mills versus JP Reva Cement, reported in 2004 3 SCC 85, that consolidation can be permitted only when it avoids multiplicity and when the issues are substantially the same, and that if the suits are at different stages or involve different causes of action, consolidation would delay justice, and the consolidation cannot be permitted when the subject matter reliefs and issues are distinct when one suit has reached advanced stage. Accordingly, the court has dismissed the IA. And counsel appearing for the petitioner submits that the subject matter of the subject matter is one and the same. The defendants are one and the same. In those circumstances, if both the suits are clubbed together and a common evidence is let, it would be in the interest of the parties, and also otherwise it would lead to conflicting judgments. And in that view of the matter, the court ought to have consolidated both the suits. But the court, without considering all this, has dismissed the IA that's filed with the petitioner. It's better having got the counsel for the petitioner or is the material on record. The suit for injunction is filed by the daughter of the plaintiff, that is second plaintiff, in a suit for declaration. That suit was filed in the year 2016, and the declaration suit is filed in the year 2019. One is a bare suit, another is a suit for comprehensive suit for declaration and other reliefs. If the intention of the plaintiff is for consolidation of the same, he would have sought for it at an early stage. Now, the suit for permanent injunction is almost at the advanced stage, and the other suit is at the stage of is at the initial stage of evidence. In these circumstances, the court has rightly held that it is not appropriate to consolidate both the suits, and it will unnecessarily delay the proceedings. This court do not, and this court is the view that the said finding of the court the court has dismissed the IA with a sound reasoning, and it requires no interference at the hands of this court. Accordingly dismissed. Yes, next.
Great.
That's 16. Leela P for petitioner.
My lord, this is a LIC matter, my lord. The impugned order is an order allowing the impleading application of the respondent number 1 to 6, my lords. The petitioners are the claimants, my lords. My lords, the impleading application, my lords, relies on two documents, my lords. One is a typed copy of the partnership deed, which.
What is the suit?
My lord, land acquisition case.
Land acquisition.
Please, my lord. The impleading applicants, my lords, claim they claim the property as per a typed copy of a partnership deed, my lords, which is misrepresented and said that it is a copy of the partnership deed, my lords. And another order of the Tahsildar on 1/10/1984, which was already repealed by set aside by the Assistant Commissioner in 1984 only, my lords. But they suppressed these two facts and they implead themselves as claimants in the land acquisition case, my lords. My lords, may come to page number 45, my lords. Annexure C of the impleading application.
1 minute. No, we'll come to the order. Please come to the order.
Page number 29, my lords, para 10. The respondents have acquired the land bearing survey number so and so for metro rail project. The impleading applicants have stated that their mother, Srimati Sharda R. Kattare, has entered into the partnership.
Yes, I got it.
Please. May I continue, my lords? With late Lakshmi partnership deed on 19/5/1996 with late Lakshmi Bai Kattare, wife of so and so, and Lakshmi Bai Kattare M Kattare was entitled 33.33% in partnership from.
Where are your objections? Have you stated all these facts?
My lords, my objections, everything was taken, my lords.
There is a discussion about your objection in the order.
My lords, may I seek a pass over, my lords?
Pass over.
Cell number 17.
Lord, I appear for the petitioner in this matter.
Mahesh Kiran.
My lord, this yesterday one similar matter had come up before your lordship with regard to the shifting of the licensed premises within the panchayat limit. On similar lines. Yesterday, the one Mr. Praveen Kumar was directed to take notice, and matter is posted on 30th.
This is matter on 30th. Mr. Praveen Kumar is directed to take notice.
For R3, my lord.
For R3, AGA takes notice for 1
R4, my lord, R4.
R4, AGA for 1 to 3.
1 to 3.
1 to 3. In the name of so-and-so. Please this matter along with, give the number.
Please.
18664 of 26.
Write on a paper and give so that there won't be any confusion.
Please.
Yes.
It's listed on 30th, my lord.
30, along with that.
Please, publish.
18. Rajgopal TK.
Appearing for the petitioner, manner. Suit is filed by the plaintiff for ejectment of the suit schedule B property against the defendant, manner. First defendant is the tenant of the plaintiff, manner. And first defender sublease to the defendant number 2 and 3, manner. The application is filed now is for depositing of the rent by the first defendant, manner. That came to be rejected, manner.
You are the plaintiff.
We are the plaintiff, manner.
Come to the order. Where is the order?
Para 9, manner. 20, page 20, 21, manner. Para 10. Page 21.
Yes.
The relief sought in the IA is in the nature of the final.
Come to page, para number 7.
Admitting the above suit filed by the ejectment on the basis of the rental agreement with the defendant number 1 entered between the plaintiff and the defendant number 1 on 7/4/2017. According to the plaintiff, the defendant number 1 has become the chronicle default in the payment of rent since 2023 June. And he has violated the rental agreement by subletting the same to the defendant number 2 and 3. It is further pleaded that despite several requests made by the plaintiff to quit and deliver the vacant position, he has defeated it. The plaintiff's interest is shifted to the Bangalore and reside at the suit schedule B property. In this regard, the plaintiff sought for relief of ejectment of arrears of rent. The plaintiff one has filed defendant number one has filed wakalat on 1/4/2001. Thereafter, he has not appeared before the
Now, the
court.
defendants have, is there any admitted rent as per the defendants?
What, Milan?
Any admitted rent by the
Yeah,
defendants?
Milan. In the written statement, they have clearly admitted that they are in the. Kindly come to page 35, Milan. Para 7, Milan. Below from top file. The lease agreement was executed between the defendant number 1 and defendant number 2 and 3 dated 1/9/2021 is true. The defendant number 2 and 3 and verification of the other tenants agreed in the same premises flat was executed by defendant number 1, maintaining the premises and was collecting the maintenance charges for the many years. Clearly, they have admitted that.
It is submitted that defendant number 2 and 3 were put up in AK apartment in the year 2020. The advance amount paid is rupees 65,000 only towards the lease amount for the present premises by defendant number 1.
That AK apartment is a separate one, Mala. He was put.
Asking you, where did the defendant admit that this is the rent?
They say that they are in the lease for the 10 lakh rupees. But we have let out the premises for the D1 for a 20,000 Mala.
Where is that accepted by D1? No, at this stage, if you're asking.
D1 has not filed the written statement, Mala. He just appeared before the court and filed a wakalat.
Oh, that is what the court said, that it has to be decided now. No, you're seeking the main for final relief itself.
But one decision is clear, Mala.
What decision is clear? Now at an interlocutory stage, what the court can do?
Malad, he is the tenant, Malad. D1 is the tenant. He let out that sublease to the D2 and D3 by receiving 10 lakh rupees, Malad. So he has not before the court and he has not filed a written statement. But owner is let out the premises to the D1 for the.
Take notice. Notice to the respondent. Petition is permitted, take out hand summons on the counsel appearing for the respondent to the trial court and file a memo. Memo by, if the memo is filed by 3rd of August, list the matter on 4th of August.
Stay of the proceedings. Stay of the proceedings, further proceedings.
Your suit. So that means something is not right. Why should the suit be stayed? Yes.
19, PN Nanda Reddy, for petitioner.
Yes.
It's a plaintiff's petition. Plaintiff's petition. Plaintiffs filed a suit for partition declaration and consequence of injunction against his brother and the vendor of his brother before the vacation court. The vacation court had, after hearing on the interim application, ex parte, passed an order at page number 36. 36, an emergent notice was issued. I have filed an application for relief of injunction not to alienate the suit schedule.
We'll ask the court to do it when the suit summons are returnable by?
August, Miller. Here, what is happened is that.
We'll ask the court to hear this matter within 1 week.
Until then, my lord,
No, until then. We'll ask the court to hear it within 1 week.
Please, my lord. But
no,
in the meanwhile, if they.
No, but no meanwhile. Please come.
Please.
The petitioner is before this court questioning the order passed on item number 2 in OS number 207 or 2026.
It is transferred to the jurisdictional court. It is OS
20
1 to 112.
Dated 29 by 2026. Now transferred to the principal senior civil judge Bangalore Rural in OS number 1123 of 2026. Petitioner has filed a suit for injunction.
No, partition.
Partition. In that he filed an IA seeking, where is the order?
Order is at page 36.
Page 36.
36. But 36, it.
Has filed an IA seeking injunction. Seeking ad interim injunction that the court where is that? Where do you get it? the court, instead of granting the ad interim injunction, had issued summons. I have issued the emergent notice on I number 2 and sued summons to defendants returnable by 15/6, not August.
Now it is posted on August month.
What happens? Summons or not served?
Summons was not served.
On 15/6/2026, learned counsel for the petitioner submits that when an application is filed seeking ad interim injunction, whether the petitioner is entitled or not, either ways, the court should pass an order, but the court cannot issue summons without considering the IA on the merits of it. If any order is passed, if any adverse orders are passed, still the petitioner would get a remedy to approach the appellate court. A coordinate bench of this court in so and so, that judgment is there. You can so and so has observed as follows: in the light of the order dated so and so, the writ petition is disposed of, directing the trial court to consider the IA number 2 passed by the petitioner on the merits of it in accordance with law within a period of 1 week from the date of receipt of the copy of the order, whether the summons are served or not.
Please.
Number 20, Siddharth Suman.
No notice is issued to the respondent as no adverse orders. Yes.
Not a very shocking order passed by another trial judge in a matter which is stayed by the very same judge, my lord. This is a matter, my lord. I'm the defendant number 3 before the honorable trial court, my lord.
Defendant number?
Defendant number 3, my lord. This is a suit of the year 2013. There are 3 suits totally, my lord, intersect between all the parties. This is the 3rd suit, my lord. First 2 suits, my lord. First suit is in 2007. Second suit in 2009, my lord. Third suit, my lord, which is before my lords, is 2013. My lord, I filed my written statement. It's a suit for partition, my lord, also seeking for cancellation so far as a bill is concerned, and mean profits, my lord. All are related, my lord, all intersect, my lord, because all the 3 disputes pertain to the very same properties, very same parties, very same family, my lord. Now, my lord, I filed an application under section 10. In the section 10 CPC, my lord, saying that, see, since the first suit is already pending in 2007, this has to be
In
stayed.
which suit you have filed the IA?
In the subsequent suits, in 2009 suit and 2013 suit. That is this suit, not which is before my lords.
You filed the IA
I filed an IA
to
under
stay the
section
proceedings
10.
in 2007 suit.
2013 suit, because the subsequent suits. Subsequent suits. So 2013, my lords, may kindly come to page 74. There's an order passed on my section 10 application staying all further proceedings.
This is dated 18th March.
18th March 2025. After that, my lord, it only says await orders, await
March
orders.
2025 and
2025.
OS number 2784
Please.
of 2013.
Please. My lords, may kindly see the operative portion at page, my lord, 81, my lord.
I am filed with defendant number under section by invoking the further proceedings of the present suit state till disposal of OS number 25917.
That is pending consideration. Now on 19/6/2026, an application is filed by the plaintiff before this very same, before the honorable trial court in this suit, my lord, with the state seeking for injunction. Honorable trial court, my lord, takes the application, pass an order of injunction saying I'm not supposed to put up construction of suit with the state.
Come to that.
My lords, may kindly see annexure A, page 22. 1 line order, my lord. We apprise the honorable court saying that this has already been stayed on 18/3/2025. Either way, that's the first contention. Second contention, I'm on record without taking my objections on record. Orders passed. Page 22, my lords, were to kindly see. Let there be no construction of the suit property.
Where is the order?
My lord, page 22. I've sought for dispensation of the order because it's an online order. 22, my lord. That is the order. That's it. No reasons, nothing. 22, my lords, has been the daily order. Same suit.
Have you verified there is no separate order?
No separate order. This is the only order. Nothing else. Till me filing objections.
How can the court do like this?
Not that is why, my lord, I was shocked.
Take this copy, take a Xerox of this and Xerox of this order, page 74. Take that.
The first part is it stayed. Second part is, my lord, no reasons at all and without me filing objections.
This entire order, take a copy of it, and this also. The petitioner is before this court, agreed with the order dated 19/6/2026, passed in IA 1 of 2026, LOS number
2784,
2784 of
2013.
2013. Then counsel for the petitioner submits that between the parties, 3 suits are pending, that is OS number,
I'll just tell minutes. 25917 of 2007.
it must be there, no?
It's
OS
there.
number 25917 of 2007,
7095 2009.
7095
of 2009
of 2009,
and 2784.
2784 of 2013.
Please.
Then the petitioner has filed IA number 1 of 24 in OS number 2784 of 2013, seeking under section 10 of the CPC, seeking stay of all further proceedings of the suit till disposal of OS number 25917 of 2007, pending before the very same court. By order dated 18th March 2025, the court had allowed the IA number 1 of 2024 and the court had stayed the further proceedings in OS number 25917 2007. Then counsel for the petitioner submits that to the surprise of the petitioner, the court now has entertained an IA 1 of 26 filed under Order 39, Rule 1 and 2 by the plaintiff, and passed an order that there shall not be any construction in the suit property and filing of objections to IA number 1 of 2026 by 24/6/2026. It is submitted that in a suit where the entire proceedings are stayed, the court passes an order ad interim injunction order considering the submission of the learned counsel for the petitioner. There shall be stay of all further proceedings pursuant to the order dated. Or what is the relief you're seeking?
We're not seeking a stay of the order, and because
Stay
the
of
proceedings
stay of the
cannot even go.
operation. Obviously, there shall be stay of operation of the order dated 19/6/2026 till the next date of hearing.
Even further proceedings, there may be a line, because if this was entertained, Manoj, God knows what else will be entertained, because nothing can proceed. Section 10 has already been allowed. Nothing
That's
can
what
proceed.
I said. You said you're
No,
all.
Manoj, I've sought for the order, because let that be clear, Manoj,
There
because
will be stay of all further proceedings pursuant to the order. Sorry.
please, grateful, Manoj.
There shall be stay of all further proceedings in the suit. OS number.
Stay of the order as well as the suit, because I don't want to take a chance.
Yes.
Please, grateful, Manoj.
There shall be stay of all further proceedings in OS number so and so, including the pursuant to the order dated so and so.
Please, grateful, Manoj.
Notice.
You both send it to me and send it to the chambers and ask R&S to come. Notice to the respondents.
Cell number 21. 21, Bhuvan KP.
My lord,
Sir,
kindly pass out from yesterday to today regarding a 23(3)A. From yesterday to today has been, my colleague is held up in CCH.
22.
Pass so much.
22. P. Nataraju.
Defendant, my lord, has filed the application under Order 7, Rule 11 to reject.
This is a suit for?
Suit for partition and separate possession, filed by the second wife and children during the lifetime of the first wife. Therefore, my lord, suit for partition is not, they are not.
Did they say about this first wife, second wife?
Yes, my lord. Yes, Lordship may kindly see it. Plaint itself, my lord, they are stated.
Let's see.
Page 15, my lord. It is submitted that one deceased Timagoda has two wives.
Page number?
Page number 15, para 2. We submitted one deceased Timagoda has two wives. They are the first wife Ningama, who is the first dependent, and second wife Shantama, who is the first plaintiff. This Timagoda has 3 children through his first wife, Ningama. They are S.T. Uchegoda, Uma Devi, and S.T. Nagaraju, who are the dependents 4 to 4 in the above case. Like that, through second wife, Shantama has got 3 children. They are S.T.
Tayama, ST Sushila and ST Pavitra. They are the plaintiff number 2 to 4 in the above case. In this way, Thimagoda died leaving behind the plaintiff and defendant.
Thimagoda is the husband.
Yes, ma'am. Thimagoda is no more now.
No more now. He has two wives.
He has two
No,
wives.
the second wife and the children have filed this suit
Filed this
for.
one. In fact, my lord, 29 guntas of land was also given to them. So lordship may kindly say, think piece. Para in the
No,
same.
no, now come to the order. I understand. Come to the order.
My lord, order, my lord. My lord, in the para, relevant, my lord, in page 12, my lord, para 10. What is the observation of the trial court, my lord? This court carefully gone through the rival pleadings carefully. Plaintiff filed this suit for the relief of partition and separate portion of their share. This court has carefully gone through the plaint amendments. It is settled that in order to reject the plaint, court has to consider the amendments in plaint only, and no written statement or defense taken. But in this case, defendant our content, the plaint to be rejected as partition is already heard. This aspect needs.
Is it your case that because there is already a partition?
There are two grounds. One, they are the second wife and children. There is already a oral partition. In fact, in the plaint, they admit that my lord, 29 kuntas of land given to them.
So that is, the court was right on that aspect.
Yes.
Because what you say in the written statement cannot be the ground.
No, my lord, in the plaint itself, they stated.
No. About a oral partition that you are pleading.
Yes, my lord, that is
It is
there,
not
my
there
lord.
in the plaint.
That is not there, my lord. Because, my lord, they are the second wife and children, my lord, they are entitled for that. They are not the co-partitioners, my lord. They are entitled only for the notional partition if they are.
They're only?
My lord, if they are entitled, my lord, it's only a notional partition in the shares of Thimagoda. My lord, in this case,
that
my
will
lord,
be decided by the court, and whatever they are
in fact, my
entitled,
lord,
the court
they
has to give it.
themselves admit, my lord, they have got 29 guntas of land.
No, if that is sufficient or some more is required, that the court will decide.
My lord, in fact, if there is already admission by the defendants, my lord.
No, about this aspect. What is this? It is, in this case, defendant number 1 to 4 contended the plaintiff is rejected as partition already held. This is not accepted by them. This is your case.
In the plaint number 4, paragraph number 4, my lord, in the plaint, they say that my lord, 29 guntas of land was given to them.
And according to them, they are entitled for some more. That has to be a matter of trial. Please.
Your lordship may kindly see, even my lord, there is only, according to the plaintiff herself, my lord, the defendants have got 151 guntas. They are entitled, my lord, notional partition is much more than the share allowed, available to them, my lord. That's why that is the contention of the plaintiff.
These are all about the merits and the maintainability. Merit not on the maintainability, on the merits. The present writ petition is filed. Agreed with the order passed in IA number 4. IA number 4. Invoice number 191 of 2023 dated 3rd November 2025 by the second edition senior civil judge JMFC Mandya. The defendant is before this court. The respondent herein has filed a suit for partition. In that, the petitioner herein, there was a defendant has filed IA under Order 7 Rule 11 seeking rejection of the plaint, that the second wife and the children are not entitled for partition. Already there is an earlier partition, and as such the present suit is not maintainable. The court by order impugned had dismissed the said IA. Next part. While rejecting the IA, the court has observed that the court has carefully gone through the plaint averments. It is settled law that in order to reject the plaint, court has to consider the averments of the plaint only, and no written statement or defense taken by defendant. In this case, defendant number 1 to 4 contend that the plaintiff is to be rejected. Plaint has to be rejected as per partition already held. The aspect needs evidence. In this case, court has not found any material to reject the plaint and accordingly dismissed. Next parallel, and counsel appearing with the petitioner submits that already in a oral partition 29 guntas.
Yes.
29 guntas is given to the respondent. There was an earlier partition. The children of a second wife, the second wife and the children are not entitled for, they can't be treated as a co-partners. And on this ground that the suit is not maintainable and the same has to be rejected. This aspect was not considered by the court. Next part. Having heard the counsel for the petitioner, there is a material on record. The suit is for partition. It is an admitted fact that the plaintiffs are the second wife and children of the deceased, and they're seeking partition of the property. The court has rightly held that while rejecting the application under Order 7 Rule 11, while considering an application Order 7 Rule 11, court can consider the plaint amendments, but not the statement that are made along with the written statement. The written statement, according to the respondent, there is a oral partition. The court has held that do not find place in the plaint. Then coming to whether the plaintiff is entitled for the 29 guntas or more than that has to be, or whether she's entitled at all, the plaintiffs are entitled at all or not. It has to be decided by way of after a full-fledged trial, but not at this stage. And the court has rightly dismissed, or this court finds no reason to dismiss.
Serial number 23.
But my apologies, ma'am. Just one request, ma'am. The matter serial number 20 is tomorrow. It may be uploaded today if possible, ma'am. Please, grateful, ma'am.
Yes, to be uploaded today, that's all. Yes, 23.
23, Mahesh BJ.
My lord, revision petition by defendants 2 to 3 minutes. Suit is for partition. My aunts have filed this against us after the death of my father. My father and plaintiff, the original plaintiff, for the brother and sisters. But the suit is for partition. In the plaint, they simply say properties are all joint family properties. There is no earlier partition. We are entitled for a share. But we have filed a written statement. Of course, my lord, the contents of written statement cannot be gone into. But a fact that, my lord, there is a registered partition of the year 26/8/2003.
Whose case is that?
All these parties, these persons, the plaintiffs are also parties to that partition.
No, that is whose case? Your case or their case?
No, it is my case,
But
and
how
they
can
don't
they
dispute
look into?
that. That's true, my lord. In the written statement, my lord, your lordship may kindly say, I can understand if their suit is for on the assertion that there is an unequal partition and partition is not acted upon. That is not the case, my lord.
No, let's not go into all that. You yourself have said, while looking at while considering application Order 7 to 11, except the plaint and the documents filed along with the plaint,
that's true,
court cannot look into other things.
Yes, ma'am.
You are relying on a registered partition date.
Yes, ma'am.
And that is not part of the plaint or the plaint
That is,
document.
they are convenient. That is what, my
To be
lord.
decided by the
That
court.
is what, my lord, the lordship, the Supreme Court has said.
What can't be done directly
Correct.
cannot be done indirectly also.
But my lord, this is a case, my lord, classic example where not a clever drafting. It is. I don't say it is a clever drafting, my lord. It is an abuse of process of law, because I can understand, my lord, if they admit yes, there was a partition, but it was unequal. We are not given proper share. I can understand if they
come to the court with suppression of facts, that will be dealt with by the court during the course of trial, and basing on that the
No,
judgment will be
apart from
passed.
that, my lord, if my lord, there is a registered partition prior to 2012-2004, but it is the daughters who are claiming partition.
How will the court come to know about that?
No, my lord, I have produced. No,
And according to you, should be
That's
looked
true, my
into.
lord. I can understand, my lord, if a document is disputed, existence of a document is
Not even
disputed.
disputed.
Statement of objections filed by the plaintiff to my application. That is their pleading. Statement of objections filed to the application under Order 7 Rule 11. They don't dispute the existence of the registered partition of the year 26/8/2003. But if they admit the existence, unless in the form as it is, my lord, your lordship may kindly see the plain. I do understand, my lord, when it comes to 7 Rule 11, that too in case where, my lord, an abuse is made where a registered document is sought to be given a go by. They have disowned the document for which they are the parties. Your lordship may kindly say for amendment, page 28. I will stop, my lord, by saying
Still,
this.
we cannot consider.
Page
Just
28,
because
my
they have not denied it. Then where is a document before the court to see that whether what
It was, my lord. The court has looked into the document. Your lordship may kindly see for a moment. Even, my lord, the court has also
Your Lordship,
I'm just hearing this matter for your satisfaction.
2 points I will, my Lord, I
Yes.
will stop it, my Lord.
Yes.
Page 19, my Lord.
Yes,
It is a court finding, my Lord. It is not the contention of the parties.
yes.
Further reading the registered partition deed, the defendants have agreed to pay rupees 2 lakhs cash to each.
Where are you reading? Page number?
Page 19, my Lord. In page 9 of the order.
Hmm.
Further reading the registered partition, the defendants have agreed to pay rupees 2 lakhs cash to each Srimati
How
Pittulingamma
can the court record a finding also on this?
and Srimati Boramma because
This itself is wrong.
no, because they don't dispute the existence of the registered partition deed. No, this is only this I can understand, my Lord. If my contention was with respect to a oral partition which is acted upon, it is a matter of trial. But if it is a registered document and no relief is sought for to annul the said document, and if it is produced and it is not disputed by the plaintiffs in the state.
You please place one law on this, one citation, one precedent on this, that this kind of contentions can be considered.
Not that.
It's just waste of
The
time.
judgment,
Let's
my
not.
Lord.
It can't be, it can't be. First of all,
But
considering.
when, my Lord, my Lord, if your Lordship, my Lord, for a moment feels that this is a case, plaintiffs have intentionally suppressed a material fact, that is the execution of a registered document, then that itself, my Lord,
At this stage, this will not give, the court will not give any finding on that. For the reason, the trial court ought not to have considered the document that is filed by you. It should have not been part of this order. That itself is wrong. That is the wrong committed by the court. And and now this court will not perpetuate this by saying that something is, like, they have suppressed that fact. I will
No,
not
it is a clear
observe.
suppression, my Lord.
Because
It is a
that-
register, in the statement of, I can understand, my Lord, in the statement of objections, if they say there is no such document.
I will record all your contentions, but in spite of that, I have to dismiss the writ petition. Please come. Agreed with the orders passed in I number 1. And what is I number 1 and 2?
IA 1 is, my Lord, the order 39 rule on it. Both the applications were
So we know
simultaneously
what is
taken.
this I?
Nah, this revision is only as against IA number 2, my Lord.
I agree
7
with
rule
the
11.
orders passed in I number 2. In OS number 362 of 2023, dated 14 January 2026, the defendant is before this court. The respondent herein has filed a suit for partition. In that, the defendants have come up with this application under Order 7 Rule 11, stating that there was an earlier registered partition, and the said fact is suppressed by the plaintiff and filed the instant suit, and the suit is not, and the suit has to be rejected. That came to be dismissed by order impure. Next one, the trial court, while dismissing the application, observed that
But observation with respect to this application, my Lord,
21 paragraph.
paragraph 21, my Lord.
Yes. That the court has observed that the plaintiff filed the suit for partition of ancestral properties. The partition deed dated 26/8/2003 is acted or not could be decided at trial. Under the circumstances, it is possible to say that the suit for partition is entertainable. Now the kata of the suit schedule properties is transferred in the name of defendant number 1 to 4. The defendants did not produce the mutation register extracts based on which they claim their, what is this order of the court?
But that is what, my Lord, even one stretch, my Lord, it says it requires, it is a matter of trial. Now virtually court has proceeded to give a
This order.
finding on merits.
Copy of this order also, please send to the chamber. And this, the entire order copy, please send. Kata of the suit schedule property is transferred in the name of defendant 1 to 4. The defendant did not produce a mutation register. So if you produce, the court will see. The defendants did not produce a mutation register extracts based on which they claim their absolute right over the suit schedule properties. The contention taken in their application filed under Order 7 Rule 11D is evident that they have refused to effect partition to the plaintiffs and also deny the rights of the plaintiffs as suit schedule properties. Until the share is determined, the nature of properties must be protected. Does it
But
is
it does
proper?
it does not say why 7 rule 11 does not attract. It is not 7. It says it is virtually a continuation of the order on order 39 rule 1 and 2. Specifically why 7 rule 11 is not maintainable
Accordingly,
is
the
not
court
stated.
has dismissed the IA. When counsel appearing for the petitioner submits that the court has failed to give specific findings. It is a case that he has filed the written statement and he has mentioned about the registered partition date. And when the petitioner has filed IA under order 7 rule 11, he has stated all these aspects. And the plaintiffs, when they have filed objections to that, they have not denied the partition date, registered partition date. It is submitted that it is a registered document and nobody can deny the same. And particularly in this case, by filing objections, the respondents have not denied. In those circumstances, it's a classic case of abuse of process and a clever drafting. And the court ought to have considered the application under order 7 rule 11 and rejected the plaint. Next para, having heard the counsels on either side, peruse the material on record. The court What is point number 4?
Point number 4, my lord, it is at page
What
6,
kind
in
of
page
order?
6. If not, whether the defendant number 1 and 2 make out sufficient cause to reject the plaint under order 7 rule 11 D of
Counsel
surplus.
the petitioner, peruse the material on the record. When an application is filed under order 7 rule 11, it is settled law that the court will only look at the plaint and the documents filed along with the plaint. The court will not consider any other material than this. The defendant has to make out from the plaint averments and the documents filed in support of that the suit is liable to be rejected in the light of the provisions under order 7 rule 11. In this case, the court observes that the kata of the suit scheduled property is transferred in the name of defendant 1 to 4 and the defendant did not produce a mutation register extract. If the petitioner, even if the defendant produces a mutation extract, the court is not empowered to look at the document. When the IA is filed under order 7 rule 11, the court has to record the reasons from the averments in the plaint, whether the defendant could establish a case for rejection of plaint. Unfortunately, the order does not disclose the same. This court has considered the submissions of the learned counsel. The entire contentions are based upon the defendant's written statement and the documents that are filed along with it. In the light of the settled law, the court cannot look into that document, the petition, that even if however strong the defendants have a case, but that cannot be a ground to reject a plaint under order 7 to 11 unless the same is demonstrated from the plaint and the documents filed along with the plaint. In that view of the matter, this court do not find any reasons to interfere with the order impugned. However, it is made clear that the trial court shall be careful in passing orders on an order 7 to 11 by giving cogent reasons and not the manner in which it is dealt with in the present case. A copy of this order shall be sent to the learned judge. The registrar is directed to send a copy of this order to the learned judge. Accordingly, it is.
Observation shall not come in the way of merits of the case.
No, this court has not expressed anything on the merits of the matter. Whatever the observations are that are made, that are only for the limited purpose of considering this application, and that shall not be construed as an expression of this court. If it is not complied, it will not come. If it complied, then only it will come. That's why I said. Yes.
24, Abhinay Vaiti.
For petitioners
number
in this case,
24.
my lords, we have to produce a plain copy by making a
Does this
separate.
matter in the month of September?
My lords, kindly in next week, my lords. My
number
lords, kindly
20.
pass over the matters,
Pass.
please.
Yes.
Cell number 25, urgent, 26. Cell number 26, Kiran V. Ron.
My lord, we are relying on one sale, agreement of sale, my lord, which is in Kannada. My apologies, I'll file a translated copy if it can be
Why
had
is
on
it
Monday.
relevant?
My lord, it's a suit for specific performance of this agreement of sale of 2013. So the terms of the
That
agreement,
you can tell the court, not necessary that you should file a translated copy.
the terms of the agreement would be.
You can tell the court, you can read it.
Monday, my lord, a translated
Monday it
copy.
won't come. If it is adjourned today, it will come only in the month of August or September. So if you are ready to argue, argue today, or else I'll post it in the month of August.
Kindly pass on, my lord.
Yes, right.
27, Mohammad Zabiullah Khan.
Plus, the suit is filed seeking reliefs of declaratory nature and permanent injunction order, my lords. I am the defendant number 5. I file an application under Order 7 Rule 11D stating that the subject matter of the suit revolves around Section 92 of the Code of Civil Procedure, and that it is the principal district judge, court of the principal district judge, that is to try the suit, and it is not for the civil courts, my lord. My application is rejected, my lord. So I
No, please
orders
come to the plaint. Where is the prayer?
plaint, my lord. Plaints, my lord, starts from page 66. Prayer at page 75, my
What
lord.
happened to this? Yes. Page
Prayer at page 75.
75.
Prayer for reliefs. Plaintiff prays that this honorable court be pleased to pass the judgment and decree in favor of the plaintiff and against the defendants, to declare that the plaintiff institution is entitled to administer the goddess Vidhi Nagaradamma temple.
I've seen. Then please come to your IA.
Yes, my lord. Page 44, my lord. Page 44, it starts. Very specifically, I have mentioned in page 60.
Page 6. Your affidavit itself runs into these many pages.
Yes, my lord. So, written statement, I have converted it into
Paragraph?
paragraph 36, my lord. I am advised to.
What will happen is by filing these kind of lengthy affidavits, the crux of what you want to say will go with all repetition of.
Yes, my lord.
Probably that's why the court has not understood your objection.
My lord, the court has reproduced section 92.
I'm advised that. Read para 36.
Lord, I am advised that this honorable court does not have the jurisdiction to entertain and adjudicate the present suit, and the same is liable to be rejected under Order 7 Rule 11 of the Code of Civil Procedure. The subject matter of the suit pertains to the management, administration, and conduct of affairs of the temple and religious institution, which is admittedly a public religious charitable endowment. Therefore, Section 92 of CPC is a special provision that deals with the public charities and
Yes.
expressly confers exclusive jurisdiction.
Please come to the order.
Order page 30, my lord. Starts from page 30. Reasons page 37, my lords. Page 37, 2 paragraphs are reproduced. One that of the plaintiff's contention, one that of the defendants.
Come to para 14.
Para?
14.
Para 14, please, my lords. The above suit is filed by the plaintiff against the defendants for the relief of declaration by declaring that the plaintiff institution is entitled to administer the goddess Vidhi Nagaradamma temple and its assets situated in the plaint schedule property, and for permanent injunction, restraining the defendants, their agents, servants, or their family members from interfering with the plaintiff's institutional activities of goddess Vidhi Nagaradamma temple situated in the plaint schedule property. As could be seen from the prayer, it can be said that the suit is with regard to administration of the goddess Vidhi Nagaradamma temple and its assets, my lords. This is the entire crux.
Who is the plaintiff?
The plaintiff is one trust.
It's a trust.
It's a trust. It's a registered trust, my lords, admittedly. But we are the successors in interest of one deity, that is goddess Maramma, that was translocated by the Maharaja, and my family members have been doing all the pujas there, my lords. This is a trust that is created. It's a kind of a bogus trust that has no role to play.
On perusal of the plaint, it can be seen that nowhere there is a mention about or what with regard to management or conduct of the trust or settling scheme or accounts on inquiries of the temple trust.
My lords,
At page para 15 is the observation. Para 15 of the order, it
Yes, my lord.
says on from the bottom about 6 lines.
Yes, my lords.
On perusal of the plaint, it can be seen that nowhere there is a mention about or with regard to management or conduct of the trust or settling scheme or accounts.
This is my contention, my lords. This is my contention.
Your contention that is not there in the plaint, that's what is the observation of the court.
But the prayer is very specific, my lords.
Under such circumstances, the contention of the defendant and plaintiff suit fall within the scope of section 92.
Cannot be taken into consideration is what the court says. But the prayer is very specific.
It is not seeking for any scheme for the administration.
It's not correct, my lords. This is the gray area, my lords. This is, I may be permitted to read section 92.
Here it is there, extracted at page 38.
Page 38, it is there, my lords. I'll read that. Page 38, that is public charities, my lords. In the cause of any alleged breach of any express or constructive trust created for public purposes of a charitable or religious nature, or where the direction of the court is deemed necessary for the administration of such trust. The question that I am canvassing here, my lords, is with respect to the jurisdiction of the civil court.
The jurisdiction of the court will come provided it is suit under section 92.
Yes.
It according to the plaintiff, it is not a suit under 92.
It is not. It is not,
Now we will
according to the
examine
plaintiff.
whether it will fall under 92.
It does fall under 92, my lords.
Which portion of 92 it will fall? Read.
Administration, my lords. Necessary for the administration of such trust.
Yeah, that is not what they are.
I'll read the prayer once, my lords.
Yes.
To declare that the plaintiff institution is entitled to administer the goddess within Nagaradamma temple and its assets situated in the plaint schedule property. B is issue permanent injunction order against the defendants, their agents, servants, or so and so.
So it is not a dispute within the members of the trust, or it is not a suit that is filed by a person saying that the mismanagement of the trust.
Yes.
Now the trust is filing a suit for injunction against somebody who is interfering.
But that comes under, my lords, section 92 only is my humble submission. 92H, granting such further or other reliefs as the nature of the case may require.
Come to that again. What it starts, it says in the case of any alleged breach of any express or constructive trust
Yes,
created for public purpose of a charitable
or
nature,
religious
where
nature.
the direction of the court is deemed necessary for if you file a suit, saying
I have
that-
filed a mispetition, my lords.
That's a different one. Now, as far as if a suit is filed by you saying that there is mismanagement in the trust, there has to be some administrator has to be appointed.
Yes.
Or something has to be done, then it will come under 90. A trust, there is nothing, no problem with the trust. They say somebody else is interfering.
Yes, my lords.
You have nothing to do. A third person who is interfering with the trust, it's a suit for injunction. Why it will come under 92?
With the scheme of the act, the section says that.
Notice to the respondent.
Respondents number 11 to 16 may be dispensed with. I'll
Memo
file a memo
specifying
to that.
dispensation of notice to 11 to 16, dispense with at the risk of appellant. Notice to the other respondents. Yes.
Number 28.
Readful, my lords.
28.
Yes, 28.
Petition, my lords, it's a different number 2 petition. It's a suit for declaration and injunction, my lords. Declaration of a sale deed dated 6/7/2020. My lords, the imprint order, my lords, is at Annexure A, page 13. My lords, the factual outset is this, my lords. I am, my lords, the plaintiff in another suit, where, my lords, I entered into an agreement for specific performance with the mother of plaintiff number 1 in this suit. Now, my lords, they did not perform their contract, my lords. Thereafter, my lords, I instituted a suit. 10 lakhs was paid in advance. They settled the matter, saying that, my lords, during the pendency of the suit, they sold the property to the defendant number 2 in this suit. So my lords, may I take my lords to the compromise petition that would make everything clear. Page my lords, 43. 44 would be the relevant paragraphs. May I read my lords? That the third defendant in the meanwhile having sold attained majority pending litigation have sold the above lands in favor of one Krishna Shetty, who is the defendant number 2 in my suit, defendant number 1 in my suit, under the registered sale dated so and so, and as such said Krishna Shetty is now in possession of the plaint properties with Khate and RTC changed in his name. Though the above sale deed does not bind the plaintiff, Krishna Shetty having come forward with the offer to refund the plaintiff monies paid by him as advance and persuading the plaintiff to get his claim settled, has not pressed for specific performance. After discussion, subject to plaintiff being properly compensated in this behalf by refund of this sum, all sums due under the agreement, plaintiff agreed not to press the claim against the defendant, subject to further defendants not pressing their contentions as well. So the sale deed was part of this compromise petition. Now, Malats, what they do, Malats, they file a fresh suit seeking for declaring the sale deed as null, void, and not binding.
What was the compromise? That is no more in existence then.
No, Malats, we got compromised.
No, you got compromised.
Please, Malats.
In the suit,
Please, Malats.
whatever the advance money you have paid, that
Please,
is
Malats.
returned. And you will not be pressing on that. That is no more existing.
No, Malats, what has happened, Malats, if that sale deed gets, I mean, the suit gets, if it gets null and void and declared not binding, then Malats, my compromise will get frustrated, Malats. Because Malats, the amount that was
When
paid,
was the compromise?
Malats, the compromise, Malats, was on 18/12/21.
18/12/21.
Please, Malats.
And when was the next suit filed?
The next suit was filed subsequent thereafter.
No, have they paid your 10 lakhs or not?
The person to whom they sold paid me my 10 lakhs. Now they are seeking for cancellation against him. So in turn, my rights will be affected. Now he will come again. I'll be drawn into unnecessary litigation. Now there is also one more aspect, my lords.
No, you please tell me.
Please, my lords.
What is the consequences of this compromise?
Now, my lords, the consequence of this compromise, my lords, the defendant number 1 got his property, my lords. I was paid back my refund amount. Now they are seeking for cancellation of this sale deed. Now, my lords, the defendant number 1 will be behind me, dragging me into litigation.
You filed a suit for specific performance.
Please, my lords.
D1 has executed an agreement of sale in your favor.
Please, my lords.
What happened to D2? D2, you sold the property to D2.
No, my lords. The D1 sold the property to the mother of the plaintiff.
So forget about that. D1 is in your suit for specific performance.
I have no relation with D1 and D2. The D1 out, he was not a party in the old suit. He gave me my 10 lakh rupee refund so that because he purchased the property in the pendency of that suit.
Suit for specific performance is between who?
Between me and the family of the plaintiffs. The D1 is nowhere party in that suit. He entered only during the compromise.
So you filed a suit for specific performance.
Please.
They have paid you, they have refunded the money which you have received.
The D1 refunded the money.
Then what should happen to that agreement?
Number he refunded that money on the strength of a sale deed that they have taken place because the property was sold.
Please find out. Please come to that.
Please, Milats. Let's should I go to the impugned order, Milats?
No, compromise.
Compromise, please, Milats. I'll come from the first, Milats, page 43. The first defendant, having inherited plaint A scheduled property from her father under will dated 9/4/2007, having acquired absolute title thereto, offering to sell plot, had received 10 lakhs from plaintiff as advance purchase price, and for above purchase entered into an agreement for sale thereto plaintiff under agreement of sale dated 9/4/2015. For rupees 43 lakhs, subject to terms and conditions covenanted therein, and she failed to comply with the demand of specific performance per terms thereof. But in meanwhile, settled properties to minor third defendant represented by guardian.
1, 2, look at the cost title.
Please,
about
Malats.
that. 1, 2, 3, 4. Who are there?
Malats, defendant number 1 with whom I entered into agreement.
Yes.
Defendant number 2 is the husband. Defendant number 3 is the minor daughter. During the pendency of proceedings, she transferred the title into her name. The minor daughter sold it to the D1 in this suit. Now, during the pendency of proceedings, when I got to know that the property was sold, they entered into a compromise with me, stating that we have sold the property to D1 in this suit, and he is going to repay you 10 lakhs. This is my advance amount. I accepted. All 4 parties signed the compromise decree. Now, what they did, Malats, after 3 years, they institute another suit, seeking for.
Who are you concerned?
Now, my lords, if the sale deed goes, is declared as null and void,
But that is between them.
now, my lords, then he'll come.
No, no, why will he come to you? That is your, by way of a compromise, they have, they said you just take 10 lakhs and you have nothing to do, you are happy with it, you went off. Money is paid to you.
But the,
Now, basing on this compromise, the D1 and these defendants and the one who has purchased, they will fight.
now what has happened, my lords? They filed a plaint. They have taken contention that we both have colluded. And there's also one more aspect, my lords.
If
They are
they
the
say that you are colluded, that has to decided by, that has to be decided by the court.
Now, my lords, there's also one more aspect. The executants themselves are seeking for declarations cancel null and void. Under 35, they have to seek for cancellation.
No, why are you concerned? You are not in the picture at all.
My lords, there is a direct allegation on that's loitering over my head.
Allegations have to be decided during the course of the trial. Please come. Agreed with the order. Passed it. I number 9 in OS number 15 of 2023.
Let's may I make, I'm sorry, let's order 23 rule 3A, my lords, to overcome that bar of challenging the compromise petition, they have only challenged the sale deed because the sale deed forms part of the compromise. Order 23 rule 3A, it bars the suit for against any compromise, my lords. It's a case of clever drafting.
You have no grievance at all that he will take care. Your the person who is affected by that, you are not affected by it. You got your money, you are out of it.
Let's at least
You
I'll
have no
take a
cause of
chance, my lords,
action.
notice.
Huh?
If I may at least ask for notice, my lords, I'll take a chance.
Notice the respondents.
Case number 29. Banu Prasad, K for petitioner.
For responding in this case.
Suit is one for partition in separate possession. May I just take your lordship to the plaint, relief sought in the plaint.
Now, what are the grounds for rejection?
I have filed this application order 7 to 11 on the ground that the suit does not disclose any cause of action, maintainability of the suit. Also, there is a specific bar under order 23 rule 3A. These are the grounds I have urged in my application. May I just take your lordship to page number 31, that is the plaint in OS 5176 of 2022.
Yes.
Page number 39.
No, I have to hear it finally.
Please,
I'll
my
hear it in the afternoon.
Can it be taken on Thursday, my lord?
Thursday.
Please,
List on Thursday.
Please.
Because I have to finally pass orders.
please.
First list on Thursday.
Yes. Case number 30.
First list, end of the list. It's 30.
Case number 30.
I prefer the
Unless
petitioner, my
Yes,
lord.
both of you are there. I will hear finally when? Today in the afternoon or some other day?
Today afternoon.
Afternoon? Yes, afternoon.
case number 31.
Pass over. Yes.
Appear for the petitioner, my lord. Lord, ejectment
Mr.
decree
Gunath.
is passed. I am the tenant revision petition before my lord.
What is the amount?
My lord, ejectment.
Only
Eviction.
ejectment. No.
Only.
What is wrong with this?
Lord, my contention is there is no relationship of landlord and tenant between myself and the respondent. I have further pleaded that my father is a tenant under the mother of the respondent. There is a lease agreement and I have produced that lease agreement also. Trial court ignores that lease agreement and holds that there is relationship of landlord and tenant and
When was
passes
this
an
order
order.
passed?
Lord, the order passed on 28/4, please. 30 days time is granted to me to vacate and hand over possession.
There exists a relationship of
That is what the trial
landlord
court,
and tenant between the plaintiff and defendant. The plaintiff has proved the termination of tenancy in respect of suit B premises.
One aspect the court did not notice is PW1 himself deposes that the document under which he claims title is executed for the namesake by his mother. In spite of that admission.
But there is a document. Registered
Certainly.
document.
There is a document,
Whatever it is.
certainly. He himself admits it is for the namesake.
So why should we stay this now?
Not till the other side comes, let me have the benefit of being in possession of the property. We can settle the issue at least, please, my lord. If he is interested to extend the
Shall I
lease.
record that?
I
Counsel for
extend the lease, my lord, not extend the time to vacate, please. My lord
No,
can
then
record.
counsel for the petitioner submits that they want to compromise this matter with the respondent.
Please, I have no
Respondent,
issue.
considering the submission, notice to respondent, petition is notice to respondent, till the next date of hearing. There shall be stay of all further proceedings pursuant to the order dated.
Much obliged.
Till number 32. Consider MR.
Appear for the petitioner.
Report received. What is this?
Minutes. This is the case where the trial court is adjourning the matter.
For the petition submitters, Marshal, the matter is being adjourned on several occasions. On the request from the date the petition is not appearing for passing it for the convenience of the adjourning the matter. The entire order sheet is placed before the registrar is there to call for the court. Orders are pronounced. That's what the
Happened on 7/2/26. Their impleading application order was passed on that IA even without hearing them, impleading me as a defendant, my lords. Again from 7/2, my lords, 3 chances has been given, my lords. There is specific direction that once the CPC says 14 days is the time within which the amendment should be carried on and amended plaint should be filed, my lords. Lords, it was listed for the trial court on 4/6/2026. I'd like to pass on the order passed on that day.
present petition is filed. Seeking a mandamus directing the principal senior civil judge Bangalore, rural at Bangalore in OS number 942 of 2023 to proceed with the suit strictly in accordance with the provisions of the Code of Civil Procedure Code. And to direct the trial court to consider the plaintiff and to pass appropriate orders. This court on 17/6/2026 has passed an order and recording the contentions of the petitioner and directed the registrar judicial to call for a report in this regard. The report is placed before the court. It is submitted, it is stated in the said report that the court has that the court has pronounced the orders on application. On the day the defendant number 7 appeared to ensure substantial justice, the matter was adjourned to 4/6/2026. 4/6/2026, counsel for the defendant number 7 filed a memo seeking the dismissal of the suit for non-compliance with the amendment order. However, to provide a final fair opportunity to the plaintiff, the court extended the time to 21/7/2026 as a final chance. It is also stated that under Order 6, Rule 18 of the Code of Civil Procedure, if a party fails to amend within the permitted time frame or the statutory 14 days window, the immediate legal consequences is the forfeiture of the right to amend and not the dismissal of the suit. The court extended the time in the interest of justice and to prevent multiplicity of proceedings rather than out of leniency towards the plaintiff. Since the suit cannot be legally dismissed for a mere failure to carry out an amendment, the memo filed by the counsel for the defendant number 7 was properly and lawfully declined. The next paragraph. This court has heard the land counsel petition and also perused the report that is placed before the court. Even as this report, the matter was posted to 6/2026 for carrying out the amendment. And the court, in the report, the learned judge says that it has to be done within 14 days. And the court gave him a reasonable time. The court, for amendment of the amendment to carry out the amendment, 6/2026, the matter was 21/7/2026. This kind of indulgence is not required if the party in a reasonable time is not proceeding the matter. It's for the court to take appropriate steps. In that view of the matter, the writ petition is disposed of, directing the court to proceed with the matters in accordance with law without granting unnecessary adjournments. Takes no notice to the respondent because yes, next.
One submission. Lords, in that there is also a specific prayer telling that under Order 9 Rule A, if the defendant doesn't take steps, then also the court has power to dismiss the suit for 9 Rule 8 is very clear.
Yes.
Lords, the only reason why I filed this was that the bank money of around 35 crores is tied up.
Considering that the respondent is a secured creditor, party is a secured creditor, the court shall adhere to the timeline as per this, as prescribed in the CPC.
Cell number 33, Divakar Kane, petitioner.
My lord, I appear for the petitioner, my lord. In this case, respondents have not entered appearance. Truth will come out if and only if, according to me, they come before the honorable court.
Comply with the office objections. Office objections shall be complied within a week, or else the writ petition shall stand dismissed. Yes, 34.
I may be granted 1 week's time, my lord.
Yes, I have already granted. Yes, 34.
34.
Lord, there is one office objection which says I had to file multiple orders are there. So I had to file a separate WP for
What
each.
are the orders?
My lord, it's arising out of a common issue, my lord. My lord, the application.
What are the orders?
My lord, orders is one on expert opinion which I have filed. I am a defendant. For referring to the FSL. And another application is for perjury. My lord, these two IAs are there from my side. I am a defendant in a eviction suit. My lord, one more application filed by the plaintiff asking for deposit of arrears of rent. All these applications were taken together and passed a common order.
But you have to file they are not consequential to the other.
I have a submission on that.
Yes.
Lord, kindly one judgment.
Not the judgment. There is a circular issued by the High Court. High Court rules. What are the rules we have? You have to follow. Further judgment is not required.
No, my lord, it is arising out of a common issue, my lord.
But
my lord, I have paid the separate court fees.
IA to reopen, those kind of applications, they are different. These are through 3 distinct applications. Just because the court has dealt with by a common order, we cannot. There will be a difficulty while passing orders with these kind of applications. Office objection shall be complied with.
Can it be considered on an urgent basis, my lord? Today is the matter.
If you want, you restrict it to whatever is a prayer you are, I will hear it. out of these IAs, if you are restricting it to one IA, which IA you say, you write it, I will
My lord,
consider
I
that.
will restrict it to application under
Complete all that,
45.
I will hear it in the afternoon.
Please, my lord,
Yes.
please.
Give the file to them.
Because, my lord, the matter is listed today.
That's why, to afternoon I'll hear it. You please, yes, next.
Furniture. Cell number 35.
One
Office
application is,
office objection shall be complied with. However, when counsel for the petitioner submits that, he will comply with the objections and he is restricting this writ petition as far as I number? I number 11, yes. Next.
Cell number 35 P Nataraju.
one IA is, my lord, for attachment of sale of immovable property. Another file, my lord, issue of sale proclamation, my lord.
Two different orders.
Two different orders, my lord. My lord, I will restrict my prayer to IA number 2 only, my lord.
Do that.
The grievance is that, my lord,
I will hear it. Do it in the afternoon, I'll hear. The office has raised objection with regard to the maintainability of the writ petition, seeking different, questioning different IAs. Then counsel for the petitioner submits that he'll restrict his prayer to
IA number 2.
IA number 2. You may, give them the file. I call it in the afternoon.
Cell number 36.
Hearing for the petition in this matter may be passed over, my lord. We have engaged senior counsel in this matter.
No, maintainability of the writ petition, you have challenging more than one IA and single
My lord,
application.
IA number 19, 20 and 21 IA, my lord, for recall and reopen and production of additional document, my lords. Comma order.
Yes.
Kindly
The
pass.
office objection with regard to the maintainability is overruled. Pass over.
And the office has raised the objection with regard to the court fees, my lords. I have filed the necessary court fees.
It is submitted that the necessary court fees is paid. Yes,
Pass over.
pass over.
Cell number 37.
But I'll have it next week.
Amendment petition.
I have filed the additional facts, madam. I permitted to incorporate, madam.
List this matter in the month of August. Yes, next.
38.
IA may be allowed, madam. IA may.
What IA may be?
That
You said you
additional
wanted
fact.
time.
Additional facts, madam. Additional facts I have to.
You wanted time. I granted you time. Yes, 38.
Cell number 38. Delay notice.
Appearing for the petitioner in
Notice.
this.
Cell number
39 notice, 40
Notes.
notice, 41 notice,
42 notice.
42 notice, 43.
Notice has to go on.
Yes, notice, 44,
44. Impleading application notice has to go.
44 notice, notice on IA number 1 of 26. Yes, next.
Hearing cell number 45.
No, what is this IA have to see? Draw notice. No, leave it. 44, no representation. This is matter in the month of August. Yes, next.
Cell number 45.
Yes, 45,
Cell number 45.
no representation. List in the month of August.
Cell number 46.
Yes, 46.
Appealing for the respondents. The challenge is to an IA filed under Order 7. I'm for the plaintiffs before the Learned Commercial Court. 24 suits came to be filed arising out of a JDA. It's a dispute between a landowner and the developer. Developer has sold the landowner's apartments.
Where is the petitioner? You appear for all the respondents?
Not all the respondents, because the rather.
Because there is processes, like in so many cases, they have to notice as issue on R2 and R3.
Please, in this, what has happened is, I am the landowner, he's the developer. I have filed, I'm the plaintiff before.
No, he has an interim order.
He has an interim order. Interim order has been enforced for almost 10 months now.
I'll pass over then.
Please, obliged.
Cell number 47. 47. Harish Kumar MS for petitioner 47.
No representation, does this matter?
I appear for the
Any
respondent.
stay in this?
There is a statement.
State matter? No representation on behalf of the petitioner, list this matter for dismissal tomorrow.
Cell number 20.
Tomorrow in the first list for dismissal. Yes, 48.
48.
No representation, list this matter in the month of September. Is 49.
Cell number 49. GB Narsimurthy.
Same order.
Cell number 50.
Same list in the month of September. 51.
Cell number 51. Nagaraja RC.
Same order.
Cell number 52.
Same order.
Cell number 53.
Password in that.
50?
50th, 50th, kindly password.
Password. Yes, 50.
54,
Yes, this is the month of September.
55. For orders matter.
Office objection shall be complied with within a week or else the writ petition shall stand dismissed. 55. 55.1 process shall be paid within 1 week. That also same. Then 56.
Till number 56. Shriram Timappa Nayak.
No represent. Office objection shall be not office objection. This is no representation listed in the month of September. It's 57.
57. SK Mithun.
Appearing for the respondent, my lord.
Yes.
SK
My
Yes.
lord, on the last day, the petitioner had filed an affidavit with regard to the payment, my lord. This is with regard to the execution petition. There was a affidavit which was filed by the petitioner on the last date. My lord, I'm represented by senior. I request for a short accommodation, my lord.
Is this matter in the month of August? On 6th of August? Yes. 58.
My lord, 58, petitioner, my lord.
Please, my
It's regarding court fee, I have already paid it, sir. 58, my lord.
It is submitted with the
respondent number 1 to 3.
My lord, the last occasion, your lords are directed to serve the other side, my lord, through
Yes,
hand.
sir.
I've served, they've appeared. Seal number 58.
Yes, my lord. I appear for the respondent number 1 to 3.
Yes.
I'm challenging the order under 39, 1 and 2.
39, 1 and 2.
Yes.
I'm challenging the order passed on application under 39.
What
1 and
happened?
2.
Why is it, then you mute that.
He is on record.
Yes.
My lords, I'm challenging 39, 1 and 2, my lords, as against, there's a stay obtained as against my property. I have not been made a party to the proceedings. So a suit for bare injunction, my lords. Bare injunction suit, application is filed not to create charge. The question that involves is, my lords, can the interim prayer go beyond the main prayer? My lords? As suit is for bare injunction. Interim order obtained is not to create charge over the suit schedule. I have not been made a party. I am the purchasers of site.
Password, I'll take it.
Please.
Today, all the passwords call at 2:30 because there's more passwords.
Till number 59. Manjunath BV. 59.
No representation list in the month of September.
Till number 60. Till number 60. Syed Amrullah Khan.
Respondent, ma'am.
Interim order is there.
No interim order and the delivery warrant has been duly executed.
Then comes no representation on behalf of the petitioner. Then comes for the respondent submits. The delivery warrant is already executed. This is matter in the month of September. The 61.
62.
61.
61 is on.
Huh?
Ramesh P. Kulkarni.
Yes.
He appeared for respondent appeared.
Who appears for respondent?
61.
No representation on behalf of both the parties. September. Yes, 62.
Till number 62.
This also same.
Koda.
Yes, same order.
Till number 63. Rajeshwara PN.
Appear for respondent.
64, sir, number.
63.
64.
63. Rajeshwara PN for petitioner.
So this also in the month. Yes, next.
Serial number 64.
On
Madhukar Nani.
64, my lord, what is up, my lord, trial court, my lord, I have filed my lord suit for recovery of my lord the 60 lakhs and that. My lord, there is entire my lord details has been produced in the plaint. My lord, all the transaction is with respect to my lord transferring of the amount by my lord the account as well as my lord the mobile. My lord, the application came to be filed under order 38 rule 5 attachment before judgment. My lord, the court issued a notice, my lord, to respondent by saying that you should furnish, my lord, the security of the, my lord, the claim amount. He did not, my lord, give any security amount. But he goes on, my lord, taking adjournment. He filed, my lord, the return statement by denying the entire amount. My lord, I filed, my lord, 2 memos before the court, brought to the knowledge of the court that, my lord, total, my lord, the property which has been, my lord, he has, my lord, he has to pay, my lord, the amount, total amount, since as per the document itself. My lord, for the purchase of, my lord, the suit schedule property which has been sought for attachment itself, my lord, he purchased that amount out of, my lord, my payment.
Now,
Now,
file, come to the impugned
my
order.
lord, one submission.
Come to the impugned order.
Now, the court, my lord, though, my lord, he has mortgaged the very same property to defendant number 4. Now, court holds that, my lord, ink page number 77. My lord, I may permitted to read out, my lord, only, my lord, the portion of where the court holds. But ink page number 77.
This is small order, we'll read the entire order.
My lord, no, my lord, I will.
No, I
will.
want, I
Okay,
want you to
sorry,
read.
sorry.
Read.
My lord, from the reasons itself.
No, from the reasons itself.
The plaintiff has filed this suit for so and so against for recovery of so and so amount. The defendant number 5 is the Kaveri Gramina Bank. The defendant number 1, 2, 3 have filed the written statement contesting the suit. The plaintiff has filed IA number 1 under order so and so, along with the suit praying to attach the IA schedule property so and so, Bengaluru South Taluk so and so, perused the citation in between the Rajendra so and so and so, my lord, the defendant number 1 to 3 have opposed IA number 1. The plaintiff contended that the defendant number 1 and his wife TL Gayatri borrowed a total amount of 38,30,000 and they have not repaid the amount. The defendant number 1 to 3 denied the claim of the plaintiff. The defendant number 2 and 3 contended that the property sought to be attached before the judgment is an exclusive and absolute property of D2 and D3. Admittedly, the D2 and D3 are not parties to the loan transaction alleged to have been placed on between the plaintiff and defendant 1 and 5. Malad, now, Malad, he, Malad, being a Malad, the legal heirs of Malad deceased. Admittedly, the property sought to be attached before the judgment is mortgaged to the defendant number 5, which is the bank from which the defendant number 1, that is Malad, defendant number 1 and his wife borrowed Malad 30 lakhs by mortgaging the very same property. By mortgaging IA schedule property. Therefore, admittedly, the defendant number 5 is secured creditor in respect of IA schedule property, and therefore the defendant number 5 has preferential right.
Property which you wanted to be attached is already mortgaged to the
That
bank.
is a Malad. I do admit, I am not.
Oh,
Please
not admitting. Please listen to the court.
Please.
When you file an application under Order 3815, that this property, they are going to alienate the property. If that property is not attached, that would cause hardship to you.
Please.
That property is already mortgaged to the bank.
Malad, I am Malad. That is why I made submission before the trial court. At least second charge for attaching the property can be given to me for the reason that Malad, I have sought for prayer in the very same.
Second charge.
But prayers, I have sought in the prayer in the plaint itself that which has been documented, which has been pledged before this court should not be released in favor of Malad, these person, because my total amount is 60 lakhs. Please.
Under the surface proceedings, when the bank is proceeding against them.
But there is no such proceedings. There is no such proceedings.
If the property is mortgaged, if they don't pay the money, they will initiate.
Malad,
If they initiate,
please.
Once they pay the money or the property, they can buy. You cannot compel the bank not to discharge that property. That is altogether a different aspect.
Malad, my submission before the trial court is that Malad, I have sought a prayer until unless my payment has to be Malad, paid by this person.
Come to your right. We'll read
Come
your
to
right. IA
IA,
in
Malad.
support of your application.
Malad, IA ink page number 37.
37 or 83?
38, Malad. 38 is the affidavit.
I state that 1 and 4 are trying to alienate the property in favor of third parties. So the first ground itself is gone. When the property is mortgaged with the bank, how will they alienate the property?
Malad, that is why Malad, I filed a memo. Malad, kindly see Malad. Kindly see Malad, my memo. Malad, ink page number 71. 81, sorry Malad. 81, Annexure J. Malad, I may permitted to read out Malad from last Malad. The plaintiff submits that the plaintiff has filed the application and so attachment to property. However, by the order dated 27/2023 has issued show cause notice to the defendants that why property the defendant should not. Malad, this is the order passed by the court. attached and issue show cause notice to them. However, still so far the defendant did not come forward to this court to furnish any security for the amount in the suit. However, it is noticed by this court that the subject matter of attached suit property is prior mortgage of the Kaveri Gramina Bank. But I have sought only second charge itself, because if he pay the entire amount to the bank, he will sold the entire property. But my entire claim will be become, I cannot in the position to recover that amount unless second charge is to be given to me. I am not denying that the first charge can be, because the total amount of the bank is 30 lakhs, but my amount is more than 60 lakhs. If they are going to pay the amount 30 lakhs, bank will directly release the entire documents to him. He may be sold without giving security before this court. Still passed order on 2023 itself. He did not come before the court by giving the security for the like amount. That is why I filed a memo. At least consider that second charge will be given to me itself. Still that period he should not alienate. Though he may pay.
Are arguing a petition under order 38 rule 5, not under order 39 rule 1 and 2.
Please, ma'am.
Please come. Agreed with the orders passed in. I number 1 under order 38 rule 5.
Now Kata has already been changed in spite of grant.
25/4/2025.
One submission. Before this court, one of the defendant has made undertaken that before this court that is not going to alienate the property. But now the Kata has already been changed.
Where is all this? Why should this court do all that? We are not here on a writ petition to just pass orders like whatever. We are confined with some procedure. First of all, what are the reasons for allowing an application under order 38 rule 5?
Please, ma'am.
That itself is not there in this case.
Though this court can one submission.
On that.
One submission, only one line. If this court holds that I cannot prove under order 38 rule 5 for attachment, at least direction may be given to them to give the security of that loan.
Because that is not part of order 38 rule 5. Yes.
But the court passed an order.
Where is that order you show?
I may permitted to. Please,
That you pursue.
that is why,
No, if that is not happening, pursue that. This order 38 rule 5.
That is why I filed a memo before the court, direct him to give security. The order is that. Where is? The ink page number 71.
Memo will not become an order.
No, this is the order.
Yes, what is the order?
Order, ink page number 71. The defendant number 1.
This is show cause notice.
No, ink page number 71. Ink page number. But this is the order sheet. There is no separate order. This is the order.
I am looking at it. Court has issued notice to the respondents.
No, if the defendant number 1 to 3 failed to show cause the property mentioned in schedule II is hereby attached before the court.
The present order is consequential to this. After this, after appearance of the defendant, the present impugned order is passed. There is no order under order 38 rule 5 in your favor. If that also I have to explain, then
Virtually, the entire.
Dismissed.
But I am not in a position to get at least the amount
Yes,
for
yes.
my security and because at least one submission.
Yes.
But he is already aged about 78, 80 years. Now at least for expedient of the suit
Which year
itself.
is the suit?
But suit is here 2000.
Saying that he was aged. He filed again an application. And now he also
You
filed
can't-
But he is 75 years the first plaintiff.
When is the suit? I'm asking which year?
Suit is 2023,
23 too, so it should be, which court is it?
56
Which court?
The city civil court in the
Civil
Bengaluru
court
itself.
2023. See, suit has to be disposed of expedition.
First plaintiff is aged about 75 years.
Yes.
But at least by considering the senior citizen, the age at least.
May
62 and 63,
Huh?
62 and 63, and for the respondent. By the time I could come from court on 10, the matter is urgent to September. Will not be
62, 63, pass over.
serial number 55, my lords.
PD is ready, my lord. We are supposed to make payment. I want to 7.5 crore TD. It is urgent to August, my lord. Kindly have it tomorrow.
Which matter?
57, madam.
57, pass over.
My lordship, 49, my lord.
whatever the matters that are adjourned, wherever they are asking passwords, give it.
49, my lord.
So even the advocate on wherever they're asking password those matters and call the passwords list first because there are more passwords.
Lordship 62, my lord. Madam, 51, 51.
ಬೇಕಿತ್ತು ಪಾಸ್ವರ್ಡ್ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಡ್ಜರ್ಮೆಂಟ್ ಮಂಡೇ ತಗೊಂಡ್ಬೇಡ
Madam,
ಕಂಟಿನ್ಯೂ ಸರಿ ಮಧ್ಯಾಹ್ನ
ನೀವು ಬನ್ನಿ ಸೀನಿಯರ್
ಪಾಸ್ವರ್ಡ್ ಅಲ್ಲ
ನೀವು ಬನ್ನಿ
ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದು ಬೇಕು ಹೇಳಿ ಒಂದು.
ಹಾ ಮೇಡಮ್
ನಮ್ಮ ಅದೇ ತರ ಕೊಡ್ತಾರ ಅಂತ ಈಗ ನೆಕ್ಸ್ಟ್ ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಕೊಡ್ತಾರ ಕೊಡ್ತಾರಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಸಡನ್ಲಿ ಬ್ಯಾಕ್ ಚೇಂಜ್ ಆಯ್ತು
Madam, serial number 62, madam.
Madam, 49, madam.
ಪಾಸ್ವರ್ಡ್ ಬೇಕಾಗಿರೋದು ಹೇಳ್ಬಿಡಿ.
49, madam.
Serial number
ಆರ್ಡರ್ ಆಗಿರೋದು ಹೇಳ್ಬೇಡಿ, ಆರ್ಡರ್ ಆಗ್ತಲ್ಲ. ಒಂದ್ ನಿಮಿಷ.
ಸೀರಿಯಲ್ ನಂಬರ್ 55.
Madam, 1 second.
ಒಂದ್ ನಿಮಿಷ. ಈಗ 44 ಹೇಳಿ ಆಮೇಲೆ
62.
49 ಒಂದ್ ನಿಮಿಷ ಸೀರಿಯಲ್ ಆಗಿ ಹೇಳಿ. 44 ಆದ್ಮೇಲೆ 49
55.
51 ಆಮೇಲೆ
55.
Madam, 56, madam.
54 56 ಆಮೇಲೆ
Yes, madam. 56.
56 57 ಆಮೇಲೆ
62. 62.
62 ಆಮೇಲೆ ಸರ್ 63 53 ಇದೆಲ್ಲ ಪಾಸ್ ಓವರ್ಸ್ ಮಧ್ಯಾಹ್ನ 2:30 ಕಾಲ್ ಔಟ್ ಆಗುತ್ತೆ.
62.
ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ
ಉಳಿದಿದ್ದೆಲ್ಲ ಹೋಗುತ್ತೆ ಆರ್ಡರ್. ಬೇರೆದೆಲ್ಲ ಹೋಗುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಅಲ್ವಲ್ಲ ಅವು
ಆರ್ಡರ್ ಆಗೋಗಿರುತ್ತೆ ಸರ್. ಇವಾಗ ಯಾಕೆ ಪಾಸ್ ಓವರ್
ನಮ್ದು
ಕೇಳಿದ್ದಾರೆ ಅದನ್ನ
68 ಇದೆ ನಮ್ಮ ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು ಹೇಳಿ
68 ಇನ್ನು ಕಾಲ್ ಔಟ್ ಆಗಿಲ್ಲ. ಅದಿನ್ನು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ಕರೆಯಕ್ಕೆ ಸರ್ 53 ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಆಗೋಗಿದೆ ಸೆಪ್ಟೆಂಬರ್ ಅಂತ. ಇವಾಗ ನಾವು ಯು ಆಸ್ಕ್ 53 ಬೇಡವಾ? These are all the matters will be passed over and will be called in the afternoon. ಅದು ಮಾತ್ರ ಹೇಳಿರೋದು ನಮಗೆ. ಒಂದ್ ನಿಮಿಷ 53 ಬೇಡವಾ?
Court officer? Hello, court officer ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? Hello, court officer? ಮೇಡಮ್ ನಮ್ಗೆ ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಈ ಕಡೆ.
ಸರ್ ಹೇಳಿ, ಏನ್ ಬೇಕು ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 59 ನಲ್ಲಿ ಏನಾಯ್ತು ಮೇಡಮ್?
61 ಕೊಡಪ್ಪ, ಪಾಸ್ ಓವರ್.
59 ಪಾಸ್ ಓವರ್.
59 ಪಾಸ್ ಓವರ್ ಅಂತ ಕೊಡಪ್ಪ. 59 ಕೊಡು, 61 ಕೊಡು. 55 ಪಾಸ್ ಓವರ್. ಆಯ್ತು ಹೇಳಾಯ್ತು. 53 ಎಷ್ಟು ಸರಿ ಕೇಳ್ತೀರಾ? How many times I have to answer to the councils? Everybody repeating and asking. Case ಕರ್ದಾಗ present ಇರಬೇಕು ಇವರದ್ದು. It is your duty. When the case is called, you are not present, and again you are confusing me also. You are also confused yourself.
Court officer? Court officer, ಕೇಳಿಸ್ತಿದೆಯಾ?
court officer. ಮ್ಯೂಟ್ ಆಗಿದೆ, ಕೇಳಿಸ್ತಿಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಸರ್ ಹೇಳಿ, ಏನ್ ಬೇಕು ಹೇಳಿ.
230ಗೆ ಲಿಸ್ಟ್ 2 ತಗೊಂತಾರೆ, ಇಲ್ಲ ಲಿಸ್ಟ್ 1 ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಬಿಡು.
ಸರ್ ಇದು ಲಿಸ್ಟ್ 1 ಇದೆ, ಪಾಸ್ ಓವರ್ಸ್ ಇದೆ, ಎಲ್ಲ ಮುಗಿದ್ಮೇಲೆ ಲಿಸ್ಟ್ 2 ಕ್ರೋನಾಲಾಜಿಕಲಿ ಆ ಪಾಸ್ ಓವರ್ ಮುಗ್ದೋಗ್ಬಿಟ್ರೆ ಲಿಸ್ಟ್ 1 ವಿಲ್ ಕಂಟಿನ್ಯೂ, ದೆನ್
List 2
ಆಫ್ಟರ್ವರ್ಡ್ಸ್
will
ಲಿಸ್ಟ್ 2.
ಓಕೆ ಓಕೆ.
Reasons to follow.
The passwords.
Beg your pardon, my lord.
How can you mention now? What were you doing in the morning? Every day I will not entertain this. Huh?
Maybe posted on 25th.
No, why should I take up mentions at 2:30? That's what I'm asking. Please look at the list. That's a note on the list, in the cause list. No 1:30, 2:30 mentions. Just call the list, call the passwords,
My lord,
call the passwords first.
my lordship, with your permission, my lordship, there is urgency of break lock partially executed, my lordship. It was listed in serial number 62.
All that matters will be called. Did you ask the court officer? Wherever the matters are passed, adjourned, I will take up if you mention.
Serial number 62, 60. Syed Amrullah.
Anyone, no, take up.
Passover matters. List number 1, serial number 16, Leela P, petitioner.
Serial number? Yes. Yes.
Your Lordship, I have challenged the order passed by the trial judge, wherein Your Lordship, the application filed by the respondents, Your Lordship, have been allowed. Your Lordship, they filed an application seeking impleadment on the ground that Your Lordship, they have right over the property. On the basis of the order passed by the Tahsildar. Your Lordship, that Tahsildar order is later on, it has been cancelled, Your Lordship. That order is set aside and
Come to the impugned order.
Please, Your Lordship. Annexure A is the impugned order. And the reference is made at page number 29.
Page number?
Reasons, page number 29. Point number 1. May I read, my lord?
Yes.
Your Lordship, the respondent has acquired the land bearing number so and so for the metro railway project. The impleading applicants have stated that their mother, late Srimati Sharada R. Katare, had entered into a partition.
On what ground you are questioning this order?
Your Lordship, on the ground that because they suppressed before the trial court, saying that Your Lordship, the order passed by the Tahsildar is attained finality. That is not so.
Have you mentioned it in your objections?
Your Lordship, what happened is I did not file objection because this copy of the order, AC order, I got it subsequently in the year 2020.
So as on that day, the order of the court was right. In the light of the subsequent.
Subsequently, because I collected.
You are saying
the
that it is wrong. What is not before the court? What can the court do?
It's because what I would
notice to the respondents. Notice to the respondent. Petition is permitted. Take out handsomens. Once the memo is filed, list the matter. Yes.
Serial number 21. Bhuvan KP.
Yes.
Lord, this matter came from yesterday to today. Lord, whether a third party, my lord, can challenge a compromise.
That you wanted to file, Judge.
Yes, my lord. One judgment I gave, but my lord said it is only one paragraph. There is an earlier judgment, my lord. May I just pass this over? Lord, what this says is, my lord, if the parties are claiming through a person who is a party to the compromise, then you have to go back. For example, my lord, if the father is a party, daughter comes and says, no, this challenge is bad or this compromise is bad. What this judgment says is you go back to the suit and file an application there. You can't maintain a separate suit because you are claiming through one of the parties to the compromise.
No, that was not the proposition. Earlier, yesterday, you were saying that every third party cannot file a separate suit.
Yes,
any third party, third party has to go before the very same court is what
yes, yesterday's judgment said that. Lord, yesterday,
it didn't say in so many words.
It only says third party. Lord, here also in this judgment, what they would say is if you are claiming under a person who is a party to the compromise.
No, generally you tell the court what is the.
Generally, my lord, let me say this, my lord. The words used in order 23, rule 3 says party. party to the compromise.
Yes.
Well, compromise is nothing but a contract entered into between the parties. We come before the court sees whether it is lawful or not, and then it is accepted.
Yes.
So therefore, my lord, the general rule is, if any person wants to avoid that compromise, which is nothing but a contract, I have to go back to the same court. I can't file a separate suit, my lord. 77 Supreme.
Yes.
It was amended.
That is settled law. There
Yes,
is
my
no
lord.
dispute about
Now
it.
the question is, my lord, in this case, my lord, the daughter wants to now say that whatever compromise my father entered into in relation to a compromise of joint family properties, that is to be declared as null and void, and my lord, void ab initio. Similar facts are, my lord, there in this, where, my lord, the court would say that if you are claiming under your father, and father is a party to
Let's see that. Where
Yes,
is
my
that?
lord.
Paragraph?
Yes, my lord. Please turn to paragraph number, my lord, first 17 and then 22, my lord.
Yes. Hmm.
Lord, the 17 general principles are there of Order 23, Rule 3, saying there should be, my lord, to avoid multiplicity, suit should not be filed. Now, my lord, please come to para 22.
Yes.
In other words, the appellant can claim only through the predecessor Sampatya to the extent of rights and remedies available to Sampatya in reference to the compromise decree. Merely because the appellant was not a party to the compromise decree in the facts of the present case will be of no avail to the appellant, much less give him a cause of action to question the validity of the compromise passed by the High Court by way of substantive suit before the civil court, to declare it as fraudulent, illegal, and not binding on him. Assuming he could agitate about the validity of the compromise entered into by the parties to the partition suit, it is only the High Court who accepted the compromise that would examine the same, and no other court under proviso to Rule 3 of 23 can do it. Therefore, my lord, here in the present case, my lord, it is the daughter who comes, sister who comes in relation to the ancestors'
We'll
property.
order notice. Notice to the respondent. Petition
But
is
may I
permitted to
request
take.
for some date to be fixed, my lord?
Petition is permitted to
I'll
take
also
out hand summons.
stay.
If the hand summons are filed by memo, the memo is filed by 17th of July, list this matter on 20th or 18th, list on July 18th.
Should I ask for a limited stay, my lord?
I'm not convinced. Yes.
My lord, there are other grounds, my lord, I will. Because
That's why you should notice. Otherwise, I would have dismissed now itself.
very well, very grateful.
Yes.
Then number 24, Abhinay Vaiti, petitioner.
30?
24.
20. Yes.
7 Rule 11B, madam.
Yes.
2006, plaintiff's 2006, plaintiff's vendor purchases the property for 60,000.
2006.
It's a 48.30 square meter land. In 2015, my lord, plaintiffs purchases it for 4,68,000. Suit is filed in 21, valuing it to be 60,000. Therefore, we file an application at 7 Rule 11B. Both the sale deeds are produced along with the plaint. Trial court holds, my lord, that it's only the plaint averments it can look into and not into the documents. This, my lord, is contrary to the judgment of this apex court, my lord. Para 23.8, my lord, page 378, para 23.8. All we are saying, my lord, it will have to be returned back to the plaintiff to produce before. 23.8, my lord.
Point?
23.8, having regard to order 7 Rule 11 CPC, 14 CPC, the documents filed along with the plaint are required to be taken.
These documents are filed.
Filed along with the plaint. Court says, my lord, will just look into the
Come to the order.
order portion, my lords, at. The order portion starts at page 16, my lord, para 9. Order 7 Rule 11A to CPC empowers the court to reject the plaint where the statements made from the plaint itself. The suit appears to be barred by any law. The suit is undervalued and does not disclose any cause of action. The scope of this provision is limited to examining whether on the meaningful reading of entire plaint, without reference to the defense of the suit, is ex face barred. The expression
Please
from
come. Then counsel the petitioner submits that the defendant has filed an order 7 to 11 petition to reject the plaint on the ground that the court fee that is paid by the respondent is not correct, as basing on the sale deeds that are filed along with the plaint. That came to be rejected by order impugned, observing that the court can look only at the plaint And as per the plaint, the court fee that is paid by the plaintiff is proper, considering, and he relied on the judgment of the apex court in the Heben versus Arvind by Kalyani Bansali, reported in 2027 SCC 366. Considering the same, they shall be stay of all further proceedings. Pursuant to the order dated so and so. Hand summons memo by 16th of July, or else the stay granted, but this court stands vacated. Next.
Number 26.
26.
Kiran Menon.
Will appear for the petitioner who's the defendant. Not. Application under Order 7 Rule 11, A and D was filed not, to reject the plaint on the ground that the suit is barred by law of limitation. Suit is for specific performance of agreement of sale dated 9th of October 2013, my lord. And suit has been filed in the year 2023.
In October
2013. Now, my lord sees the plaint at page, suit filed is in the year 2023 on 2/2/2023. Now, my lords may kindly see the plaint is at annexure B at page 33. My lords may kindly see the para 13, which is at page 38, my lord.
Yes.
The cause of action for the suit arose on 9/10/2013 when the sale agreement was entered, and the legal notice is issued only in the month of December 2022, my lord. Now the agreement of sale, my lords will get it at page 43. This is in Kannada, my lord, so we wanted to actually translate it. We had
What is
commenced. My lords may kindly turn to page 48. Now, clause 4 may be seen, my lord. The time stipulated in the end, the last line, my lords will see, 4 months. Now, ಈ ದಿನದ ಲಗಾಯತಿನಿಂದ ಮುಂದೆ 4 ತಿಂಗಳ ಒಳಗೆ ಸದರಿ ಜಮೀನಿನಿಂದ ಸಂಬಂಧಪಟ್ಟ ಎಲ್ಲಾ ದಾಖಲಾದೊಂದಿಗೆ ಬಂದು ಮತ್ತು ಸದರಿ ಜಮೀನಿನ ಅಳತೆ ಮಾಡಿಸಿ ಸ್ಕೆಚ್ ತಯಾರಿಸಿ ಸದರಿ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದ ಮೂಲ ದಾಖಲಾದೊಂದಿಗೆ ಬಂದು ನಿಮ್ಮ ಹೆಸರಿಗೆ ಆಗಲಿ ಅಥವಾ ನಿಮ್ಮ ಸೂಚಿಸುವುದಾಗಿ ವ್ಯಕ್ತಿ ಹೆಸರಿಗಾಗಿ ಶುದ್ಧ ಕ್ರಯ ಬರೆಸಿ ಸಂಬಂಧಪಟ್ಟ ಉಪನೋಂದಾಧಿಕಾರಿ ಸಮಕ್ಷಮ ಮೇಲ್ಕಂಡ so and so ಹಾಕಿ. So the time stipulated is about 4 months under the agreement of sale.
What that entire clause says?
No, entire clause now 50, the total sale consideration is 1,65 lakhs. What is received under the agreement of sale as advance is about 50 lakhs. Now in all there are about 7 schedules, my lord. They're all contiguous land belonging to the 2 vendors, my lord, whom I represent. There were one suit which was pending in respect of 30 guntas out of 8 acres. My lords will see the agreement. What is agreed is per acre basis, not the composite entire property, my lord. What has been agreed is to purchase each acre at about 18 lakhs and odd thousand, my lord.
No, as per this,
yes,
the remaining amount has to be paid within 4 months.
4 months.
And what about the other clauses? It speaks about some sketch and other things.
Sketch, what the agreement says is, my lord, the item 5, 6 and 7. Now 6 had to be, Podi had to be conducted. 7, there is a dispute which is still pending, my lord. Right from the year 2011, it is pending. Insofar as 5 properties are concerned, my lord,
It's better we go to the objections. Where are the objections filed by the?
my lords will get that objections at page 152, my lord. Now, my lord, I have to,
1 minute.
my lords will see, or may I just take my lords to the impugned order, my lord? The kindly,
Let me understand what is
the objections, my lords will see at para 6 at page 153, my lord. It is submitted in the agreement of sale dated 9/10/2013. There is a period of 4 months in which the defendant had to obtain certain revenue records and as well as documents in respect of survey number 154/P2 mentioned in the agreement of sale, and this time period was fixed only for the purpose to allow the defendants to get proper documents with respect to scheduled properties, and in no means can be construed as a time limit fixed. These records are not ready till date, and recently notice sent by defendants to Tahsildar Kanakpura with regard to Hadbust, which was applied by Sharda, who is defendant number 2 herein, on 31/5/2023. The said
fulfillment
application
of this condition is contingent on this to be fulfilled by the
vendor, my lord. insofar as item number 6 and 7 are concerned, my lord. Item number 1 and 5, my thrust of the argument, as I said, my lord, the parties are fully aware, even as on date of the agreement of sale, that this, insofar as one item property, PODI has to be conducted. Insofar as the other item property, suit is pending, and rest 5 are free for registration, my lord, which is to the extent of nearly 6.5 acres out of 8 acres.
In agreement where it says about this.
Each schedule, my lord, may kindly, I'll read the entire clause, the section, my lord, that clause 4. My lords will see in each of the, if my lords comes to page 5 of the agreement,
Page number.
there's a description,
Page
page 48, my lord. Or my lords will see, there are, at page 46 also, my lord.
Yes.
Sorry, my lord, page 2 of the agreement at page 44, each survey number is described, my lord. If my lord sees survey number 277/2, it measures 1 acre 35 guntas. There's no litigation, there's nothing that's required to be done. Insofar as survey number 287 on page 3, 1 acre 36 guntas is free, my lord, again. No dispute, no documents are required. Survey number 277/1, 18 guntas. Survey number 155/3, 1 acre 20 guntas. This put together, my lord, nearly comes to 6 acres. Now, my lords will find survey number 154P2, which is 2 acres, which was required to be PODI'd, my lord. And survey number 288, which measures about 1 acre 36 guntas, is, I think, 30 guntas, my lord, only 30. There was a litigation pending right from the year 2011, my lord. And parties have agreed the consideration, not a lump sum amount, but they say the per acre is about 18 lakhs, my lord. I'll just point out to that extent. And then the payment made is about 50 lakhs as advance. Time contemplated is about 4 months. This aspect of the matter, the learned trial court, my lord, has not even considered in the impugned order, my lord. This clause has not been considered at all by the learned judge. Suit is filed only in the year 2023, February, my lord, nearly after lapse of 9.5 years. Hit by first limb of Article 54 of the Limitation Act, my lord. It's not a case where the
Please come to the order.
Impugned order, my lord. Impugned order, my lords will get it at page 19. The reasoning is at para 16 from page 28. Settled position of law that in order to examine as to whether plaint is liable to be rejected or not, only plaint averment shall be looked into. 17, my lord. As observed above, perusal of the agreement of sale dated 9/10/2013 shows that parties have entered into transaction with respect to 7 properties, out of which Durast was required to be made with respect to 154/P2, item 7 of the suit schedule property. Further, suit was pending with respect to 282, item number 6 of the suit schedule property, and same was required to be resolved. It is true defendants took 4 months' time to obtain necessary for registration, including sketch, hadbast, and to execute sale deed by receiving balance consideration, and after disposal of the suit with respect to survey number 288. In para 6 of the plaint, it is stated that even now suit in OS 143 of 2016, which was earlier in 2011, my lord, renumbered as 16, is pending for adjudication with respect to survey number 282. And further, counsel for defendant has argued that hadbast with respect to 154/2 is not completed.
Now that the entire extent, as per the agreement of sale,
Is
all
about-
those properties.
Correct.
What is the consideration?
1,65 lakhs.
So it is not independent. For
No,
this
no.
property.
Each
this
acre is about 18 lakhs. It's not about lump sum amount being agreed between the parties. Kindly envisage a situation, Lord. If I want to buy a property, if I am aware that a particular extent is embroiled in litigation, I will fix a consideration which will not affect that piece of land. The intention is to complete.
No, your agreement of sale says all this, like whenever an amount is paid, the sale deed will be executed in respect of that property.
Sorry, I didn't get my lords.
No, there are 10 properties.
Correct.
If in respect of one property, some amount is paid, you will get it registered separately.
Because it is independent of the other, my lord. Kindly see, my lord, the survey numbers are distinct. This is
Now
one
you
property
have
that
taken
is to
50
the,
lakhs. You know,
sorry,
now you
my
have
lord.
taken 50
I
lakhs.
have, my lord, I have, I'm not.
No,
on
no,
each-
no, that 50 lakhs amount for which property you have taken?
I have taken for each acre basis as a consideration which is fixed, my lord. What is paid to me is 50 lakhs under the agreement
So in
of sale.
in that sense,
My,
for
my,
50 lakhs, if you are taken it for each
kindly-
acre like that, so then he is entitled for a sale deed in respect of whatever he is
the
taken.
balance, which he has not exercised within 4 months is my case, my lord. Kindly turn to para 35,
The court
page
has,
35.
court has in detail has discussed.
My lord, kindly turn to page 35, my lord. 35, my lord,
Yes.
which is the plaint. Kindly see, my lord, para 5.
Notice to the respondents, petitions permitted take court handsomely. And shall file a memo to that effect. Once memo is filed, is the matter.
Then number 30. Yes, Appa, Janardhan G for respondent.
Yes, my lord.
Please.
Is a revision by the defendant, my lord. In this case, my lord, the first respondent issued a notice to the petitioner on 23/4/2024, saying that the petitioner is a tenant in the scheduled property on a monthly rent of rupees 5,000 with security deposit of rupees 50,000, and there is a rental agreement entered into between the parties on 1/10/2018. My lord. Subsequently, my lord, the
Defendant
petition.
is directed to deliver the vacant portion of the suit property to the plaintiff within 30 days from the date of the order. Directed to pay the damages. I thought it is an IA. It is arising from a small causes court.
There is no relationship of landlord and tenant, my lord.
I think I have to appreciate this, the entire, this is matter
No, that,
on,
because they filed execution, my lord.
this is matter on 18th of July, till such time.
Lord, may I make one request, Lord?
It's a working day, I think.
Lord, may I make one request? Lord, from 2017, he has not deposited even single pay under section 16 of the act. He is under the obligation to pay. Lord, until he such, he is not entitled.
My lord, because it is the contention of the petitioner that there is no relationship. He is
Oh,
staying.
there is a decree.
Yes.
What the decree says.
Pay
will not be-
13,000.
Further proceedings will not be stayed
Yes.
unless and until.
Sometime may be granted. Will
How much, what is the amount and what is the time?
no, because what the judgment says, my lord, it is from the date of the suit, my lord.
It comes to how much?
Lord, it comes to
13,000 from the date of the suit.
Blood
Comes
3,
to what is the amount?
blood 3,16,000. 1,50,000 at the rate of 13,000 per month. Blood.
It comes to 3 lakhs. Deposit half of it in 6 weeks.
Blood, it is a rent
Before-
payable. Blood.
Some 6 weeks
2017.
time might be granted, my
Lord,
lord.
I
6
may
weeks
make
time before that will
May I
deposit
make one
amount.
request? Lord? From 2017, he himself in the written statement has admitted that he has been a tenant under my vendor.
Different man,
And
not
if
an
that is
accused.
so,
We'll
Lord,
hear it the next time when the matter comes. Then counsel for the petitioner submits that the court has passed an order of eviction without appreciating the contentions raised. Then counsel for the respondent submits that the petitioner has not paid any amount from 2017. From 2017. The court has fixed the
13,000
13,000
per month.
per month. And as per the land counsel for the respondent, it comes to 3,16,000. The petitioner shall deposit an amount of.
No, my lord, it is from the date of the suit, my lord.
Yes.
That is what the judgment says.
Correct.
Not from the 2017.
That is what 13,000 from the date of the suit because he has.
Yes, 13,000 from the date of the judgment.
That comes to that.
What is that?
From 2024.
That comes to that. Kindly see, not 13,000 due to 12 months.
Not 30, 13,000.
ಹೌದಪ್ಪ ಅದನ್ನೇ ಹೇಳ್ತಿರೋದು 13,000 per month. I am repeating that.
Defendant is directed to deliver the so and so.
Let
within
him calculate
30
and
days,
pay.
And further directed to pay damages of rupees 13,000 per month.
Yes.
To plaintiff number 2 from the date of the suit till handing over the vacant position.
Yes.
Please, my lord.
When is the suit filed?
2024, my lord.
24.
So 24 which month?
27/5/2014. 24.
Huh?
27/5/2024.
2 years, my lord.
So 26?
Please, my lord.
Yes, 2 years.
Please.
24 months.
Yes.
Please.
24 into 13, how much?
24 lord.
I said, but he is not. He want to calculate. Let him calculate.
It comes to 3,12,000.
You will deposit 3 lakhs, my lord.
You
Not
deposit,
that.
By 6 weeks, my lord.
you deposit how much?
3 lakhs, my lord,
It could be.
within 6 weeks, my
And
lord.
what my requesting is, let him continue to deposit or pay him.
No, no,
Because he
no,
can't,
that is to be
and there is an
decided.
order, my lord. We can't, he can't keep the premises, enjoying the property, even occupation charge is liable to pay.
We'll see whether you are the landlord or.
When counsel
see
for the
later, let
petitioner
us see.
submits that he will deposit an amount of rupees 3 lakhs within 6 weeks.
And
On this, hence there shall be stay of all further proceedings on the condition that petitioner, on the stay of all further proceedings pursuant to so and so, on the condition that the petitioner shall deposit 3 lakhs within 6 months, within 6 weeks.
Before this court, my
matter,
lord. Before this court or before the trial court?
wherever you want to, where you want to deposit.
Maybe permit deposit before this court, my lord.
And on such deposit, the respondent is at liberty to withdraw the money.
No, in so far as that, please, I got serious
Why?
objection, my lord. No, your lordship may kindly, it is serious dispute. You have not admitted the relationship. We say that is not.
It shall be
Let
deposited.
amount be there before
Right.
this on
It
court.
shall be deposited. Let's just matter. The 25th is a working day. 25th July is a working day. List on 25th July.
Please, my lord.
Not, that let him continue to deposit that rate, not because he can't give, if he goes away, not then what is
I
it?
have given him 6 weeks' time.
Not that is true.
This
No, further
Matter
rents,
is posted on 25th.
that is true, but suppose if any reason, not, that is why I
District
say.
Court. We'll have it on 27th. And that order I'm not going to pass right now. Yes.
Please, my lord.
Next.
Question number 34. Sridhara K.
They're all passed over. Yes.
In this matter, my lord, I have restricted my claim relief with respect to IA number 11 only. My lord, IA number 11, it's a suit for eviction, my lord. I am the defendant. My lord, the basic matter is he has claimed, the plaintiff has claimed that there is a rental agreement in the year 2017. My lord, I have
Sign number 11.
IA number 11 is for referring the matter to the expert opinion FSL. Because, my lord, he relies on the 2017 rental agreement on which my signature is not there. That is the whole point of this petition, my lord. My lord, kindly, my application can be seen at page number 44, my lord. He has filed an objection. The order passed by the court says the relevant paragraph of the impugned order can be seen at page number 24.
You're referring to objections.
Not?
To your application you are referring to.
Yes, I am referring to order now. My application is at page 44, my lord. Application under section 45 of the Indian Evidence Act. Prayer, my lord, at page number 46. Direct the disputed document exhibit P5, which is a rental agreement, along with the admitted specimen signature of the defendant available on record to the Forensic Science Laboratory. This is my prayer before the court.
For what purpose? The suit is based on that agreement?
Yes, my lord. Kindly, my lord. I will take the.
So by virtue of that, you have leased out the property to him. You rented out the property.
Yes, my lord. He says on the agreement dated 2017, I was inducted as a tenant.
You were inducted.
Yes, my lord. I am the defendant. I am the tenant. I am saying, my lord, that agreement is not at all there. I have not signed any of that agreement. The entire case bases upon the same thing.
So the burden lies on him to prove whether that agreement is executed by you or not in the light of the denial.
My lord, apart from that, if the agreement is found to be not genuine, my lord, automatically case will fall on the face.
Come to the order.
My lord, relevant pages of the order, page number 24, my lord, where the court says, admission of the defendant, he is tenant on the suit premises under the plaintiff. Looking at the fact and circumstances of the case, the court is empowered to compare the signature of exhibit P5 and other admitted signatures under section 73 of the Evidence Act. Admittedly, the defendant is a tenant at the suit premises under the plaintiff. Thus, the court can decide whether exhibit P5 or the oral agreement as contended by the defendant under these circumstances. The court is of considered opinion that it is not necessary to refer. My lord, what I am submitting before the court is, under section 73, yes, my lord, court has the power to check this as a specimen signature. But my lord, no conclusion is drawn. Court is not saying whether my document which is produced, whether the document produced by the plaintiff is genuine or not, is not.
That the court will consider the same while passing the orders.
Yes, my lord, for specimen signature and
So
all.
as of now, The court said the court has the power under 73, not necessary that it should be sent. What else you want?
My lord, I am seeking, my lord, it has to be sent right now, my lord, because, my lord, otherwise, if a case, if a lab points out that the agreement signature which is alleged by the plaintiff is not mine, my lord, lease agreement itself is not there.
Come to paragraph number 13. What is extracted by the court from your written statement?
In the written statement, my lord, after the expiry of the lease, 15/8/2020. Earlier, there was an agreement.
Read that.
2020, the plaintiff has refunded the lease amount to the defendant. Thereafter, defendant has continued to tenancy of the premises for the monthly rental of 6,000 rupees and 300 rupees per month for water charges, paying security deposit of 50,000. The defendant, as per the oral agreement dated 28/2020, has been paying the rentals, water charges regularly up to date.
Now, what you say is, rental agreement dated 7/7/2017, produced by the plaintiff, that should be sent for the expert opinion. Now, in this para, you say, after the expiry of the lease period,
Yes.
that is at 15/8/2020, the plaintiff had refunded the lease amount to the defendant.
Yes.
What exactly does it mean?
My lord, I refund the amount to the plaintiff. My lord, he issues a check.
No, you accept that till 2020.
Yes.
You are in possession of the property.
Yes.
You are referring to certain lease deeds and all.
Yes. Lease.
For what purpose you are denying it, and why you want it, want the document to be sent to the expert?
My lord, the entire format of the suit will change because my submission to the court is, it is on a oral agreement. Oral agreement, my lord.
You are saying after the
Yes,
expiry
madam.
of the lease period, that is your contention.
Yes, my lord, I agree. But the entire case bases upon 2017 rental agreement, not this one. This is my contention. Kindly, my lord, page number 39, paragraph number 13 of my written statement. Page number 39. I have taken a contention. Since no such rental agreement has been executed as alleged in the plaint between the plaintiff and the defendant, as such, the Honorable Court has no jurisdiction to entertain the present suit. The plaintiff has forged the defendant's signature alleged rental agreement dated 7/7/2017. My lord, in a usual course of time, when a rental agreement is made, original be with the defendant, tenant. My lord, here the plaintiff produces it. Why there is a suspicion, my lord? It was supposed to be in the hands of the defendant. It was supposed to be in my hand, original agreement. But he produces. Secondly, my lord, signature is not mine.
That will be considered by the court. Court has the power to do it. The court has rightly considered this.
No, my lord, if
application
it
not
is
made.
found out now that the agreement itself is not genuine, the case will fall, my lord.
You ask
That is
the-
my submission.
You ask the court to decide it.
My lord, but the court has not given a conclusion. Court says it is not necessary as of now.
It will
But
not
I am
send
saying,
it. That's what he said. Court will decide it. If you want it to decide, file an application.
Lord, I have filed the application for referring to the FSL. That is the only dismissal. That application is dismissed.
That's what court said. At an appropriate time, the court will decide. What is the stage of the evidence now?
My lord, now it is posted for arguments. It is posted for today only.
Then we'll ask the court to decide. Let other side come. Notice to the respondent. Petition is permitted to take out handsomely.
Till then, my lord, stay
If
may
the
be
memo
granted.
is filed, let's just matter.
Lord, if decree
the-
is drawn,
if
my
the-
lord.
Please wait. If the memo is filed by 29th of June, list the matter on 30th. Nothing is going to happen in 2 days. Yes.
Lord, if a judgment is drawn, my lord, this contention will go.
Arguments,
Yes.
court will hear it in 1 day.
Lord, today they were supposed to hear. It is taking on day after day basis, my
That's
lord,
what-
even though there is no
what
direction.
What is today? Today is Tuesday.
Today is 23rd.
Only 2 days or working days. I said you file a memo, even if you file a memo by 25th, the matter will come up on 29th. I'm not inclined to stay it. This is the matter, if the memo is filed by 25th, this is the matter on 29th. Yes. What is that?
Notice counsel.
Oh. The same, give it to me. Yes.
Cell number 35,
Appear for the petition.
35.
The respondent has filed the execution petition for recovery of 13 lakh rupees, my lord. Now I have deposited a sum of rupees 5 lakhs before the executing court on, my lord. 10/6/2026, ink page 51, my lord.
Hmm.
I am ready to pay the balance amount within 2 months, my lord. Now they issued this self proclamation.
Hmm. Where is the order?
Lord, ink page, my lord, 47.
Execution is filed in the year 2023.
Yes, my lord.
Hmm.
I am ready
When
to
is the
deposit.
order passed?
My lord, 23/4/2026, my lord, your
No,
lord.
I'll grant you that time, but I'll record that if you fail to comply with the same within 2 months,
Please, madam, please, madam.
the court will impose exemplary costs.
Please, madam, we will
Not
pay the
comply with the
entire
order
balance
and for
amount
making
within.
a concession before the court with regard to that.
Please, madam, within 2 months we will pay the entire.
Then counsel for the petitioner submits that. What is the suit for?
Suit for recovery of the money.
It is submitted that the petition is a judgment debtor and the suit for recovery of money is decreed. The decretal amount is how much?
Lord, the execution of the decree amount is, my lord, 9,89,000.
Execution
With
is filed.
interest, my lord, 13,05,348.
Execution is filed for recovery of an amount of rupees 13 lakh,
5,348.
5,340. Before the trial court, he has paid an amount of rupees 5 lakhs. It is submitted that with 2 months' time is granted, the petition is ready to pay the entire amount. Considering the submission of the learned counsel for the petitioner, this court is passing the following order. There shall be stay of all further proceedings pursuant to the order dated so and so for a period of, there shall be stay of all further proceedings on the condition that the petitioner shall deposit the remaining amount within 2 months. 2 months is what's the date? Today is
23rd.
23rd. By 24th of August. If the petitioner fails to pay the amount by 24th of August, this petition will be dismissed with exemplary costs. Notice to the respondent.
Sought for hand delivery, my lord.
Hand delivery of the order is permitted.
Till number 36. Kishore Kumar.
Hearing for petitioner counsel.
Yes.
Lord petitioner, your lordship, before lordship is the respondent in a regular appeal.
What are these IAs?
Pardon me, Lord.
What are the IAs?
IA-19 is for reopening of the proceedings. IA-20 is for production of additional document. IA-21 is permission to adduce the evidence. All these
It is
three
submitted that office has raised objection with regard to already said.
that was complied with and
The
court say
necessary
have been paid.
objection with regard to the maintainability is overruled. Yes. Yes.
Lord, a suit, appellant before petitioner before your lordships is a defendant before the trial court. Without service of the suit summons, the suit came to be decreed, the suit for partition. Then, my lord, the one among the defendant before the trial court, the plaintiff has filed a regular appeal before the first appellate court. Even first appellate court also, my lord, appeal came to be allowed. And the decree was passed decreeing the suit is concerned, without notice to the present petitioner is concerned. After he came to know about all these things very recently, he made an application by initiating a miscellaneous proceedings before the appellate court. He sought for restoration of the appeal or rehearing of the appeal. That application came to be allowed. Accordingly, now the regular first appeal is restored. It is on track before the first appellate.
When was that? When was the suit was restored?
Suit was restored, my lord, on 2023, my lord.
When was it?
7/3/2023.
12/3/20.
7/3/2023.
When was it decreed?
Suit earlier decreed on, suit came to be dismissed on 17/5/2008. Then suit subsequently decreed because of a judgment of the appellate court in 29/3/2014.
So a 2014 decree is set aside and now the suit
That
is
was
restored.
set aside during the 7/3/2023. Appeal came to be restored at the instance of my application.
Yes, yes.
Since 2023, proceedings are going on. Now, recently, I made an application for reopening of the proceedings and also to produce the additional evidence. And I sought for permission of the court to adduce the evidence before the first appellate.
So from 2023, what is happening?
But there are other proceedings and service of notice is incomplete. One of the person is dead. LR application proceedings in that way. Now the first appellate court reject all these applications on a solitary reason. Since I have not filed any written statement before the trial court, no purpose will be served allowing this application. This is the reason of the first appellate court. My lord, my submission is a non-filing of the written statement. It does not take away the right of the litigant to cross-examine the witnesses. I may not tender my examination, Chief. It is, of course, a different matter. Your Lordship is note order 41, rule 21 of.
Let's see the order before that.
Yes, your Lordship may see order, common order was passed. Order is set, my lord. Page number, my lord, 295. In that manner, 297 is the relevant page. There your Lordships may kindly take note the paragraph 4. 7th line from the top of paragraph 4 at page 297.
It's a small order, we'll read from 295
Yes.
to understand the fact.
Relevant order is 297 may kindly be seen. This is the only reason forthcoming in the order, my lord. That's what I wanted to advert your Lordship's attention kindly. So far as paragraph 1, 2, 3 facts are narrated, relevant part of the orders commencing from paragraph 4. Relevant part is, my lord, the 7th line from the top of paragraph 4. In the absence of any written statement before the trial court, present attempt to lead further evidence, recall witnesses, reopen the state, produce additional documents wholly unsustainable. It is a settled principle that evidence cannot be traveled beyond the pleading, and in the absence of necessary pleading, the question of producing further evidence does not arise. This is the only reason rejecting all the 3 applications. Even under order 41 rule 27, application could not be considered independently at this stage. It has to be considered along with the merit of the matter. That application was also declined by a common order which is impugned before your Lordships. There is no fault of the defendant before the trial court because without service of summons, suit came to be dismissed. Later on it was declared the instance of the one of the plaintiff. There also I could not hurt. Then as a purchaser of the property having substantial interest, this application came to be moved. My application was examined and appeal is now restored to the original file.
No, you file an application. No, one of the IA is to submit certified copies of the original additional documents to protect the property rights. What is this?
That my lord, I am concerning IA number 19, IA number 20, and IA number 21.
Correct.
Another
No,
application,
you don't file the written statement.
I cannot because no
that's why-
notice was issued to me.
There are no pleadings.
No,
When
no.
there are no pleadings on your behalf, what is that you will do?
Madam, your Lordships may kindly see matter to be examined in this angle. I am one of the defendant.
Yes.
If I served with the notice, if I committed a default from appearing in the court, it's a different aspect. Court summons was not served upon me. Without serving notice to me, suit came to be dismissed. Then at the instance of other plaintiff, suit came to be declared by virtue of following the regular appeal, where also I was not served with a notice.
No, but you should fight for it.
That's what I made. In 2022, I made a miscellaneous petition saying that my right to property is deprived of without due process. Therefore, appeal has to be restored. Convincing the reason, First Appellate Court restored the appeal. After restoring the appeal, now these applications I have filed. Since I have not served with the notice in the trial court, I could not be able to file the written statement. How I could file a written statement?
Oh, no, according to you, without filing any written statement, without any pleading, now you will adduce the evidence.
Well, that's precisely the reason. Order 41 rule 21.
Cross-examining the witness is a different aspect.
No, no.
You are saying that you want to adduce the evidence.
Milord, it is. Milord, order 41 rule 21 may kindly be seen. What is the remedy of a person against whom ex parte order have been
Yes,
passed.
give that.
May kindly see, my lord.
Yes, let's read.
Order 41 rule 20, order 41 rule 21, where an appeal is heard ex parte, judgment is pronounced against the respondent, he may apply to the appellate court to rehear the appeal. And if he satisfies the court that the notice was not duly served, that he was prevented by sufficient cause from appearing, then the appeal was called on for hearing. Court shall rehear the appeal on such terms as to the court or otherwise of it thinks fit to impose upon him. Now the appeal is restored, which is available for rehearing. Then the appeal is to be reheard. Then I am entitled to reopen the proceedings from the stage my rights have been deprived of. Trial court, well, if all other issues I do not want to. An application is filed for production of additional document by a party to the first appellate court. That application cannot be independently considered. That has to be considered along with the merit. That was the law of the land. Order 41 rule 27 does not contemplate a power upon the...
Without any pleadings, any amount of, the party can adduce the evidence.
My lord, could I...
You satisfy the court on
My lord, a person...
No, you please
One
place
minute.
something on record to show some judgment. That you don't file a written statement. There are no pleadings on record.
Yes, admittedly, there is no dispute.
Right. From your side, you want to file the documents.
My lord, my
That is
submission is...
permissible or not? That I want to know.
My lord, settled legal position I can explain. Could your lordships have this matter tomorrow? My lord?
Yes.
It may be listed tomorrow.
Yes, tomorrow.
What is the right of such a person?
Yes,
In a
yes.
list I can explain to lordships.
Yes, next.
Serial number 44. Anjaneya, petitioner.
For the plaint, petitioner.
My name is not shown in the,
You file caveat.
no, IA for impleading.
What is this IA for impleading?
Madam, they are affected parties, the suit, madam, suit is not made party. FDP not made party, then FDP execution also not made party to these impleading applicants. These applicants are
Go
resident.
before the trial court where the case is pending and then get
Madam,
impleaded.
only execution order is challenged by the petitioner before.
No, that is again, go before the impleading court and implead yourself, not
In
before
this
this
matter,
court.
my lord,
Yes.
the respondents are suppressing the facts and they have amended.
Forget
this
about the
other side,
respondents. Please argue on your writ petition. What is order impugned?
My lord, order dated 2/4/2026, my lord. Order under order application under order 6 rule 17, my lord. My lord, in this the southern side of the item number 1 bar.
What is the suit for?
My lord, the suit is of execution, my lord. Earlier in 2000, OS partition suit was filed, and then the FDP was made.
Come to the order. In an execution petition, you have filed an order 6 rule 17 petition.
We have not filed, my lord. The respondents have filed, my lord.
Oh, that is ordered.
Yes, my lord. That is allowed, my lord.
Come to that
And,
order. Come to the order.
Lord, page 17, my lord.
Yes.
On pursuit of the materials available on the record, it reveals that the DHR, the decree holders have filed the suit for partition and separate possession against the defendants JDRs in OS number 11/2000 in respect of the suit schedule properties, and the said suit has been decreed and the plaintiff DHR is entitled to 1/4 share of the suit schedule properties, my lord. My lord, after that the FDP was drawn, and my lord, the major issue, my lord, in reality there are 80 residential houses, my lord, in the southern side, and there is Lakshmi temple, my lord, and there is
Read
a
the
public road.
order. Read the order from paragraph number 7.
The decree holder has filed the petition for delivery possession of his 1/4 share in the petition scheduled property as per the final decree proceedings in FDP number 5/2003. When the matter is at this stage, issue of delivery warrant, the LRA of the decree holder has filed an IA to insert the southern side boundary as AK colony, my lord. After that, the word of the south in the item number 1, my lord. My lord, in this, my lord,
Previously, a delivery warrant was issued, my lord. My lord, I'll pass on the photographs and report given by the village administrator, my lord,
Not required.
regarding
Not required.
survey number 1/1, my lord. There are 80 houses, my lord, and there is a public road and a Lakshmi temple, my lord. Impleading respondent is the person who has house there, my lord. Regarding the application, my lord, we had filed the objection, my lord. It's in page number 31, my lord.
Then counsel
Please,
for the
ma'am.
decree holder submits, the judgment debtor submits that the court permitted the decree holder to amend the boundaries. Then the executing court gone beyond the decree. Considering the submission, they shall be stay of all further proceedings.
Submission,
Pursuant to,
my lord, there is high chances of issuing the delivery warrant, my lord.
pursuant to the order dated 2nd April 2026. Next, come, where is that IA? Where is that IA? Who filed this? An IA number 1 of 26 is filed, seeking to implead them as respondent number 18 to 23. In this petition, it is stated that the petition is residing in the address and the learned judge, without looking into item number 1 of the property, passed a delivery warrant dated 26/5/2022, and also in item number 1, suit scheduled property in the southern side. There is 82 residential houses, including the house of the impleading applicant, and he is not a party to the execution petition. Hence, he shall be pleaded in this case as a respondent. Then counsel submits that is a proper and necessary party to decide the dispute involved in this case. As such, the IA may be allowed and they may be pleaded in this case. The petition, next para, the implead applicant is not a party to the suit or to the execution proceedings. According to him, his property is going to be, by virtue of the delivery warrant, they're going to attach the property which the petitioner is in, which the implead applicant is in possession of. In that case, his remedy is to file a petition before the court as an objector under 21 Rule 97, but not come before this court and file an application to implead in these proceedings. In that view of the matter, the IA number so-and-so is that this court do not find any merits in the IA. IA is dismissed. However, giving liberty to the respondent to file appropriate application before the executing court.
Say number 46.
I'm so loud. I said stay of all proceedings. Still you are asking for that. You should follow what is happening in the court. Huh? Yes. Next.
Say number 46.
Okay, for the respondent number 1.
For the petitioner.
Yes.
I'm for the plaintiff before the learned commercial.
Yes. Why you are not, when did you, when you have, when the stay was granted? When the stay was granted?
No, stay was granted, my lord, while the
20th
Then what
August.
are you doing without paying the process from now, from there to now?
Lord, we have paid, my lord, we have paid.
It's coming up for paying the process. Regarding furnishing of so-and-so to issue
Lord, what has
notice to
happened
R2
is,
and R3
so
for
far
the
as-
first time.
For those respondents, there was an order saying that to be dispensed with, my lord.
Where is that? If that is the case, we will hear the matter now itself.
Please.
Where is the memo? Let's see.
My lords, but actually, we did not ask for the dispensing, my lords. The truth of the matter is, the main list is between the bank and the plaintiff, my lords. I am the
In
one-
that case, if you feel that they are not proper and necessary, their presence is not necessary, File a memo.
My lords, that is the opinion which was taken earlier, my lords. So far as we are concerned, they are necessary.
Then we should have paid the process.
My lords, I'll pay. Just one day to time may be given.
No, why we having obtained a stay in the year 2025.
No, my lords, it was
When
not
is the
pending
order?
from then, my lords.
When is
May
the
may I
order?
just make, July 25, they filed the
One
writ
minute,
petition.
1 minute.
Apologies.
The order sheet may.
The commercial court matter.
Please.
And there is a time limit, there is a time frame for disposal of the matters, and you come to the court.
No, my lords. In fact,
And you don't pay the
in
process.
fact, on the last day.
That should be the reason why on this ground alone, the writ petition should be
No, my
dismissed.
lords.
The court may take the order sheet in 872. In that, the interim order has been passed.
In fact,
The
on
main
the-
872, 21872. The main
21872, when was the order?
20th August 2025. The
Almost
lead-
a year.
My lords, may I mention, my lords, it's not that we drag. In fact, on the last day, this matter was going to be disposed of because the issue here is whether the matter should go from the commercial court to the civil court. We considered that it's fine, we are okay to go it before the civil court. The only bone of contention, which is why it got adjourned, was that we should not be given a right to file a written statement. They wanted to stall that, saying, since the matter has been pending for a long time, we are okay if at the same stage it goes to the civil court, but we do not want to concede their right to file a written argument. I'm sorry, written statement. Only on that point, we are at.
Why, how can you be unreasonable on
Your
the?
Lordships, may I just make one comment? Your Lordships, today, originally I filed the suit before the civil court. It comes to be
When was
transferred
it? When was it?
in the year 2019.
Hmm.
There are 24 suits. First suit came to be filed in the civil court. Notice, a summons issued, they enter appearance. Thereafter, suo motu, the administrative order.
You're the bank.
I am for the plaintiff who was the landowner. The crux of the issue is issue between landowner and developer. Developer, we allege, has sold our share of the property under the JDA. That's the bone of contention. I file a suit regarding one of the apartments. 24 apartments have been sold before the civil court. Summons issued, they enter appearance. At that stage, it comes to be transferred to the commercial court. They don't take up any objection. Trial is conducted. They don't file their written
When
statement.
was it transferred to?
I just give the date immediately. Just one moment, Your Lordships. Leadership.
First case First case
22/1/2021. May I just pass on the order? Your Ladyship.
126.
Yes.
Page number 2 of the Honorable Court.
Page number?
2 itself. Lordship, this is an online order which has been extracted.
Hmm.
Register the case. Entire file is to be indexed properly since this case has to be transmitted to the newly established court of 10th Additional District and Sessions Judge
This
Bengaluru.
order is dated?
This order is date is not forthcoming, Your Lordship. It is 22/1/2021, which I've mentioned in my memo.
Yes.
So this comes to be transferred to the commercial court. Commercial court, they continue to enter appearance. They contest it. They have not filed the written statement. The written statement comes to be taken as not filed. I lead my evidence. The other defendants, some of them have filed their written statement, some of them have not filed the written statement. It goes for final arguments. Final arguments we start to advance. At that stage, in the interim, may I also place before the Honorable Court that they file an Order 7 Rule 11, comes to be rejected. They come to the High Court, comes to be dismissed. They go back. At the stage of final arguments, they come and file an application under Order 7 Rule 10. Now, this was not the first time. There was another defendant who had filed a memo on similar grounds saying that the commercial court does not have jurisdiction prior, which was also dismissed, and nobody has challenged that. At the stage of final arguments, they file this application. Application comes to be rejected. Then they come up to this court in writ petition, and for 1 year, they have stayed the entire proceedings before the commercial court. Our grievance is only this. For us, as far as we are concerned, we want adjudication of our dispute, whether it's the civil court or the commercial court. Now, the issue here is, now if it goes back to the civil
So
court.
do you concede to the fact that the jurisdiction is the civil court?
Your Lordships, whatever the Honorable Court holds, we do not.
No.
The contention is today we have taken up a contention that it's a commercial dispute.
But anyway, I will not record that you have said.
It may not come as a concession.
Nothing to be adjudicated on that issue as of now.
It may not come as a concession. If the Honorable Court feels this has to go before the court, we have no objection. Our only contention is today having taken up a contention that this has to go before the commercial court in the Order 7 Rule 10. We have gone on record that this is a commercial dispute and it is above the specified.
At your instance, it has been transferred to commercial.
It's not. It was an administrative order. So today, and trial has been conducted for 7 years before we were before the commercial. 6 years we were before the.
Why should you be kept in a better position than what you were from
But what has
this
really
stage?
happened is just a few aspects I'll bring to your Lordship's attention. in 2006, there was a joint development agreement. There were two survey numbers, survey number 118 and 119 as part of the JDA. The one of the survey number 119, I am not a localite. I am a professional developer. I am basically from Kolkata. I came, I took up this. The landowner said, both the survey numbers are part of my ownership. But when we started the project, as per the JDA in all earnestness, what came out is that in 119 is actually a Sarkari Topu land, which is a government land. This is where it all, Lords, after that.
It's on the merits
No,
of the
Lords,
matter.
why there was a delay? In 2018, they file a criminal case against me. I am taken into custody. I am not my entire business has come to a standstill. The matter goes right up to the Supreme Court. The entire case is quashed, my Lords. It is then that I get a lease of life and I start litigating this matter, my Lords. This is where the delay is. My Lord, if your Lordship.
We are not here to consider whether you can file a written statement or not. We are only on the point on the merits of your order
Merits of the
7.
case. On the merit, if I may
Only to that, if the court feels it's a case for transfer, it will be transferred. But court will not give any finding with regard to your written statement. Because whatever is your position, which you have never contested, you never wanted to file a written statement, and you never asked the court to receive the written statement, there is no order by the court, then why should we go into all those things?
My Lords, by the time the matter had gone from civil court to the commercial court, and the commercial court issued summons to us and we came on record. We had
Under the Commercial Courts Act, there is a provision, which says that you have to file the written statement within so and so.
My Lords, in this whole transit period where I was facing criminal case, then the transfer happened from civil to commercial. The strict limitation which is there, I lost it. I filed it and it was rejected.
Then what did you do?
My Lords, I have no remedy, my Lords. Under the Commercial Courts Act, I have no remedy.
So for that reason, no, it has to go from commercial
not for
court
that
to
reason. No. I am on a point of law only, my Lords. I'm not trying to.
When did you realize this point of law?
My Lords, there are
Is it not your abuse of the judicial time?
What happened was there is
and
an
the process
arbitration.
of court?
There is an arbitration clause in this. So I moved an order 7 rule.
Why
11.
did you surrender yourself to the jurisdiction of the court?
No, my Lords, I filed an order 7 rule 11.
When?
My Lords, date I'll come, my Lords.
That ended up in dismissal.
Yes. My Lords, then I came to the this honorable court. This honorable court said no arbitration. It's too late now. Therefore, you have surrendered. Therefore, you can go ahead. Now, my Lords, that is a separate issue. But the point of jurisdiction, whether section 2(1)(c) of the commercial court's definition, whether I fall within that, certainly no.
They're not contesting before the civil court.
My Lords, at that time I had not issued summons, my Lords. By an administrative
They
order.
were issued summons. They were before the civil court. Then it got
At least,
transferred.
My Lords, I was not on record. I have no knowledge.
He might not be on record, but the defendant had been
Shouldn't
served.
come to the rescue of a litigant who is like this. You have lost your right to file written statement. You have lost.
My Lords.
We will now decide only on order 7 rule 11. Please come to the order.
My Lords.
On what ground you say that
before I
you
come
should go to the
before I
civil?
come to the order, may I show the plaint, my Lords?
Yes.
Please. With your Lordship's indulgence, one writ petition 22233 of 25.
Take that.
That has orders in paper. All the papers in order, my Lords. 22233 of 25.
That is serial number.
46.13.
So that it's easy for her to take up the bundle.
Yes.
That is 46.13, I think.
13.
Yes.
Your Lordship may kindly come to page 126, which is their plaint. This is the plaint filed by the landowner.
1 minute.
Suit
126.
filed by the landowner.
Yes.
Your Lordship should see the cause title. The landowner is the plaintiff. I am the defendant number 1 and 2. And the third defendant is the person to whom I have sold the property belongs. There is, in fact, thereafter, bank is also made a party belongs.
No, you're the landowner.
I am the developer. The landowner is the plaintiff.
MRG Realtor.
Please, that is the other side. I am Parkway. My Lords, kindly come to the prayer. I won't trouble your Lordship with all the details. Just the prayer. What is the nature of the suit? Wherefore the plaintiff so and so declaring that The sale deed dated 14/8/2018 registered on so-and-so in book number so-and-so in the office of the sub-registrar Banaswadi purported to have been executed by the defendant 1 and 2 in favor of defendant 3 is illegal,
The
null, void.
declaratory relief that is sought.
That's all. Where is a commercial dispute, my lords? What the learned trial court has said is, this is a commercial dispute arising out of a construction contract, which is section 2(1)(c)(6), sub-Roman 6. There is no construction left to be done. It is not even their contention that I have to construct anything more. Their contention is, I have sold a property which is falling within their share. Therefore, this is non-esteem law. This should be declared as a sale deed, void ab initio. Now, this is a list primarily between MRG Realtors, the plaintiff, and the bank which has given them the loan, and the other defendant who has bought this from me. Now, there is no way in which this is either a litigation arising out of a joint development agreement, nor is it a case where any construction is pending. And there,
No, how did you sell? By basing on an agreement between you, you have sold a property. It is arising out of a joint development agreement.
That is not out of joint development, not it is out of a revised sharing agreement, which is also not in contention here. They're not asking that declaration on the revised sharing agreement. They're not asking on even joint development agreement.
You have an agreement.
No,
And
agreement is there.
This relief has emanated from that agreement.
Please.
From that agreement, if you have to sell this, you have sold his share also. That is.
Tomorrow, I ask myself this question. Tomorrow, even if the relief is granted, I am not the person who is directly being asked to do anything. There is no relief sought except injunction, which is a blanket injunction which has been sought. On the sale deed, they are not even asking for any compensation from me. They are only saying that the sale deed, which is the defendant number 3, is illegal. Now, to convert a list which is purely private and civil in nature into a commercial dispute, a sale deed being void or not is not a commercial dispute, though generally it may have a flavor of a commercial dispute. Under section 2(1)(c).
Let's see, where is a commercial court?
Kindly see.
Let's see.
Your Lordship would kindly see section 2(1). 2(1)(c)(6). In fact, it's only under this that the learned trial court says I come, or this dispute comes, and therefore says that commercial dispute is made up. May I read this? 1. In this act, unless the context otherwise requires, I would come to see number 6.
Construction and infrastructure contracts.
And infrastructure contracts, including tenders. Now, my lords, if they
said you will fall under this?
That's the court has. There is no way I fall under that. So on the point, there is not another section which has been highlighted apart from that. The second aspect which the learned trial court says, the bank which had first entered appearance, my lords, had filed a memo saying this doesn't come under 3C. I didn't file it. I never filed a memo. Prior to my coming onto the scene, the bank had filed a memo in one of the connected cases saying that this is not amenable to the jurisdiction of commercial court. It has to go back to the civil court. The then predecessor had passed a order saying no, it is coming within this. Well, it's a matter which has happened inter partes between these two parties, that too on a memo, is being sought to be used against me to say that
you are before the commercial court from the year 2021 or not?
No, it's 21 or 22. I'll have to check.
Let's take it you are before the commercial court in 22.
Please.
When did you file this application?
My lords, this application was subsequent to, first I made an attempt to send it to the arbitration because there is an arbitration clause, admitted. But what happened was because...
So whatever are the possible alternatives,
no, my lords,
one after the other you
I am trying to protect my rights to make my pleadings. My lords, even in this, if I'm given even...
From 1 year, it's also you from 1 year you have taken the stay and you don't pay the process.
No, my lords.
That itself reflects on the conduct of the party also.
There is an order passed in one of the order, on one of the petitions, saying that they are not necessary. In fact, they contain.
If the court passes such an order, or the registry will not, then there would have been an also order that
one of the connected petitions. I remember this very well, which is the reason why we did not take any steps. In fact, all this time it was not coming in.
22 you are contesting till 20, when you realize, when is this IA? IA in the year 25 you realize
This is
that?
in 25, my lords, after my order one, my lord, it will be contradictory for me to seek arbitration and also to seek for transfer, my lords. I can't do that.
No, you want arbitration number one. If arbitration is not working out, then order 6 rule 17.
My lords, it's a matter of jurisdiction.
Then order 6 rule 17 not working?
No, my lords, I have not filed. I have not filed order 6. I am, my lords, I will be,
unfair.
I will be bound by time, my lords. Your lordship make even direct. I do not want to protract the matter.
But one thing I'm making it very clear.
Please.
That issue, whether you can file a written statement or not, is not at all the dispute or the issue that is concerned in this petition.
True.
So
that can be left
if
open.
it has to go to the civil court, it will go to the civil court, but no order on that.
Please, my lord. It can be left open, my lords. I'll agitate before that.
They come to the commercial court, they file for recall to file the written statement.
But ultimately, any order that's passed by court which is not having jurisdiction is a nullity. So unnecessarily it will affect you. So let it go to the civil court. Let it go, say civil court. I will not give any finding on the written statement.
Please.
That's not part of this. Civil court shall proceed from the where it has started. It has left.
Request to the civil court to dispose of expedition, considering the suit of the year 2019, 2020. Any time limit will be fixed. Civil court will proceed with this.
What is the, where are the banks in this? No, is a bank a party?
Party. Subsequently, they have made.
They're not served.
In this petition, they're not served. In the suit, they are served. Some of them are filed a written statement, some of them are contesting, some of them are appearing but not filed.
No, but in that case, their presence is not necessary. Today, we are allowing their application. By this, now the suit will go from commercial court to civil court. Yes. They don't even be put on notice on.
Then there are of the transfer. That may go. I don't object. My only grievance today, Your Lordship, is the delay. If it's for civil court, commercial court,
all these writ petitions or filed agreed with the orders passed with the commercial court in an application that is filed under order 7 rule 10, whereby 10 came to be dismissed. The defendant in the suit is defendant number
1 and 2 minutes. In all the cases,
1 and 2 are before this court. As the parties in all the suits, or the plaintiff and defendant 1 and 2 or one and the same in all the suits. These writ petitions are disposed of by way of a common order. The suit is filed seeking the relief that the sale deeds purported to have been executed by defendant number, different sale deeds in all these suits. The sale deeds that are executed by defendant number 1 and 2 in favor of defendant number 3 is illegal, null and void, and honest in the eye of law, are not binding on the plaintiff. Initially, these suits are filed before the civil court. Later, after the Commercial Courts Act, commercial courts are formed. After constitution of the commercial courts, these matters were transferred to the commercial court. Before the commercial court, the defendant herein, who is a petitioner herein, has taken the plea that there is an arbitration clause and the court has no jurisdiction. That came to be rejected. Again, is that he came here and he filed a writ petition. Writ petition also came to be dismissed. Thereafter, the petitioner has come up with the present application saying that the civil court has no jurisdiction, the commercial court has no jurisdiction, and that came to be dismissed by order impugned in all these writ petitions. The court, while dismissing the application, has observed that the alleged dispute narrated in the plaint come within the ambit of commercial dispute as defined under section 2(1)(c) Roman 6 of the Commercial Courts Act. Considering the same, the court has dismissed the application. Next part. Land Counsel for the petitioner has drawn the attention of this court to section 2(1)(c)(6) of the Commercial Courts Act and submits that it deals with It refers to construction and infrastructure contracts, including tenders. The declaration that the sale deed is null and void, has to be necessarily declared by a civil court, and it is not arising out of a commercial contract between the plaintiff and the defendant, whereas the sale deed that is executed is in favor of the third defendant. As such, the dispute is not a commercial dispute per se, and the commercial court has no jurisdiction. Anything else? The next part, when counsel appearing for the respondent plaintiff submits that the suits are filed in the year 2019. 2021, they are transferred to the commercial court. From 2021, the defendant is coming up with several applications and only with their intention to drag on the proceedings. Because of this, the suit of 2019 is not concluded even till date. It is submitted that it is a commercial dispute, and the commercial court is having jurisdiction. It is submitted that basing on the joint development agreement, this sale deeds were executed pursuant to a joint development agreement. As such, it is a commercial transaction, and contrary to the joint development agreement, as he has executed the sale deeds, they have filed the present suit seeking cancellation. In view of the same, the commercial court has jurisdiction to deal with to try the suit. Next para. Having heard the counsels on either side, there is the material non-record. The relief that is sought in the suit is cancellation of the sale deed, and the same is null and void. That sale deed is executed by defendant number 1 and 2 in favor of defendant number 3. Defendant number 3 is not a party to the contract between the plaintiff and the defendants. And that too, this is a suit is in the form of a declaratory relief. The court has come to the conclusion that this comes under section 2(1)(2)(c)(6). That is construction and infrastructure contracts, including tenders. Looking at the allegations in the plaint, the said observation of the court is contrary to section 2. So and so, as rightly submitted by the learned counsel for the petitioner, the civil court is a competent court to decide this dispute between the parties. In that view of the matter, this court is passing the following order. And it's before that, the third respondent is not served, and except the plaintiff, the other respondents are not served. You appear for? Huh?
46.10 is appearing for
Respondent number 3. In one of the matter, the respondent number 3, only in one matter you are served. In 46. Write the number. In WB number so and so, the third respondent is served. In all other matters, he has not filed the wakalat. It is submitted with the learned counsel of the plaintiff, as it's a suit of the plaintiff, and if the same is transferred as he is affected, he ends the notice to other parties is not necessary, and while transferring the matter, the court can, if this court comes to the conclusion that the matter has to be transferred, the civil court will issue the notice to the parties. Next para. Accordingly, this court is passing the following order. The order passed in in all the cases I number 9. The order passed by the court under order 7, rule 10, read with section 151 CPC is set aside, and is set aside, and accordingly the set aside, and consequentially the order dated so and so is allowed, and the matter is transferred. The petitioner the same is it stands transferred to the civil, to the, which court?
Not state, city civil.
To the city civil court, number 2. This suit is of the year 2019, and it's been pending between,
It's Bangalore Rural District. So there it may have to
For the
go.
Bangalore Rural District.
Yes,
True, true.
Bangalore Rural District.
I don't know exactly which jurisdiction works, but it will be rural. We can verify.
it
and-
stands transferred to
To the
city civil court, Bangalore Rural.
Bangalore Rural District, we decided.
Huh?
To the jurisdictional court in Bangalore Rural. District.
To the jurisdictional court, Bangalore Rural. Number 2, the so-and-so court shall, considering the fact that this matter is pending from 2009, shall expeditiously decide the matter. Number 3, the court shall not grant unnecessary adjournments to the parties.
Great.
At the same stage,
It shall continue from the same stage.
Because after a limit of 1 year if possible.
That we will not, We don't know what is the pendency of that court. Yes, all petitions. How many matters are there?
21.
Huh?
21.
22.
Yes.
Main matters. Say number 47.
My lord, I appear for the petition. I'm sorry, my lord. In the morning, I was held
No,
up
no,
in
it's-
court hall number 2.
It's okay.
My lord, the petitioners are all.
Where is he, Mr. Devraju?
I called him. I said that I have requested to seek passover. He said he will try to come. And even
Can
I
I take it up
requested.
tomorrow in the first place?
No problem.
Tomorrow?
Only my request is that interim order may kindly be extended.
Extend interim order, this is matter in the first place tomorrow.
Much.
Yes, next.
Number 40, 49.
48.
48.
My lordship.
48.
48 here. Not 50.
You didn't mention, you didn't give the number to the court officer.
Beg your pardon. I think somewhere in September date is given. Could it be sometimes during second week of July at least?
48, list this matter on 14th of July.
Much of it.
Interim order is there?
There is no interim order for 10.
Yes, 49.
49.
Lordship,
Give it plus.
application address, order about 26 and rule 9, my lord. It is appointment of surveyor, my lord. The dispute between the survey number.
What is the suit for?
Suit for declaration and injunction, my lord.
Which year the suit is filed?
My lord.
Which year is the suit filed?
The suit is 2020, my lord.
What is the present stage?
For instance, already is PW class exam completed. Now is posted for a dependent evidence. my lord.
Please come to the order.
My lordship, page number 62, my lord. The dependent has filed a written statement with counterclaim. The SPA holder of the plaintiff is examined as PW1 and got marked exhibit P1 to P11 and fully cross-examined. It is not the case of the plaintiff that the dependent has encroached the suit scheduled property. The court commissioner cannot be appointed to collect the evidence. The purpose of the court commissioner is to clarify any dispute matter in a suit, not help the party collect the evidence. A commissioner cannot be appointed to investigate the factual position of the property. A court commissioner can be appointed if there is a valid reason to clarify a dispute matter in suit. Looking to the nature of the suit, fact and circumstances of the case, the appointment of the court commissioner is redundant. The principles laid down in the above the decisions relayed by the plaintiff are not applicable to fact and circumstances of the suit. Hence, the plaintiff is not made bound to follow the IA1.
Where is that IA?
IA, my lordship, in 41, my lord. Page number 41, my lord. Annex C, my lord.
No, what is the necessity at this stage for
My
appointment?
lordship, and is the identification of the property. It is only in the dispute, my lord. Is
Let
two
your
survey
evidence-
numbers. my
No,
lord.
you let your evidence. Now it's coming up for the defendant's evidence. Why did you file this application at this stage?
Lordship, all after the completion of my evidence, my lord, already cross-examination also is completed. Now is posted for dependent evidence. My lord. Is only in the identification of the property is a two survey number adjusted to two survey numbers. My lord. One is my property is fallen to the survey number 143, my lord, and dependent is illegal claiming is 143. It is same survey number.
Yes.
Without I will lead my evidence, I have produced documents also. And so far as the declarative suit is concerned, they have to independently establish their right over the property by producing documented oral evidence. They have produced those documents. Now, the burden is upon the defendant, the plaintiff, to show that their property forms part of survey number 143. I have to establish that the claim of the counterclaim property falls within survey number 142. That's all the thing. Commissioner appointment is not required. No one is actually made the allegations that one encroached upon the other property. But it is not the stage for appointment of commissioner. If court feels after recording the evidence that commission appointment is required to resolve the dispute, as materials are not sufficient to come to right conclusion, then court can actually exercise this discretion.
Order is at page number?
Lordship,
Agreed
page
to
number
the- Yes, yes, I found. Agreed to
62,
the order
ma'am.
passed in I number 1. Notice number 4577 of 2020. Dated 1/6/2026. The plaintiff is before this court. The plaintiff, the petitioner herein, who is a plaintiff in the suit, has filed a suit for declaration and injunction. In that, the defendant has filed the written statement and also sought for counterclaim. After the plaintiff's evidence is completed and the matter is posted for defendant's evidence, at that point of time, the plaintiff has filed the instant application seeking appointment of the advocate commissioner that came to be dismissed by the court by order impugned. Next para. While discussing the application, the court has observed that the plaintiff has filed the suit against the defendant seeking relief of declaration and permanent injunction. The defendant has filed written statement with counterclaim. The SPA holder of the plaintiff is examined as PW1 and got marked exhibit P1 to P11 and fully cross-examined. It is not the case with the plaintiff. The defendant has encroached the suit scheduled property. The court commissioner cannot be appointed to collect the evidence. The purpose of a court commissioner is to clarify any dispute in a suit, not to help a party to collect the evidence. A commissioner cannot be appointed to investigate the factual position of a property. A court commissioner can be appointed if there is a valid reason to clarify a disputed matter in a suit. Looking at the nature of the suit, facts and circumstances of the suit, the appointment of court commissioner is redundant, and the principle laid down in the referred cases relied by the plaintiff are not applicable to the facts and circumstances of the case, and accordingly dismiss the petition. Next part. Land counsel appearing for the petitioner submits that where both the plaintiff and the defendant are seeking declaration with respect to the suit scheduled properties, the appointment of court commissioner is very much necessary, and it will help the court in deciding the dispute between the parties. Court, without considering all these aspects, has dismissed the petition. Next parallel counsel appearing for the respondent submits that when both of them are seeking declaration, they have to they have to adduce evidence, and the burden lies.
The plaintiff also sought for. Plaintiff sought for declaration.
You also filed a counter.
I have filed for counter injunction.
The plaintiff has sought for declaration, and the defendant has filed a counterclaim seeking injunction. It is submitted that the court has rightly observed that there is no dispute with regard to the identity of the property, and the plaintiff has to succeed on the strength of the evidence that is adduced with regard to declaration of title and rightly dismiss the petition. Having heard the counsels on either side, there is a material non-record. The plaintiff's suit is for declaration and injunction, and the declaration and injunction, and the defendant has filed counterclaim seeking injunction. The evidence of the plaintiff is completed. Now it is coming up for the evidence of the defendant. At this stage, at that stage, the petitioner has filed the application. This court has perused the affidavit that is filed, except stating that the appointment of the commissioner is relevant and it would be helpful in deciding the dispute. No other things are stated. The court has rightly observed that there is no dispute with regard to any boundaries. And the petitioner, the plaintiff is claiming title, is seeking declaration, and that he has to prove by adducing necessary evidence. And he cannot, for that purpose, he cannot seek appointment of the commissioner. The court, as rightly held by the court, after the evidence of the adducing of the evidence in the facts and circumstances as it is required, the court would consider the same. But at this stage, it is not necessary for the court to appoint the advocate commissioner. In that view of the matter, this court is passing the following order. The order dated so and so is set aside. This court do not find any merits in the. This court do not find any infirmity with the order passed by the court. Accordingly, the petition is dismissed. However, after the evidence is completed in the facts and circumstances, if it is required, the plaintiff is always at liberty to file an appropriate. This will not preclude him from filing an application, and the court will consider the same in accordance with law.
Number 51, Rajasi.
50?
Lord, it is order 7 rule 11 application. Application has been dismissed. Lord,
What is the suit for?
suit for partition. Separate
On what
question.
ground you filed this application?
Application is, suit is already dismissed before this one submission. 11/12/2066. Lord, the defendant, the defendant, respondent 1 and 3 filed a suit for partition and separate question.
Yes.
OS 126 of 2006. Lord, it has been dismissed. Appeal has been filed. Appeal also dismissed. Then, Lord, respondent 1 to 3 filed a suit for permanent injunction. That has been also dismissed. Now, with your lordship, kindly see the
According to you, it's barred by res judicata.
order. Same cause of action that has been dismissed. Suit for partition. Kindly see the para 42, page number 42.
No, all these facts, what you're stating, is it the case of the plaintiff or is it the case of the defendant? Did the plaintiff state all these things in the plaint about the earlier suits getting dismissed and all?
Suit has been dismissed on merit.
Did the plaintiff state so in the plaint? That's what I'm asking.
Lord,
Come to the plaint.
Kindly see the page number 42, Lord. Page number 42, issues, Lord. 42, Lord.
Not the issues.
No.
We have to see.
It is relevant, Lord. Kindly see. Plain copy is in Kannada, my lord. Is it?
Come to the order.
With your lordship, kindly see that this is 42 issues are framed, Lord. Whether the plaintiff wrote that the suit shall be
Let's see how the court has dealt with. I understood your submission. Please come to the order of the court. Why it has dismissed it.
29, page number 29.
The principle reiterated in the above decision at page 29. Please read from there.
Reverting back to the factual metrics, the defendant 3, 6 and 14 were not made as a party to the proceeding. OS to the OS 126. Furthermore, than the regard to the principle of res judicata application, while dealing with the application filed under order 7 rule 11 CPC, it is relevant to rely on a decision reported 2021-9 SCC 99 in between Srihari and Hemant Vittal Kamath. Since an adjudication of the plea of res judicata requires consideration of pleading issues and decision in previous suit, such a plea will be beyond the scope of order 7 rule 11 D, where only statements in the plaint will have to be pursued. The principle reiterated in the above decision squarely applicable to the case on hand. On the face of it, it does not disclose any fact which depicts that the suit shall be plaintiff is barred by principle of res judicata. The all question
The res judicata is the mixed question of fact and law. When such being the case, without recording evidence, the case cannot be nipped in the bud on the basis of res judicata. It is relevant to note that the Ketenoff decision rendered by the Honorable Apex Court, it is made clear as cloudless sky that while considering
Please
the
come to your IA. Where is it?
para 24 blood. Para
IA affidavit in support of the IA.
It is in Kannada.
File this is matter on 5th of August by the time the translated copies shall be filed.
In meantime, blood. Stay.
No.
The same set of facts. With your Lord's man.
No, I have to understand each.
The plaintiff filed a suit for partition and separate position. That has been dismissed. Same parties have filed the same.
Technical ground, that case was dismissed. Non-joint of necessary party.
The next date of hearing, Land Counsel, the petition shall file the translated copy of the plaint, the IA that is filed in support of the application. Yes.
Short date, maybe short
Date the matter on 13th of July. Yes.
Number 53, Kekrappa.
Please don't tell the senior, this matter on, in the month of August. If they are not coming, what the court can do is. Just call that matter.
Number 78, urgency mentioned matter.
Yes.
Yes, I'm petitioner. Petitioner is a defendant in a suit for partition. Because my IA for recall and reopening the stage of plaintiff's cross-examination has been rejected on the ground that I have not disclosed what are the questions I want to ask. That's the only.
Let's see the order. When was this order passed?
This order is passed on 5th of May, my lords. 2nd of May. I filed it on 1st of June. Soon after the vacations were over, I filed it.
And you have taken your sweet time to comply the office objections.
Because office objections were overruled on the first date itself.
Then when this matter has come up before the court?
No, it's on 4th of June.
If the memo is filed by 9/6/2026, list this matter on 10/6.
Because they have already entered the appearance. The respondents have entered the appearance.
When?
Because they have soon after, in the next commencing week, they have entered appearance.
Who appeared? Who appears? Have you informed him?
Because they were in the court, my lords, when.
Not in the court. You said that the matter will be taken up out of turn.
Correct, my lords. They were in the court when it was mentioned.
Call him. I'll take up. Yes, next.
Cell number 54. 54.
Yes.
Petition challenges not rejection of application under 711.
Where is the other side?
Their entered appearance, my lord, even the cause list shows their name, and Mr. Karnataka.
We'll extend the intermod. Intermod order granted is
Strictly applied.
extended. This is matter on 9th of September. No representation on behalf of the respondent. Yes.
Greatly obliged.
55. 55.
My lord, may I
Neeraj
just-
Karan.
If it could be an early date, I would not take more than 2 minutes, I'm sorry.
No. Interim order is there. You can
I
read.
understand. I'm greatly
Yes.
obliged. I'm greatly-
Cell number 55.
Hearing for the petitioner, my lords. My lords, this is the case.
What are the office objections that are not complied with?
No, my lords, office objections are that, my lords, the impugned order has been passed, my lords, into suits, my lords, which are connected. Common impugned order has been passed, my lords. There are two suits, my lords, and accordingly, the cause title differs, my lords. This petition is with respect to writ petition OS number 2713 of 2018.
Defendant number 2 in OS number so and so are not made parties to WP to be clarified.
Yes.
Copy to be served to the caveators. Sir?
I have served.
I received it.
Millards, defendant number 2 in OS 1017, Millards. With respect to that OS, I have filed the connected petition, Millards. That is 9816, which is connected. There he has been made as parties. This petition pertains to 2713
Yes,
of
what is the order?
Millards, this is the application IN number 22 filed by the petitioners, Millards, to transfer the suit from civil court to commercial court, Millards, as the transaction between the parties is commercial in nature.
That is dismissed?
That is dismissed, Millards.
What is the transaction between the parties?
Millards, this is a sale deed entered into between the parties, Millards.
What is the relief in the plaint?
Millards, relief is Millards, suit by the petitioners, Millards, is to cancel the lease deed, Millards, because it was executed on fraud, Millards. And secondly, Millards, we also seek the recovery of money which we have spent on renovating the building, Millards. Their suit, Millards, they are landlords, the lessors. Their suit is for.
It will fall under which provision?
Please, Millards.
No, it's a commercial transaction.
15 Millards.
It's a lease agreement.
Lease agreement.
Lease
Millards.
agreement. And what happened was this, a lease was executed. It was a residential premises. They wanted it to use it for the purposes of running a catering and other things. That premises was taken from the owner of the property. The lease deed was executed. Suddenly what they said is the lease deed is a fraudulent document. I could not use the premises since it is a residential premises. We don't get permissions from the corporation in the residential area to use it for commercial purpose.
So it arises out of a lease agreement.
Lease agreement, Millards. I have produced the lease agreement, Millards.
Then on what reason the court has dismissed?
No, 1 minute, and I just put it across. What they did is they filed another suit in the first instance saying that this lease agreement to be cancelled as it is obtained by fraud. That suit is the suit for which they filed it in OS 1017 of 2019. 1017 of 2019. Relief claimed in that case was declare the registered lease agreement 15/5/2017 as illegal, fraudulent, hence illegal, null and void and not binding. Consequently, direct the first defendant to execute cancellation, revocation of the deed in favor of the plaintiff as against the aforesaid registered agreement. This is the relief that they sought for. And consequently, they said 64,12,600 is to be paid to them since they had undertaken certain renovations.
Now let's see the finding of the court by the court.
And I'll just point out this is the fact insofar as that is concerned. Thereafter, I filed the suit for ejectment, asking them to vacate the premises. Since you are a defaulter, you did not pay any
That
amount.
is also arising out of the lease agreement.
That also arises from the lease agreement. Now, these suits have been filed in 2019. From 2019, not a rupee is paid. They are in occupation of the premises. They have not paid any rents. They are just dragging on the proceedings for
You have
one
not
reason.
filed any interim application.
I did file.
What happened to that?
The said application is kept pending because matter has reached for arguments. Stage was for argument. At that stage, they filed this present application saying that it comes to a commercial law.
Millards, the stage now, Millards, before the trial.
No, why did you file this? Come to your IA. Why, how suddenly you have realized all this?
Millards.
No, let's see your IA.
But the intent is insofar, the only thing that my lords have to see is whether the intent is a commercial interest or not. That's all. The lease agreement, if is sought for cancellation, it's the prerogative of the civil court to decide. Number two, commercial court can decide, but at the same time, these two suits are being taken together for the purposes of adjudication. Now, take a case where if they say that the lease agreement itself is not put to use, the premises is remained as a residential premises. The intent is residential only. Now, am I not entitled to recover rent? Whether you use it or you don't use it, you don't give the keys of the premises. On every date of hearing, they say we will hand over the keys of the premises.
You have to argue on this aspect, on the merits of the matter, whether it is a commercial. According to you, that has to be before the civil
Premises
court.
is a residential. It remains as residential.
But the purpose.
He cannot use it. He does not use it. It's my fault.
They filed objection, Millards, before the authority, Millards, to not to grant me trade license.
No, that's not correct.
No,
Please
Millards,
make
it
a
is-
proper statement.
Please,
I've
Millards.
been in the court. I have cross-examined your witness. I have shown the documents. Please don't make a correct statement.
Millards,
the
You
lease
did
deed,
not
I have
get any
produced the-
permissions. What can I
have-
do?
my lords, I have produced the lease deed, my lords. No, what is the purpose of wasting the court's time?
That's correct.
My lords, later, at some point of time, if the court feels that it is a commercial transaction and it was wrongly fought before the civil court, my lords. Only for that
Your
reason-
client is not a party in person, he is advised, he has a legal assistance of an advocate.
Please, my lords.
You, from 2018 till 2026, you waste the time of the civil court.
Please,
Now
my lords.
that you will continue it with the commercial court.
That's because of the change of advocate, my lords. After seeing the lease deed, my lords, he has come to the conclusion that the transaction is commercial. He
Come to
has
the,
declared the.
come to the order, impugned, we'll see.
Please.
Page 21.
Page 21 is the order, my lords. Reason starts from page 24, my lords.
Come to paragraph number 9.
Please, my lords. On going through the documents relating to the suit schedule property, it is not a commercial property, but it is a residential property. Plaintiffs in OS number 1017 of 2019 who have filed the present IA have entered into a lease agreement with defendants to take the suit schedule property on monthly rent. And when they attempted to get the commercial license, the authority competent refused to grant license to run business activities in schedule property.
Because it's a residential property.
It's a residential property, my lords, but he himself in 2016 has declared it as a commercial property, my lords, and he has been paying taxes, my lords, to the BBMP accordingly. I have produced the tax paid receipts also, my lords. The last annexure, my lords, in 2016, which is prior to the execution
Where are the
of,
documents?
my lords, page number 135, my lords, is the tax paid property, tax paid receipt, my lords, annexure J. It has been marked in the suit, my lords.
130.
135, my lords. Annexure-
Residential zone classified and declared as taxpayer.
The next column, my lords, your lordship.
135. Which column?
My
There
lords.
are about 12 columns.
Please, my lords, receipt number, the left-hand side receipt number, so and so, dated 29/6/2016, my lords, that is prior to lease agreement. The next column, if your lordship sees, my lords, non-residential zone. Next is residential zone declared by the taxpayer, but as on this date, my lords, the next date says non-residential
No,
zone
you find,
classification
for each
declared.
column, you find the numbers on the top of it.
Please, my lords.
Which column? I'm looking at page 135.
Please, my lords.
There is 1, 2, 3, 4, 5, 11, 12 columns are there. Is it there or above?
Is it?
Is it non-residential classification declared by
Non-residential
tax?
zone classified declared by
the
taxpayer.
taxpayer. It is reflected in the lease deed also, my lords. The covenant is that I have to reimburse the tax paid on non-commercial basis to the landlord, my lords. It is there in the lease
And
deed also.
this observation of the court contrary to the evidence on record.
Paying, the zone is commercial zone. What they say is non-residential zone classification declared by taxpayer. It's a classification that is declared. But the premises is residential. Kindly see the lease agreement. Kindly see the lease agreement.
Where is
Lease
your-
agreement.
Where is your
Lease
written-
agreement is
Let us look
produced-
at your written statement. Where is the written
110.
statement?
One zero one seven.
110 is the agreement of lease.
106, your lordship sees, my lords.
10.
116, my lords. 116, lordship sees. Lessee approached and requested, my lord, second para, whereas the lessee approached and requested the lessor to grant the lease of scheduled premises to him for manufacturing and sale of food, bakery, ice cream, sweets, hotel catering business on rent and security deposit.
And
for
where do
10
you
years.
get that he has to pay the
Please,
commercial?
my lords, that is in page number 128, my lords. 128, clause number 5.
Yes.
Property taxes, BBMP self-assessment scheme. Property tax shall be paid by the lessor, but lessee is liable and shall pay to the lessor from the year 2017-18 and onwards till lessee vacates. BBMP SAS taxes all the total taxes payable in excess to than paid by the lessor for commercial
for 2016-17.
Where do you get that
any-
commercial? Are you reading that clause number 5?
Clause number 5, my lords. May I read, my lords? Property
Where are you
tax,
getting this commercial?
fourth line, my lords.
For commercial for 2016.
16-17. My lords, in the next covenant, my lords, the lessee shall use the scheduled premises portions for manufacturing and sale of food, bakery, ice cream, sweet, hotel, catering. Because this is a specific sanctions, rules, regulations that are mandatory from time to time and shall not use for any other activities or shall not carry on any illegal or unauthorized activities or business prohibited by law in the said premises.
Yes,
This
please
is the
come.
covenant.
But
Please
this
come.
is sought to be cancelled.
Hmm?
This they are seeking cancellation.
The order is at page?
Page number
21.
18, my lords, it starts. Page number 25 is the
Agreed with
reason.
the orders passed in. I number 22. Invoice number 2. OS number 1017 of 29, clubbed with OS 2713 of 2018 and OS 2713 of 2018. Now what will happen? Which suit you're seeking? You didn't make all of them as parties, other.
In the connected petition, I have made the other
They have to
person
be made parties here also.
No, it's all the suits are clubbed.
club, my lords. Since if the order
Clubbed
binds
in the
both the
beginning
petitions
itself.
is what I would say. my lords.
Before the trial,
There
joint
a
trial is.
connected petition, my lords.
Where is the
So,
connected petition?
9816, the connected petition.
Next matter.
Yes, my lords. In that, I have made the other person as
Then
party.
what about notices to them?
Lords, it is the son of the respondent here in my lords. Mother and son are the
Yeah, I think he has not. Been.
dependents.
I may have to take steps on him. Make a request and then.
You don't represent them? Are you representing them before the trial court?
Yes.
But mother I was representing.
Son is not
Here I
representing.
don't.
Lords, here he does.
Common evidence is let in.
No, you are
No,
not representing son and
I
both
just-
of them.
I'll seek instructions by tomorrow or day after. I'll make it.
This is matter on the top of the list on 2nd July. Land counsel for the petitioner, the petitioner, land counsel, the petitioner submits that the counsel for the respondent number for 2 is representing respondent number 1 also before the court, and the counsel seeks time to get instructions.
That's,
That
tomorrow
they will
is
pass
the
orders,
day.
huh?
Tomorrow is the
They
day.
shall be, this court has already heard the matter. As the notice is not served in the respondent, the matter is adjourned. Till the next date of hearing, they shall be stay of all further.
No, I am not going to precipitate and all that.
Land counsel for the respondent submits that they are not going to precipitate the matter. So no interim order is required. Next.
But rents are not paid.
Huh?
Should I not get
They have
rents?
kept their
Is
IFRS.
that the way?
On that day, you can, we will see what is to be done.
That's
No, when
something.
the matter is coming up on
Thing,
second,
Lord, which definitely causes, we have to pay tax, we have to do everything.
that's why on 2nd July, we will
And
decide.
all GSTs have to be
Get
paid.
instructions from the second and first respondent also.
I'll do that.
That day we will consider about that.
But that's more important, Lord, because
We'll see.
you can't keep
Your
the
application
premise.
is pending consideration. You don't pursue it. What is the court can do now in this?
But I have been insisting. They said we'll give the
We'll
keys.
see, we'll see. Yes, next part. You better comply the office objection so that it will be clear.
Please, my lords, I should do it.
The office, by the next date of hearing, office objection shall be complied with. Yes, next.
Till number 56.
Appearing to the petitioner in this case, Your Lords.
Respondent number 11 in this.
Common order under 1 Rule 10 with reference to 3 defendants to be impleaded, Your Lords. A common order is being passed. So the maintainability may be overruled, Your Lords.
What are those IAs?
Rule 10, 1 Rule 10, both IAs are 1 Rule 10, Your Lords.
Two suits?
Yes, Your Lords. No, single suit. The suit for partition, Your Lords. The 2 IAs were filed under 1 Rule 10 for defendants to be impleaded, 2 defendants to be impleaded.
So now the court will pass order that one defendant to be impleaded, others not. Office objection with regard to the maintainability is upheld and the petition shall comply. with office objections.
Lords, tomorrow the matter is listed for arguments.
What can we do? So if you want to restrict only to one writ petition, that writ petition I'll hear.
Lords
We'll
may
take
have-
it up on, this matter on Thursday. By that time, whatever you want to do. If the office objections are complied, list the matter on Thursday. Yes?
Okay.
Day after tomorrow.
Cell number 78, urgency mentioned matter.
70?
Yes, petitioner is a different.
Yes.
Petitioner is a defendant in a suit for partition, my lords. My application for recalling the cross of plaintiff has been rejected. My lords, there are two reasons which have been, their objection is that it's filed at a belated stage, my lords. It was filed in the year 2023. It was disposed of in 2026. Since there was a stay of proceedings on a different IA before the coordinate bench. Coordinate bench has disposed of the writ petition, allowing the writ petition was disposed of with a direction to dispose of the entire suit within 6 months. Plus, after that, I have led the evidence. After the evidence, it was brought to the court's notice that IA number 11, 12 are pending and that needs to be considered. That application has been rejected on the ground that I have not said what are the questions which I have.
Come to the order.
Page number 82, my lords, is the reasoning.
Yes.
Para 8, fourth line. In the applications, counsel for defendant has not mentioned any reason why this witness has to be recalled and what are the questions are left during the cross.
When was the matter posted for argument?
Lords, it was posted on the on 16/4.
16/4?
2026.
2026.
Allah.
You're saying that the IA is filed in 2023.
Please.
So then prior to that, it must have been posted for argument.
Lords, what happened is in 2023, I had filed an application for recalling the witness.
What was the stage then?
At that point of time, I had filed another application. My defendant evidence was the stage back then. After that, the honorable.
No, the difficulty is you have to be specific about the dates. So those are all relevant.
Let's kindly take the application, which is at page number.
No, you please look at the application and tell the court the dates.
70,
Counsel for the
27.
defendant has already cross-examined in length to the above mentioned witnesses more than 6 occasions.
Lords, my
The
application.
application counsel for the defendant has not mentioned any reason why this witness has to be recalled and what are the questions are left during the cross. Come to your application. What did you say? Why you want to recall?
Page number 105. IA number 11. The affidavit is at page 106.
Yes.
Affidavit is at 106.
Please
Third-
show the reason. Which para?
Third paragraph. I state that the plaintiff has filed present suit on so and so. Plaintiff has also admitted the date of death of her father on so and so. Further, the mother of the plaintiff and defendant died on 30/7/2015 and has not given any explanation except they say that the plaintiff has no knowledge of the partition under Exhibit P4. The plaintiff has suppressing the material facts on receiving amounts, presentation, gifts and gold given by her father and brother and further denying the developmental assistance in developing her husband's properties and filed the suit 4.5 years later stating that she was not invited to partition and she has no knowledge about Exhibit P4 partition deed, which is all to be proved by the plaintiff by adducing evidence further that she has to prove that she has not received any amount, services, gifts and huge quantity of gold from her father's family and she has not supported any contention to the evidence as to the receipts of huge sum and financial assistance given to develop her husband's properties. I state that it is the, again, the second paragraph.
Court was right. Order was, the court was right in observing that.
Para 10.
I've seen your, the entire affidavit. Nothing. You just, like a written statement, you recite everything, you deny everything.
No. She is the plaintiff.
I know that. I understand that.
I have to cross-examine her on the assistance which was given.
That you have done 6 times. What is the reason now?
ಅದರಲ್ಲಿ ಕೆಲವು questions after my defendant evidence there are certain
What are those certain, your affidavit doesn't say?
that I cannot say it.
No, not the questions, nothing, you just say that you have to want
I
it.
just need 20 minutes of one opportunity to cross-examine.
Yes.
One opportunity, I'll not take any further
Several times they have to cross-examine.
No, we'll give him once on cause that to be completed within 1 day.
Only their intention to only to drag on the
That's what I'm saying.
proceedings.
We'll say,
And because they are
we'll indicate a day and on cause we'll allow this. And if the, also direct the court to complete expeditiously dispose of the suit.
single day cross-examination may be
Single day.
within a day.
One day.
Within a day.
Please come. Where is the order?
82, my lord, page 82.
Cost, how much?
I'll pay 5,000.
Huh?
I'll pay 5,000.
If you yourself are saying 5,000, then it should be 10,000. Where is that order? Page number? Page number, order.
82, my lord.
82. The present writ petition is filed agreed with orders passed on I number 11 and 12 in OS number 52 of 2018, dated, this order is dated
Lords 2/5.
2/5/2020.
27/4, my lord, sir. 27/4/26.
27/4/2026. The defendant is before this court. The present application is filed to reopen the evidence of the plaintiff's side and to recall to PW1 for the purpose of further cross-examination. The court by order impugned had dismissed the application, observing that on perusal of the evidence of the above witnesses shows that counsel for the defendant has already cross-examined in line to the above mentioned witnesses more than 6 occasions. In the application, counsel for the defendant has not mentioned any reason why this witness has to be recalled and what are the questions are left during the cross. And hence the court felt that there are no reasons to recall PW1 for further cross-examination and accordingly dismissed the application. The INML 11 and 12. Land counsel appearing for the petitioner submits that one opportunity is given to the petitioner. One opportunity is given to the petitioner. He will cross-examine PW1. The petitioner has no intention to drag on the proceedings. Next parallel counsel appearing with the respondents. On several occasions, he has cross-examined the witness and only with an intention to drag on the proceedings. The petitioner, the defendant is coming up with one application of the other and the court has rightly dismissed the application. Next parallel. Having heard the counsels on either side, peruse the material non-record. It is a case of the petitioner that he has filed this application in the year 2023 and the same is decided in the year 2026 and he is requesting only a day's time to conclude the evidence and he will not seek further time and reopening the case and cross-examining the PW1 is further cross-examination of PW1 is very much in the interest of to prove very much to substantiate the case of the defendant. Next paragraph, having heard so and so, considering the fact that I have said the contentions of the respondent is recorded. Considering the fact that the suit is now posted for
argument.
Posted for argument. No doubt, the court was right in observing that it's a belated application. However, considering the substantial interest of the parties and also balance the interests of the parties, this court deems it appropriate to allow this application on cause and also by fixing a time frame. Accordingly, this court is passing the following order. The order dated so and so is set aside and the order dated so and so is set aside. Consequently, I number so and so is allowed. The petitioner number 2, the petitioner shall cross-examine PW1 on a date. Shall I fix a date or
on the next date of hearing?
On the next date of hearing?
Can it be on 4/7, my lord, this Saturday? 4/7.
No.
Alla.
On the next date of hearing.
Next
Shall
date is tomorrow, my
cross-examine
lord.
the.
I had to travel from here. It's in Chennagiri. Let it be on 4th.
Go tomorrow. Let it be day after tomorrow.
Unless I'm asking a reason.
I will not grant time.
4th, my lords, 4th
No.
of July,
No.
at least on 1st or 2nd of July, my lords.
It should be either maximum, it could be on 29th. On 29th,
Can it be on 27th, my lords? It's Saturday.
yes, 27th, the petitioner shall cross-examine, the petitioner shall cross-examine the witness. And if the petitioner does not go ahead with the same, is right to, the court shall close the same and proceed with the case. Next one. Considering the fact that this was posted for arguments, the court shall expeditiously dispose of the matter. Cost of rupees 5,000, I said. Is allowed at the cost of 5,000.
They need not to wait for the order of this.
Huh?
They need not to wait for this order.
27th, and I myself have told 27th. That's the question.
Yes.
Great.
Some matter, somebody was mentioning some six, that, where is your matter?
60.
Huh?
Item number
57, from 57 onwards.
60?
That's 57, I'm appearing for the.
60.
CRP 515 of 2026.
No, morning he was mentioning that some
Very well.
warrants were issued. Yes.
60.
Yes, my lordship. My
Yes.
lordship.
Where is the other side? 67?
My lordship, I served the copy to them yesterday in the office, and their caveat is also expired, my lordship. I hope there is no bar to proceed, my lordship. It's an urgent matter.
This is 60. Nagaraj Gupta. Hmm. Yes.
Yeah, my lordship. So before I address the core minutes of this urgent revision, my lordship, I wanted to check on the authority and majesty of the court listing, my lordship. On Friday, I submitted the memo of urgent listing for the execution of the decree that I predicted. On my lordship, based on the urgency, you allowed our application, allowed our memo, and they listed the matter on the Monday. Intermediately, what happened, my lordship, on Saturday, an execution occurred, my lordship. To the court belief, we informed that we requested that, sir, we require 48-hour permission, sir. Monday, the listing is there. Our compliance are
You
clear.
know, he is not bound by all that. Please come to the order. Unless until there is a stay by the court, he is not bound by all your submissions and all your requests.
Yes, my lordship. I crave the leave of this court to place all three interim application filed along with this petition, my lordship. IN number for interim stay, IN number 2 for dispensation of certified copies, IN number 3 for condemnation of a marginal 20-day delay, my lordship. My lordship, dealing first with the procedural application, I pray for the allowance of the IN number 3, my lordship, for the condemnation of delay. The technical deficit of 20 days was entirely beyond human control, my lordship. It's more on the medical reason, my lordship. I have affixed the annexure H and annexure F, where there was a surgery that was occurring at the same time, and also, my lordship, I am physically incapacitated.
What is the suit for? Before you reading all that, you please answer to my queries.
It's suit for eviction, my
What is the
lordship.
suit for?
Suit for eviction.
When was it decreed?
It's on Feb 10th, my lordship.
10th February. But did you contest that suit?
Yes, my lordship.
Then have you questioned that order?
No, my lordship.
Why?
My lordship, the legal advice was not given to me, my lordship. That was the only reason, my lordship. I personally went to his home, and he's physically incapacitated, my lordship.
You understand that these kind of submissions, these are not legal submissions you're making.
Yes, my lordship.
Suit, they're running a beauty parlor.
Yes,
Yesterday
ma'am.
you said.
Yes, my lordship.
Hmm.
Yeah.
And they are no legal advice to file an appeal. That's why they have not filed the appeal. And you want the court to stay the execution.
Yes, my lordship. So along with that, I submitted the medical document, my lordship.
Along with what?
Along with the petition, my lordship. I have attached the annexure.
Are you not supposed to file appeal at least now? Once it come to your notice, you should file an appeal or not?
Yes, my lordship.
And without filing the appeal, why should the executing court stall these proceedings?
Yes, my lordship. I agree with that, my lordship. So presently, the execution of the delivery warrant has happened, my lordship. But all the furniture and items are still intact, my lordship. My livelihood is impacted. So with that being the reason, I pray for your humble request that where I have lost all the remedies, and I come here in front of you.
You have not lost all the remedies. You are not availing any of the remedies available to you.
Yes, my lordship.
You have not exhausted your remedy of appeal.
My lordship, on Saturday, I filed a CPC of 151 for a stay of the execution, my lordship. So the executing court told that it does not have jurisdiction to stay for the order that is already been granted. So the authority of yours, I pray for it, my lordship.
I'm sorry, I can't pass any orders in this.
Until my lordship, an interim stay would be helpful, my lordship.
Next.
Interim stay would be helpful, my lordship.
Next.
Still number 57. Still number 57.
For the respondent, please.
SK Mithun.
Lords, my lord, sorry to interrupt the learned counsel. The arguing counsel in this matter, there's been a death in his family, my lord. If the matter is taken up tomorrow, we will place our objections on record.
Tomorrow in the first list.
Please, my lord, much obliged.
Yes. This many matters later.
Serial number 58, my lords.
All the matters, it's a passed over matter.
Please, my lord.
It will come in the first list tomorrow.
Please, my lord.
And all the matters, you please
Top of
tell the court officer, I have instructed her, all matters, interim orders will be extended. And wherever if the matters are coming up before the trial court, they will be taken up in tomorrow's list. So no mentions to be made.
My lord, item 70.
Whatever remaining first list matters should be repeated in the first list.
I make a humble submission, my lord. The matters passed over, serial number 62 and 63.
I'm in the first list.
My lord,
Can I
mine is a
seek for
KB
day
matter.
after tomorrow, my lord. Tomorrow there's some inconvenience.
If you want,
My lord,
court
mine
is
is.
section.
Touch up.
Madam, 58 tomorrow. Madam, 75 KB matter. Adu. Madam. 58 tomorrow.
Madam, serial number 70, naale, madam.
Orders matter change ಮಾಡ್ತೀರಾ second
Madam, serial number 31.
Matters, sir, ಸ್ವಲ್ಪ ಕೇಳ್ಸಿ. All the matters in list number 1 will be repeated as it is in tomorrow's first list.
Okay, madam.
ಅದರೊಳಗಡೆ ಯಾರು ಬೇಡ ಅವ್ರು ಹೇಳಿ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಯಾರು ಬೇಡ?
ಎಲ್ಲ ನಾಳೆ same first.
Madam, 72.
62 and 63 day after tomorrow, na? In all other matters will be repeated. In list number 2,
Madam, list number 2, 31 nodi. Serial number 3 nodi.
Madam.
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ನಾಳೆಗೆ ಬೇಡದಲ್ಲೇ ಇರೋರು ಮಾತ್ರ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಯಾವುದು? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಡೇಟ್ಸ್ ಅಂದ್ರೆ 29ಕ್ಕೆ ಬೇಕಾ? ಯಾವ್ದದು? 72 29. ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ ಹೇಳಿ. ಆಮೇಲೆ ಇನ್ಯಾವ್ದು ನಾಳೆಗೆ ಬೇಡದಲ್ಲೇ ಇರೋದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ? ಒಂದ್ ನಿಮಿಷ. 68 ಏನ್ ಹೇಳಿ?
Next month.
Next week ಅಲ್ಲಿ ಕೊಡಿ.
Next week.
60 ನಾಳೆಗೆ ಬೇಡದಲ್ಲೇ ಇರೋದಂತ ಒಂದ್ ತಿಂಗಳು ಮುಂದಕ್ಕೆ ಡೇಟ್ ಕೊಡಕ್ಕೆ ನಮಗ್ ಪ್ರಾವಿಷನ್ಸ್ ಇರಲ್ಲ. ರೀಸನಬಲ್ ಟೈಮ್ ಹೇಳ್ಬೇಕು ನೀವು.
66, 68 corrected matter. So next week. 66 and 68.
66 and 68 ಯಾವತ್ತಿಗೆ ಬೇಕು? ಅದರ್ ಸೈಡ್ ಇಂದಿರಾದಲ್ಲಿ 66 and 68 ಅಲ್ಲಿ ಅದರ್ ಸೈಡ್. ಇದು
Sir, second July. 29th. ಅಲ್ಲ, second July. Second July ಸ್ವಲ್ಪ inconvenience.
Second July 66 and 68. ಇದ್ರೆ ಎಲ್ಲಾನು ಕೊಡಲ್ಲ. ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಬಿ ರಿಪೀಟೆಡ್.
Please repeat 75.
29ಕ್ಕೆ 67 ನಾಳೆ ರಿಪೀಟ್ ಬೇಡವಾ? 29th 29/6 ಎಂಟ್ರಿ ಮಾಡ್ರಲ್ಲ, ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾರೆ ಡೇಟ್ ಮಾಡ್ತಾರೆ. 63 29th ಬೇಕಾ? 63 ಆಲ್ರೆಡಿ ತಗೊಂಡಿದ್ದಾರೆ ಅವ್ರೆ ಡೇಟು. ರೀ ಇವಾಗ ಸಬ್ಮಿಟ್ ಮಾಡಿರಲ್ಲ 62 and 63 somebody has ಅಲ್ಲ somebody submitted and they have ಇವರೇ ಅವ್ರ ಅದರ್ ಸೈಡ್ ಸ್ಕಂದ ಕುಮಾರ್ who is he mentioned and he has taken the ಸರ್ ಅವ್ರು ಇದಾರೆ ಸ್ಕಂದ ಕುಮಾರ್ ಆಪೋಸಿಟ್ ಸೈಡ್ ತಗೊಂಡಿರೋದು ಇವರೇ ಬೇಡ ಬಿಡಿ ಜುಲೈಗೆ ಹಾಕ್ಬಿಡೋಣ ಬಿಡಿ ಜುಲೈಗೆ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಸರ್ ಇದಕ್ಕೆ ರಾಜೇಶ್ವರ PN ಅಲ್ಲಿ ಜುಲೈ 16th ಕೊಡಿ 16 ಜುಲೈ ಬೇಕಾದ್ರೆ ಅವ್ರು ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್ ಸ್ಕಂದ ಕುಮಾರ್ ಇಲ್ದಲ್ಲ ಇದ್ರೆ ರಘುನಾಥ್ MD ಇಸ್ ಫಾದರ್ ಅನ್ಸುತ್ತೆ ಅವರು ಸ್ಕಂದ ಕುಮಾರ್ ಫಾದರ್ ಅವರು
ಲಿಸ್ಟ್ ಬಂದ್ಬಿಡಿ ಮೇಡಮ್
62 63 ಪಾಸ್ ಓವರ್ ಮಾಡ್ಕೊಂಡಿದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ ನೋಡಿ ಹಿಂಗ್ ಹೊರಟೋಗ್ಬಿಡ್ತಾರೆ ಅದರ್ ಸೈಡ್ ಇದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಲ್ವಾ ಇದ್ರೆ
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ತಗೊಳ್ಳಿ ಮೇಡಮ್ ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ತಗೊಳ್ಳಿ
ಯಾವ್ದು ಡೇಟ್ ಕೊಡಲ್ಲ ಟುಮಾರೋ ಇಟ್ ವಿಲ್ ಬಿ ರಿಪೀಟೆಡ್
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2
ನನಗೆ ಡೈರೆಕ್ಷನ್ ಇರುತ್ತೆ ನಾಳೆ ರಿಪೀಟ್ ಮಾಡಿ ಅಂತ ನೀವು ನಾಳೆ ಇಲ್ದಲ್ಲ ಇದ್ರೆ ನಿಮ್ ಜೂನಿಯರ್ಗೆ ಯಾರಿಗಾನ ಹೇಳ್ಬಿಟ್ಟು ಅದಕ್ಕೆ ಫಸ್ಟ್ ಅವರಲ್ಲಿ ಡೇಟ್ ತಗೊಳ್ಳಿ
ಲಿಸ್ಟ್
ಬೇರೆಯವ್ರಿಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ ಕೇಳಿ ಅವ್ಳು ಪಾಸ್ ಓವರ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ರು ಅದನ್ನ ಪಾಸ್ ಓವರ್ ಮಾಡಿಸ್ಕೊಂಡು ಆರ್ಡರ್ ಆಗಿದ್ದು ನಿಮ್ದು ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 74 ರೀಚೇ ಆಗಿಲ್ಲ ಅದು ಅನ್ರೀಚ್ಡ್ ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಡಲ್ಲ ಅನ್ರೀಚ್ಡ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ ನಾಳೆ ಬಂದು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ನೀವು
ಕೊಡ್ತಾರೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್ BC ನಲ್ಲಿ ಇದೀವಿ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ BC ನಲ್ಲಿದ್ದಾರೆ. Court officer. Sir, list number 2, party in person. ನಾಳೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಸರ್?
ವೇಟ್ ಮಾಡಿ ಸರ್, ಎಲ್ಲರಿಗೂ ಡೇಟ್ ಕೊಡ್ತಾರೆ, ವೇಟ್ ಮಾಡಿ.
ಓಕೆ ಸರ್.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 31 ನೋಡಿ ಮೇಡಮ್. ಮೇಡಮ್ ಸರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಏನ್ ಮಾಡ್ತೀರಾ ಮೇಡಮ್? ಆರ್ಡರ್ಸ್ ಏನ್ ಮಾಡ್ತೀರಾ ಮೇಡಮ್?
ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಡೇಟ್ ಹೋಗುತ್ತೆ ಸರ್. ಜುಲೈ 15th ಡೇಟ್ ಇಲ್ಲ ಆಗಿದೆ. 16th ಇಂದ ವಿ ವಿಲ್ ಅಸೈನ್ ದ ಡೇಟ್ಸ್, ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ನೋಡ್ಕೊಳ್ಳಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 31 ನಾಳೆ ಕೊಡಿ ಮೇಡಮ್.
ಲಿಸ್ಟ್ 2 ಮೇಡಮ್.
ಇದ್ರೆ ಅದ್ರಲ್ಲಿ ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ನೋಟಿಸ್ ಇದೆ. ಎಲ್ಲಿ ಇಲ್ಲ ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಇರೋದ್ರಿಂದ ಅದು ಕೊಡಕ್ ಆಗಲ್ಲ. ಇವ್ರೆ ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ R1 to R4 ನೋಟಿಸ್ ಇಸ್ ನಾಟ್ ಸರ್ವ್ಡ್. ಅದೆಲ್ಲ ಜುಲೈ ಆನ್ವರ್ಡ್ಸ್ ಅದರದ್ದೆಲ್ಲ ಕೇಳ್ಬಿಡಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಕೇಸು ಇತ್ತು ಅಂದ್ರೆ ಮಾತ್ರ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಅದರ್ವೈಸ್
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಅರ್ಜೆಂಟ್ ಇದೆ ಮೇಡಮ್.
11 ನಾಳೆ ಸರ್.
ಮೇಡಮ್ 3 ಅರ್ಜೆಂಟ್ ಇದೆ ಮೇಡಮ್ ನಮ್ಗೆ. ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಅರ್ಜೆಂಟ್ ಇದೆ
ಸರ್. ನೀವು ಆತರ ಎಲ್ಲ ನಾನು ನೆಕ್ಸ್ಟ್ ವೀಕ್ಗೆಲ್ಲ ನಮ್ಗೆ ಬೋರ್ಡ್ ಫಿಲ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಸರ್. ಜುಲೈ 16th ಇದೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಅರ್ಜೆಂಟ್ ಇದೆ ಮೇಡಮ್.
5/16/7 ಏನ್ ಹೇಳಿ ಸರ್?
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಅರ್ಜೆಂಟ್ ಇದೆ ಮೇಡಮ್.
ನಾಳೆ ಇಲ್ಲ 25/6
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಅರ್ಜೆಂಟ್ ಇದೆ ಮೇಡಮ್.
ಡೇಟ್ ಕೊಡಲ್ಲ, ಅದು ಜುಲೈಗೆ ಹೋಗುತ್ತೆ.
ಮೇಡಮ್ ಒಂದ್ಸರಿ ಸೀರಿಯಲ್ ನಂಬರ್ 3
16/7 ಇವ್ರೆ ಅದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇದು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವಾಗಿದೆ ಕೇಸು? ನಾಳೆ ಸಬ್ಮಿಷನ್ ಮಾಡುವಾಗ ನೀವೇನಾದ್ರು ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಮಾಡಿದ್ರೆ ಬೇರೆ ತರ ಆರ್ಡರ್ ಆಗುತ್ತೆ.
ಒಂದೇ ಮ್ಯಾಟರ್ ಅದು 3 ರಿಪಿಟಿಷನ್ ಇರೋದು ಒಂದೇ ಕೇಸ್.
85 ನಾಳೆಗೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಅದು. ಹೇಳಿ 27 ಏನು? ಅದೇ ಇವ್ರೆ 16/7 ಸರ್. ಡೇಟ್ಸ್ ಎಲ್ಲ ನಾವು ಅಸೈನ್ ಮಾಡ್ತೀವಿ. ನಾಳೆಗೆ ಅರ್ಜೆನ್ಸಿ, ನಾಳೆ ಬಿಟ್ಟು ಬೇರೆ ಯಾರು ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಡಿ
ಮೇಡಮ್. 58 ನಾಳೆ ಹೇಳಿದ್ದಾರೆ
whenever the date is given, wherever the interim orders are there, it will be added.
ಮೇಡಮ್ ನಾಳೆ ಹೇಳಿದ್ದಾರೆ ಒಂದು ಡೇಟು.
ಮೇಡಮ್ 75 ಮ್ಯಾಟರ್.
22 ಏನು? ಅಲ್ಲಲ್ಲ ಅರ್ಜೆಂಟ್ ಡೇಟ್ ಅಲ್ಲ, 16/7 ಸರ್. 22/16/7
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 75.
ಎಲ್ಲದಕ್ಕೂ ಡೇಟ್ ಕೊಡ್ತೀವಿ, ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡಿ. ನಾವು 16 ಜುಲೈ 16th ಆನ್ವರ್ಡ್ಸ್ ವಿ ವಿಲ್ ಅಸೈನ್ ದ ಡೇಟ್ಸ್. ಯಾವುದು ನಾಳೆಗೆ ರಿಪೀಟ್ ಇವ್ರೆ ಅದು? ಇವ್ರೆ ನೀವೇನು ಸುಮ್ನೆ ಆಟ ಆಡ್ತೀರಾ? ಅದು ನಾನು ಈ ತರ ಎಲ್ಲ ಆದ್ರೆ ಮೇಡಮ್ಗೆ ಹೇಳ್ಬಿಟ್ಟು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ ಅಷ್ಟೇನೆ. ನಿಮ್ಗೆ ಹೇಳಿದ ಡೇಟ್ಸ್ ಎಲ್ಲ ಕೊಡಿ ಅಂತ ನನಗೆ ಡೈರೆಕ್ಷನ್ ಇಲ್ಲ. ಇವ್ರೆ ಬೇರೆ ವರ್ಗ ಬೋರ್ಡ್ ಇಸ್ ಇದೆ ಅಂತ ಅಲ್ಲಿ ಹೇಳಿರೋದು.
ನಾಳೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಸರ್ ಬೇರೆದೆಲ್ಲ ಡೇಟ್ಸ್ ಅಪ್ಡೇಟ್ ಆಗುತ್ತೆ ನೋಡ್ಕೊಳ್ಳಿ.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಮೇಡಮ್?
ಸರ್ 71 ರಿಪೀಟ್ ಆಗುತ್ತೆ. ನಾಳೆ ಬಂದಾಗ 10:30ಗೆ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಸರ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 8 ನಾಳೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಮೇಡಮ್.
ನಿಮ್ ಅಡ್ವೊಕೇಟ್ ಇಲ್ವಾ ಸರ್?
ಇಲ್ಲ, ನಾವು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಇದ್ದೀರಾ ನೀವು?
ಹೌದು, ನಂಬರ್ 8 ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಬೆಳಿಗ್ಗೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿದೀವಿ ಮೇಡಮ್.
ಒಂದ್ ನಿಮಿಷ. 8/16/7
ಇಲ್ಲ ಮೇಡಮ್, ನಾಳೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದೀವಿ ಮೇಡಮ್ಗೆ. ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು, ಇನ್ನೂ ಬಂದಿಲ್ಲ.
ಸರ್
ಇನ್ನೂ ಬಂದಿಲ್ಲ ಮ್ಯಾಟ್ರು.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಪೆಟಿಷನರು ಡೇಟ್ ತಗೊಂಡೋಗಿದ್ದಾರೆ 16/7.
ನಾನೇ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮೇಡಮ್, ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್.
You are the respondent party in person where the advocate for the petitioner requested time for 16/7.
ಅದೇ ಏನಕ್ಕೋಸ್ಕರ ಕೊಟ್ರು ಮೇಡಮ್? ನಮ್ಗೆ ಇಂಟಿಮೇಟ್, ನಾವು ಬೇಡ ಅಂತ ಹೇಳಿದ್ವಿ. ಈಗ ಹೇಳಿದೀವಿ, ನಾಳೆ ನಾವು ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀವಿ. ಮೇಡಮ್ಗೆ ಇದಾಗ್ಲಿ, ಅದ್ ಬೇಡ ನಮ್ಗೆ ಡೇಟ್. ಅವ್ರಿಗೆ ಹೇಳಿ ನೋಟ್ ಮಾಡಿ ಮೇಡಮ್, ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಇದ್ ಮಾಡಿದಿರಾನೆ ಮಾಡಿದಾರೆ. ನಾವು ಬೆಳಿಗ್ಗೆಯಿಂದ ಕಾಯ್ಕೊಂಡಿದೀವಿ ಮೇಡಮ್ ಸಬ್ಮಿಷನ್ ಮಾಡಕ್ಕೆ. ಈ ತರ ಸಡನ್ ಆಗಿ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಮಾಡ್ಬಾರ್ದಾಗೈತೆ ಅಲ್ಲ ಮೇಡಮ್? ನಮ್ಮನ್ ಕೇಳಿದಿರ ಅವ್ರಿಗೆ ಹೆಂಗ್ ಕೊಟ್ರಿ ಮೇಡಮ್? ಕೊಡ್ಬಾರ್ದು. ನಮ್ಗೆ ಇಂಟಿಮೇಷನ್ ಮಾಡಿ
ನೀವು ನಾಳೆ ಕೋರ್ಟ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ 16/7 ಡೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು.
ಜಡ್ಜಿ ಕೇಳ್ರಿ, ನಮ್ಮನ್ ಕೇಳ್ದಲ್ಲ ಹೆಂಗ್ ಕೊಟ್ರಿ ಅಂತ.
ಈಗ ನೀವು ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೇಡಮ್ ಬಂದಾಗ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಪೆಟಿಷನರ್ ರಿಕ್ವೆಸ್ಟೆಡ್ ಫಾರ್ 16/7, ಯು ಆರ್ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್, ಈ ಹ್ಯಾಸ್ ಟೇಕನ್ ದ ಡೇಟ್ ಅಂತ ನೀವು ಬೆಳಗ್ಗೆ 10:00 ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಅದು ನೆಕ್ಸ್ಟ್ ಫರ್ದರ್ ಅಲ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂದ್ರೆ ಮಾಡಿಸ್ತೀವಿ.
ಅದೇ, ಯಾಕೆಂದ್ರೆ ಮೇಡಮ್ ಲಾಸ್ಟ್ ವಿಡಿಯೋನು ಸ್ವಲ್ಪ ಬೆಳಿಗ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗೋಯ್ತು. ಬೆಳಿಗ್ಗೆ ವಿಡಿಯೋ ಕೂಡ ಪ್ರಾಬ್ಲಮ್ ಆಗೋಯ್ತು. ನಮ್ಗೆ VC ಅಲ್ಲಿ ಮೇಡಮ್ ಅವ್ರಿಗೆ ಕನೆಕ್ಟೇ ಆಗ್ಲಿಲ್ಲ ಸರಿಯಾಗಿ, ಅದಕ್ಕೋಸ್ಕರ ಮೇಡಮ್.